General Convention to be held in his church in June 1831. Delegates at that next meeting planted the seeds of the convention movement. They established a convention fund to plan for future meetings, ruled that the Declaration of Independence and the Constitution ought to be read at every meeting, and set as their objective the overturning of the many oppressive, unjust, and unconstitutional laws which have been enacted in different parts of the Union against the free people of color. If they could not vote on constitutions, they would insist on their right to interpret them. Nullification Castle. Despite the hundreds of constitutional conventions held in the states before 1860, there were hardly any formal calls for a federal constitutional convention. In fact, there were only 3. All 3 came in the 1830s, and all concerned a doctrine known as nullification. In 1828, Southerners were unhappy with a tariff imposed by Congress, believing it to be an attempt by Northerners opposed to slavery to punish and impoverish the South. At the request of the South Carolina legislature, the South Carolinian John C. Calhoun, John Quincy Adams's vice president, secretly authored a denunciation of the tariff, in which he argued that any state had a right to nullify an act of Congress that it considered to be a violation of the U.S. Constitution. Citing the Virginia and Kentucky resolutions and arguing that the Constitution has made us a community only to the extent of our common interest, leaving the states distinct and independent as to their peculiar interests, Calhoun carefully laid out an argument that the states possessed the power to declare acts of Congress unconstitutional. They could do this by a veto that Calhoun called an act of interposition, a term that Southerners would use after 1954 as part of the effort to resist Brown v. Board of Education. In the whole Constitution, Calhoun observed, there is not an opposing interest throughout the whole that is not counterpoised. But then, what is the check against a federal law that places an unequal burden on a single state or on a minority of states? Article 5 amendment is no check to that form of tyranny. A single state or a minority of states cannot use Article 5, which requires 3/4 of the states. Under these circumstances, for a state suffering under an unfair act of Congress to propose an amendment to overturn it would be perfectly idle. A state's power to declare an act of Congress unconstitutional is not expressly provided for in the Constitution, but surely, Calhoun argued, this power is implied in exactly the same way that the Supreme Court's power to declare acts of Congress unconstitutional is implied. He proceeded to strike down objections by elaborating on the similarity of these 2 implied powers, state interposition and judicial review. To the objection that interposition rests on mere inference without any express provision in the Constitution, and that it is not to be supposed, if the Constitution contemplated the exercise of a power of such high importance, that it would have been left to inference alone, Calhoun simply pointed to the power of the Supreme Court to declare a law unconstitutional, which is surely among the very highest and most important that can be exercised by any department of the government, and the Constitution does not make any express provision to justify its exercise. Both powers rest on mere inference, but an inference so clear that no express provision could render it more certain. The 2 powers are quite similar, except that the case for state interposition, Calhoun continued, is the better claim. The deduction in the one case is not clearer than the other, but if we refer to the nature of our Constitution, the right of the state stands on stronger grounds than that of the court. Calhoun made his case. Among the earliest proponents of his doctrine was the South Carolina writer Maria Henrietta Pinckney. She lived in a house that came to be called Nullification Castle. Born in 1774, Maria Henrietta Pinckney was the eldest daughter of Charles Cotesworth Pinckney, who'd served at the Constitutional Convention in Philadelphia in 1787, to which he brought 3 enslaved people, Jenny, George, and Fortune, and where he'd been instrumental in securing the Constitution's concessions to Southern slave owners. Considering all circumstances, we have made the best terms for the security of this species of property it was in our power to make. he told South Carolina's legislature during the ratification debates of 1788. Pinckney's mother died when she was 8, after which she was raised by her aunt, Harriet, who became the 4th largest slave owner in South Carolina. Pinckney, who never married, was known as a woman of masculine intellect. When her father died in 1825, Pinckney and her sisters, Harriet and Eliza, inherited the family estate, which included the Pinckney Mansion in Charleston, several plantations, and hundreds of human beings, including, so great was the family's commitment to states' rights, a boy they had named Larry State Rights. Pinckney insisted that the states were sovereign entities that in ratifying the Constitution had merely compacted into a league of states, reserving to themselves the rights to determine whether a federal law was constitutional and to secede from the Union. In 1830, at 56, Pinckney wrote a series of statements about nullification from Pinckney Mansion's first-floor library, beginning with the quintessence of long speeches arranged as a political catechism by a lady. Quintessence was a joke. The pamphlet digested the endless speeches delivered by men into a short question-and-answer catechism. Calhoun, shunned by Andrew Jackson, resigned from the vice presidency and instead sought and gained a seat in the U.S. Senate. Congress passed another tariff in 1832. As the nullification crisis intensified, Pinckney Mansion, Nullification Castle, became the meeting place of its leaders, with Maria Henrietta Pinckney and Harriet Pinckney as both hosts and provocateurs. They were known as the family's great politicians. In response to the new tariff, the South Carolina legislature considered enacting an ordinance of nullification. "Our aunts themselves cannot be more anxious to see the nullifying law passed than I am," wrote one niece. Maria Henrietta Pinckney knew and was close to Calhoun during the time when she was reading political theory, writing the political catechism, and elaborating a theory of nullification, before he had devised his. He surely read it when it was published, and likely read one of many draft versions, too. In November 1832, a convention called by the South Carolina legislature met in Columbia, deemed the tariff law unconstitutional, and insisted that it could be made constitutional only if it were to pass in the form of an amendment to the U.S. Constitution ratified by the necessary 3/4 of the states. 2 of Maria Pinckney's first cousins served as delegates. The convention adopted the Ordinance of Nullification, declaring the tariff laws of 1828 and 1832 null, void, and no law nor binding upon this state. For both supporters and opponents of the tariff, the answer to nullification was constitutional amendment. Andrew Jackson, despite his support for states' rights, resoundingly denounced the theory of nullification, partly on the argument that it defied the philosophy of amendment. "Perpetuity is stamped upon the Constitution by the blood of our fathers, by those who achieved as well as those who improved our system of free government," Jackson wrote in December 1832. For this purpose was the principle of amendment inserted in the Constitution, which all have sworn to support, and in violation of which no state or states have the right to dissolve the Union. If those who opposed the tariff did not have enough states in support of their position to effect an Article 5 amendment, then so be it. Nullification, Jackson insisted, was a form of insurrection, rebellion, and treason that, unless defeated, could lead only to civil war. Jackson pronounced the nullification doctrine itself unconstitutional and threatened to implement the tariff law by force if necessary. When South Carolina insisted on its right to secede, Jackson fortified Castle Pinckney, a coastal fort named after Maria Pinckney's grandfather, in anticipation of a military conflict. The crisis ended only with a begrudging compromise. Congress in 1833 passed a less stringent tariff bill, but not before 3 southern states called for a constitutional convention. In December 1832, South Carolina asked Congress to call a convention of the states. The Georgia legislature sent Congress a formal call for a federal constitutional convention a week later. Alabama followed in January, lamenting South Carolina's nullification ordinance and calling for a convention to propose such amendments to our federal constitution as may seem necessary and proper to restrain the Congress of the United States from exerting the taxing power for the substantive protection of domestic manufactures. New Englanders considered secession in 1814. Southerners tried to nullify a federal law in 1832. And when that failed, they sought to call a constitutional convention. These episodes would remain the closest the country came to disunion before the Southern secession of 1860-61. But they illustrated, too, the fragility of union, the experimental, contested, and contingent nature of the power to interpret and to amend the Constitution. Judge Story. The nullification crisis called renewed attention to another agent of constitutional interpretation, the people. But how are they to educate themselves about the Constitution and such tangled issues as interposition and judicial review? At the time, the Constitution was not much taught in schools. In 1796, a New England Federalist had published a plain political catechism intended for the use of schools, the very sort of primer that had been a model for Maria Pinckney. Question: does the Constitution of the United States thus secure the liberties and provide for the happiness and prosperity of the community at large? Answer: certainly, for what country has ever flourished for the time equal to this since the adoption of the federal Constitution? And whatever defects it may have, they are all harmless, because the Constitution itself provides for its amendments. This was not inaccurate, but it was hardly clarifying. But the first textbooks about the Constitution weren't printed until the 1820s, and they were law books. Much constitutional debate was challenging for most Americans to follow. In 1833, Daniel Webster argued on the floor of the Senate against the nullifier's use of the phrase constitutional compact to refer to the Constitution on grammatical grounds as much as political ones. In our American political grammar, constitution is a noun substantive. It imports a distinct and clear idea of itself, and it is not to lose its importance and dignity. It is not to be turned into a poor, ambiguous, senseless, unmeaning adjective for the purpose of accommodating any new set of political notions. That was nicely said, but as the electorate was fast expanding to include poor white men, the overwhelming majority of whom had hardly any education at all, Webster's grammar lesson might have been something less than helpful. In 1833, Joseph Story published a 3-volume law book called Commentaries on the Constitution, the first attempt to systematically describe what's in the Constitution and what isn't, and how to read and interpret it. He was committed, too, to making his work available to more than law students. The next year he published the Constitutional Class Book, being a brief exposition of the Constitution of the United States, in which he insisted that the Constitution is the language of the people, to be judged of according to the common sense and not by mere theoretical reasoning. Soon afterward, he published a familiar exposition of the Constitution of the United States containing a brief commentary on every clause, in which he aimed to make his constitutional analysis intelligible to every class of readers by embodying them in plain and unambitious language. The Massachusetts-born Story had studied at Harvard before becoming a lawyer and member of the state legislature. Madison nominated him to the Supreme Court in 1811, when Story was only 32. A close ally of Chief Justice Marshall, one biographer declared, they may be considered one and the same person, Story opposed everything that John C. Calhoun proposed, from the compact theory of the Constitution to states' rights to the doctrine of nullification. A nationalist committed to federal supremacy, Story repeatedly insisted that it was the people, not the states, who are sovereign and who created the Constitution. It may be altered and amended and abolished at the will of the people, he wrote. In short, it was made by the people, made for the people, and responsible to the people. He was, however, no Democrat. Story loved the classics and deference to authority, and he was troubled by the pace of change and the spirit of improvement, especially the rise of manufacturing, of the age in which he lived. He mistrusted the people, regretted sectionalism and partisanship, feared for the Union, and despised the turn in American politics that led elected officials to seek popular favor. By 1818, he was so distressed at the rise of majority rule that he predicted that in his lifetime he would live to see many of our best institutions crumble in the dust. At the Massachusetts Constitutional Convention of 1821, he rose to speak resolutely against eliminating property requirements for voting. Story hoped to devise a set of uniform rules for constitutional interpretation, work he pursued as a professor of law at Harvard starting in 1829. His 2-volume commentaries on the Constitution began as a series of law school lectures. Regretting the many different rules of interpretation that had often been shifted to suit the emergency and the passions and prejudices of the day, or the favor and odium of a particular measure, Story set about offering a coherent system. He stated his rules squarely. To resolve an ambiguity in the text, consider the structure, design, and history of the Constitution. Remember that the Constitution was a compromise, and give its words and interpretation consistent with their legitimate meaning by referring to records like those of the state ratifying conventions. But be warned that those records may point you in different directions, since the states disagreed, and delegates in any given convention disagreed too. Alas, don't assume that delegates who opined about a clause in the Constitution had necessarily read it. Then, too, many earlier interpretations of constitutional clauses have since silently died away. And in any case, nothing but the text itself was adopted by the people. Because the people made the Constitution for their own benefit and protection, it ought not to be construed strictly or narrowly, as if it were subversive of the great interests of society, but rather expansively and broadly, as its object is the common good. The Constitution's construction should be fixed, uniform, and permanent, not dependent upon the passions or parties of particular times, but the same yesterday, today, and forever. The Constitution is supreme law and cannot ever be made to answer to state constitution. Finally, read a constitution as if a constitution makes sense. Constitutions are not designed for metaphysical or logical subtleties, for niceties of expression, for critical propriety, for elaborate shades of meaning, or for the exercise of philosophical acuteness or judicial research. They are instruments of a practical nature, founded on the common business of human life, adapted to common wants, designed for common use, and fitted for common understandings. The people make them, the people adopt them, the people must be supposed to read them with the help of common sense, and cannot be presumed to admit in them any recondite meaning or any extraordinary gloss. One of the most illuminating remarks Story ever made about the Constitution, one that casts light, too, on his rules for interpreting it, came when he said, "I once saw a book advertised entitled, 'New Views of the Constitution.' I was startled. What right has a man to start new views upon it?" Indian nullification. New views there were everywhere, especially on the floors of convention halls and in the pages of petitions submitted to Congress. Even the doctrines of nullification and secession spread. There would be no U.S. Constitutional Convention in the 1830s, 40s, or 50s, but the Cherokee Nation, the Choctaw Nation, and the Seneca Nation all held constitutional conventions in these years, beginning with the Cherokee, who in 1827 held a constitutional convention presided over by Cherokee Chief Kuisugui John Ross. Born in 1790 to a Cherokee mother and a Scottish father, Ross had served as an Indian agent and fought in the Creek War under Jackson. A prosperous ferry and plantation owner, he was also, like many wealthy Cherokee, a slave owner. In 1817, he'd been elected to the Cherokee National Council, and in 1827 to its Constitutional Committee. The convention met in New Echota, the capital of the Cherokee Nation, within the state of Georgia. The Constitution it devised, "We, the representatives of the people of the Cherokee Nation and convention assembled, do ordain and establish this Constitution for the government of the Cherokee Nation," was modeled on the U.S. Constitution, with 3 branches of a Republican government. It also replicated the exclusions by race and sex that had become nearly universal in state constitutions. All free male citizens, except Negroes and descendants of white and Indian men by Negro women, who may have been set free, who shall have attained to the age of 18 years, shall be equally entitled in vote in all public elections. And it defined the nation's borders beyond amendment. The boundaries of this nation shall forever hereafter remain unalterably the same. In 1828, Ross won election as the nation's principal chief, a position he would hold for decades. He and other Native leaders insisted on their own reading of the Constitution, which was that it could not apply to Native nations because they had never joined the Union and remained sovereign, having never surrendered their right of self-government. As Ross explained, our treaties of relationship are based on the principles of the federal Constitution, and any action by the states violated the principle of federal supremacy. If Andrew Jackson would not stand for John C. Calhoun-style nullification, he would not stand for John Ross-style native sovereignty either. Jackson pursued a policy known as Indian removal, forcibly relocating Native people from their ancestral lands east of the Mississippi to the so-called Indian Territory in what is now Oklahoma. He and the state of Georgia fought Cherokee sovereignty in the courts, and he fought it with the U.S. Army. Marshall, in 1831, in Cherokee Nation v. Georgia, declared Indians domestic dependent nations. The next year, in Worcester v. Georgia, the court found in favor of an understanding of the Constitution advanced by Native nations when it ruled that the Cherokee Nation was sovereign and that Georgia had no right to interfere in its affairs, since relations between Indians and the United States were the province of the federal government, not the states. The Cherokee Nation, then, is a distinct community occupying its own territory in which the laws of Georgia can have no force. The decision of the court did little to diminish Jackson's determination to remove the Cherokee. Ross fought back, resisting removal and protesting a removal treaty signed by a minority of Cherokee in 1835. During the forced march removal to Indian Territory in the winter of 1838-39, Ross's wife, like thousands of other Cherokee, died in the misery of the Trail of Tears. The Cherokee strategy of resisting removal by establishing sovereignty through the act of holding a convention and drafting and ratifying a constitution failed. Seeking relief from the Supreme Court failed, too. From Indian Territory, another generation of Cherokee would attempt, in years to come, to enter the Union as a state. That, too, would fail. From Massachusetts, the Mashpee tried something different. They attempted nullification. In 1833, Mashpee Indians living within the boundaries of Massachusetts held a national assembly and submitted a petition to the state's legislature seeking independence from the guardianship under which the tribe had been placed. The Mashpee had been resisting the authority of the Massachusetts government for decades, seeking to rule themselves. In the 1830s, their most eloquent advocate, a Pequot minister named William Apis, who had been adopted into the tribe, argued their case in a tract published in 1835 as Indian Nullification of the Unconstitutional Laws of Massachusetts relative to the Mashpee tribe. Apis, who had published an autobiography in 1829 and was a well-known speaker across New England, had urged the Mashpee to draft a nullification proclamation in imitation of South Carolina. Signed by 79 males and 92 females on the plantation, and in behalf of 79 males and 37 females who are absent and will not return to live under the present laws, the Mashpee, comparing themselves to the Cherokee, demanded self-rule. While ye are filled with the fat of our father's land, and enjoy your liberties without molestation, will not this honorable body be as benevolent to us poor Mashpee Indians, who are sighing and weeping under bondage, as ye are to poor Cherokees, and have we not ground under the weight of degradation long enough? Decrying as unconstitutional the laws under which the Mashpee were governed by guardians appointed by the state, the Mashpee proposed to write their own laws. We, the Mashpee tribe, also pray for a grant of the liberties of the Constitution to form a municipal code of laws amongst ourselves, that we may have a government that will be useful to us as a people. In 1840, Act of the Massachusetts Legislature made Mashpee an independent parish. If the Mashpee hadn't exactly succeeded in nullifying a state law, they had achieved a measure of autonomy by way of convention and petition. The petition, like the extra-constitutional convention, was among the best tools available to people not included among the people. But they were quite different methods. The convention was chiefly the bastion of men, while the petition, a form of pleading, was a tool more often wielded by women. The American Anti-Slavery Society had begun a petition drive in 1834, sending petitions to Congress calling for the abolition of slavery, many signed by tens of thousands of people. 7 out of 10 signers of anti-slavery petitions were women. Abolitionists and equal rights reformers sent petitions not only to Congress but to the states, too. In 1838, 40,000 citizens threatened with disenfranchisement submitted a petition to Pennsylvania's amending convention, pleading with delegates not to add the word white to the suffrage requirements in the state's constitution. From writing petitions, female abolitionists proceeded to holding their own conventions. The first National Convention of Anti-Slavery Women met in New York in 1837, bringing together some 200 women from 10 states. 1 in 10 delegates were black women. "To attend a female convention," one delegate wrote, "once I should have blushed at the thought." Campaigning against slavery and for an end to the black codes also brought many women into the cause of women's rights. Wrote the South Carolina abolitionist Angelina Grimke, "Since I am engaged in the investigation of the rights of the slave, I have necessarily been led to a better understanding of my own." By the 1840s, women were petitioning state constitutional conventions to demand the vote for themselves. In 1846, Eleanor Vincent, a mother of 9 and likely pregnant at the time, was the first of 6 New York women to sign a petition submitted to the State Constitutional Convention in Albany declaring that the present government of this state has parted from the true democratic principles upon which all just governments must be based by denying to the female portion of community the right of suffrage and any participation in forming the government and laws under which they live. Female petitions to state constitutional conventions were uniformly ignored. Many were probably not even recorded, and chances are that many more once existed than now survive. Southerners in Congress found a way to ignore female petitions, implementing in 1836 a gag rule under which any petition on the subject of slavery was automatically tabled. In 1839, when John Quincy Adams presented a petition calling on Congress to pass a constitutional amendment prohibiting slavery in any new state, it was tabled. Joseph Story insisted that the Constitution had been written so as to be intelligible to every class of readers, and that reading it required a straightforward application of common sense. But when people who were not included in the original Constitution attempted to offer their own interpretations of its meaning, constitutional doors kept slamming in their faces. A mere record of the dead. John Marshall died in 1835, having led the Supreme Court, defined the court, for 34 years. Joseph Story, grieving, lingered in the Chief Justice's old room, mourning its noiseless gloom. When the court was in session, the justices all lived in the same boarding house in Washington. Story had been expected to replace Marshall as Chief Justice, but Andrew Jackson, knowing Story's contempt for democracy, called him the most dangerous man in America. Story considered stepping down. "I seem a monument from the past and a mere record of the dead," he sighed. Marshall, who in his lifetime had purchased hundreds of slaves, did not free any of them in his will, with the exception of a man named Robin Spurlock, who had been given to him as a wedding present. Marshall freed Spurlock only on condition that he leave Virginia and all of his family, which Spurlock refused to do. But in an 1830 codicil, he did express a preference for preserving the families together as near as may be, something that his cousin, Thomas Jefferson, who freed only Hemmingses, did not do. At Marshall's death, Jackson passed over Joseph Story and appointed Roger Taney to the Chief Justiceship. Taney, born in Maryland, had inherited slaves from his father, and his wife brought them to their marriage. Unlike Marshall, Tawney freed some of these people. He believed slavery to be wrong. He also did not believe that the Constitution prohibited it. Abolitionists knew they had nothing close to the sweeping power both in Congress and in state legislatures necessary to amend the Constitution. To propose an amendment to the Constitution to end slavery implied that the Constitution sanctioned slavery, and that ending slavery, therefore, required a constitutional amendment. They would have preferred simply to declare slavery unconstitutional, that is, to interpret the Constitution in such a way as to argue that it did not and had never sanctioned slavery. To do that, they would have had to defeat the slaveholders' interpretation of the Constitution. As their devotion to slavery led Southerners to advance bolder arguments about states' rights, they still more forcefully claimed that the Constitution was a contract or compact, that records beyond the text were therefore relevant to its interpretation, and that the states retained the authority to interpret it. This they insisted they could do by way of historical research into the intent of the framers. Right about when they came to this view of the matter, James Madison died, and his widow published his Notes on the Constitutional Convention. Madison, the last surviving delegate to the Constitutional Convention, died at the age of 85 in 1836. When the delegates' 50-year vow of silence expired in 1837, Madison's widow, Dolly, arranged for the publication of his considerably amended notes. They appeared in print in 1840, advertised on the title page, "Now published from the original manuscripts." Madison's notes proved, if proof was needed, that no resolution to the growing conflict between the states was to be found in discovering the original intent of the framers of the Constitution. Madison's detailed account of the disputes with delegates from South Carolina and Georgia who threatened to walk out if concessions to slavery were not made convinced many abolitionists that the Constitution was a pro-slavery compact. It was for this reason that the abolitionist William Lloyd Garrison would burn a copy of the Constitution, grind its ashes under his heel, and, invoking Isaiah 28:15, call it a covenant with death and an agreement with hell. But it was possible to read Madison's notes differently, paying attention not to the concessions to the slave states, but to the objections to those concessions, and to how fervently many delegates had spoken out against slavery. By the mid-1840s, many abolitionists had elected to argue that the Constitution simply did not sanction slavery, and that therefore no amendment was necessary to end it. Slavery, they argued, was already unconstitutional. Frederick Douglass, breaking with Garrison, would take this position too. Few other paths remained open to them. John Quincy Adams came up with an idea for getting around the gag rule, attacking the slave power by proposing an amendment to abolish the Electoral College. In 1841, Adams presented to Congress a petition from Pennsylvania, calling for a constitutional amendment to cause the president and vice president to be elected by a direct vote of the people, and also to abolish all representation of property in the government of the United States. Representation of property meant counting enslaved human beings' property as 3/5 of a person for the purposes of representation. Framing the amendment in these terms allowed it to go to committee rather than be automatically tabled under the terms of the gag rule. Still, as would be the case over not decades but centuries, sectional divisions and the requirements of Article 5 made eliminating the Electoral College by constitutional amendment impossible. It is a rule of American history that when amendment becomes impossible, the risk of insurrection rises. In 1843, 58 delegates from 7 states met in Buffalo for the National Convention of Colored Citizens. Samuel H. Davis presided. Davis, born free in Maine in 1810 and educated at Oberlin College, argued that black codes violated the U.S. Constitution with its guarantee of freedom and equal rights to every citizen. The question was how to overturn the codes. Black Americans who gathered in a national convention could not, like South Carolina, nullify laws. They refused to remove from the United States. They could not appeal to the U.S. Supreme Court. "What shall we do?" Davis asked. "We have petitioned again and again, and what has been the result? If not petitioning, then what? Shall we then look to the abolitionists and wait for them to give us our rights?" Davis had no patience either for pleading or for waiting, when the Constitution guaranteed rights and they were there, he believed, for the seizing. We ourselves must be willing to contend for the rich boon of freedom and equal rights. 27-year-old Henry Highland Garnett, who had escaped from slavery as a child, rose to deliver an address to the slaves of the United States of America. He spoke for an hour and a half, recounting the history of slavery in the United States and the efforts of abolitionists to end it. But as Davis had argued that free black men would have to take action in the North, Garnett told the enslaved black men in the South that the time has come when you must act for yourselves. His advice: go to your lordly enslavers and tell them plainly that you are determined to be free. They might kill you, but they would not kill all of you. Brethren, arise, arise, Garnett urged as his audience fell to tears. Strike for your lives and liberties, he shouted. Rather die free men than live to be slaves. Remember that you are 4 millions. Despite their tears, the convention's delegates, by the margin of a single vote, deemed Garnett's address too incendiary to endorse and refused to publish it. But they did pass a resolution declaring that by the second section of the 4th article of the Constitution of the U.S., the Privileges and Immunities Clause, black people are citizens of the United States. In the fabric of American constitutionalism, they had chosen the sturdiest thread. When you can't amend the Constitution, you can insist on your reading of it. Here the United States appeared to have arrived at a constitutional impasse. By the 1840s, Joseph Story had all but given up on the Union. Few men could make a stout and strong resistance to the inroads of a low and mischievous democracy, he wrote in 1842. For my own part, I think that we have fully tried the experiment of a representative republic, and that it is a failure on our part. The vital principles of the Constitution are uprooted and disregarded in the blind fury of party spirit. I look now to the dissolution of the Union as inevitable, and at no very distant period. He died less than 3 years later. When the questions of the constitutionality of slavery and the matter of black citizenship went to the Supreme Court, it was not Joseph Story, but Roger Taney who would decide them. In an opinion that overruled every act of constitutional interpretation put forth at black conventions. As for constitutions, the people make them, the people adopt them, the people must be supposed to read them with the help of common sense, Story had written. Black Americans listened and read, and Taney ignored them. At war with the Constitution. Mary Jane Richardson was born in Memphis in 1820, the 5th of 9 children. Her parents, Elijah Richardson, a blacksmith, and Deeza Morris, who'd been born in South Carolina, were both free, although years later their son Alfred would be kidnapped into slavery. Growing up, Mary Jane met a man named John Jones. His shoulders as broad as hers were narrow. In photographs, they share a certain serene resolve. John Jones had been born on a plantation in North Carolina in 1816. He never went to school. When he was a boy, his mother, a free black woman, placed him in an apprenticeship, partly to prevent his father, who was white, from selling him into slavery. Eventually, he was apprenticed to a tailor in Memphis, where he met Mary Jane Richardson and fell in love. Not long afterward, her family moved to Illinois, a state that was nominally free. Jones planned to follow them there as soon as he could. In 1837, the Richardsons were living in Alton, Illinois, when a pro-slavery mob shot and killed the printer and pastor Elijah Lovejoy for his outspoken abolitionism. Mary Jane, 17, always remembered the day she watched Lovejoy's sad and silent funeral procession pass by her father's house. Constitutional change can sometimes begin with a love story, a family story, the daily striving and struggling to get by and even to make things better. But a new spirit of amendment grew among abolitionists, like Mary Jane Richardson and John Jones. In 1841, when John Jones, at 22, finished his apprenticeship and saved $100, he moved to Alton to marry 20-year-old Mary Jane Richardson. They had a baby, Lavinia, in 1843, and 2 years later they moved to the very new settlement of Chicago. To travel under Illinois' black codes, they had first to get papers certifying that they were free. Know ye that John Jones, a person of color, about 27 years of age, 5 feet 10 inches high, mulatto complexion, has exhibited, presented, and filed in the office of the clerk and circuit court a certificate duly authenticated of freedom. As such person of color, has a scar over the left eyebrow, a scratch across the cheekbone, a scar on the left shin bone, a tailor by trade. Their stagecoach was stopped when they were suspected of being runaway slaves. They arrived in Chicago in 1845, a city that was still barely more than a small town. Its population in 1840 was less than 5,000. It would increase to nearly 30,000 by 1850. Jones opened a shop at his house at 119 Dearborn, advertising as J. Jones, clothes dresser and repairer. He learned to read, studying with a local abolitionist. In Chicago, the Joneses led a decade-long campaign to make the state and the nation truly free. They hosted meetings, they housed refugees and fugitives. Jones later made the perilous journey back to Tennessee to buy Mary Jane's brother Alfred out of slavery for $800. Their work required organizing. It required breaking the law by providing relief to men, women, and children fleeing slavery. It required meeting in political conventions. It required constitutional argument. It required defying laws passed by Congress and a decision made by the Supreme Court. And in the end, it required constitutional amendment. John Jones attended black conventions in Alton and Chicago, and he'd been in Buffalo when Henry Highland Garnett called for insurrection, and Samuel Davis had asked, "What shall we do?" Likely Mary Jane Richardson Jones went with him. She was at his side in his every endeavor and accomplishment, their granddaughter later wrote. Early in 1847, Illinoisians debated holding a convention to revise the state's constitution. Jones wrote a petition on behalf of black men, asking the state legislature to repeal all laws making a distinction among people on account of color. In response, the Illinois Senate's Judiciary Committee in March issued a unanimous report rejecting the petition, telling Jones that if he is not content with the provisions of our laws, Africa, the land of his birth, a climate congenial with his nature, lies open before him, where he may use his powers of self-government. Go back to Africa, in short, and pledging that under the terms of the state's constitution, blacks in Illinois were excluded from the right to vote, and ever will be. 162 delegates met to revise the Illinois Constitution. "We are the sovereignty of the state," said one delegate. "We are what the people of the state would be if they were congregated here in one mass meeting. We are what Louis XIV said he was. We are the state." But John Jones, in a scathing indictment of that convention, disputed both its authority and its definition of the people. He called the amendments it had proposed anti-republican and repugnant to the Constitution of the United States and subversive of the inalienable rights of man. He objected to an amendment that inserted the word white into the Illinois Constitution. "Let us examine the word white," Jones wrote, begging the convention to expunge it. "Is it not time that the great fundamental principle that all men are equal in their natural rights was settled in this country?" Daniel Whitney, a delegate born in New York, moved to delete the word white from the requirements for suffrage. That motion was resoundingly defeated, 8 to 137. Although the convention had by no means been called over the question of the black franchise, the controversial issue on the table this time around concerned banking, the Constitution devised that spring and summer banned free blacks from moving to the state by a vote of 87 to 55, and a motion to prohibit the legislature from ever extending the right to vote to Negroes or mulattoes of African blood passed 60 to 51. In a series of newspaper articles, John Jones attempted to convince voters not to ratify the new Constitution, basing his argument on his reading of American constitutional history. We maintain that our claims to the rights of citizenship are founded on an original agreement of the contracting parties, and there is nothing to show that color is a bar to the agreement, he insisted. Yes, slavery existed in 1787, but the darkness of the 18th century has gone by, and we live in the 19th, and in a republic, too, where men understand the principles of government, and a man is regarded as a man whether his face be black or white. Illinois' new constitution, he asserted, is anti-republican and even unconstitutional. The framers of the 1776 Articles of Confederation, the 1787 U.S. Constitution, and the 1818 Illinois Constitution had not used the word white, he pointed out, so why should delegates to the new state convention? Illinois' amended constitution, submitted to the public at the next election in 1848, was ratified 60,585 to 15,903. Article 14, the ban on black immigration, submitted to voters separately, passed by a slightly smaller majority, 50,261 to 21,297. Jones then published an essay denouncing the new Constitution, calling the Black Exclusion Amendment at war with the Constitution because it attempts to prohibit natural-born citizens of the United States from settling in this state on account of the color of their skin. In 1848, a year of revolutionary change across Europe, the toppling of monarchies from Italy to Austria, black abolitionists were undertaking their own revolution. John Jones was elected one of Illinois' 2 delegates to the Great National Convention of Colored Freemen of the United States to be held in Cleveland, the first black convention in which women were allowed to participate in deliberation. Frederick Douglass was elected president, and Jones vice president. In Cleveland, black convention delegates would celebrate the spirit of the age, the upward tendency of the oppressed throughout the world. Surely, a great amendment in human affairs was underway. A Declaration of Sentiments. In 1848, 300 delegates, mostly women, mostly white women, gathered for the first Women's Rights Convention at Wesleyan Chapel in the village of Seneca Falls in upstate New York. Their meeting marked the beginning of the women's movement in the United States, a movement that was at once a moral crusade and a political protest, and that would require, in the end, more than one constitutional amendment to meet its goals. The meeting had been organized by 32-year-old Elizabeth Cady Stanton, daughter of a justice on the New York Supreme Court. Her mother was a Garrisonian abolitionist. In 1840, Elizabeth married Henry Stanton, a radical abolitionist with whom she would have 7 children. For their honeymoon, they traveled to London for the World Anti-Slavery Convention, where the female delegates were seated separately and were not allowed to speak. Cady Stanton, with the Quaker abolitionist Lucretia Mott, who also attended that meeting in London, set about studying law and preparing to adapt the methods of abolitionist and black conventions to the cause of women's rights. In 1847, the Stantons settled in Seneca Falls, and when Mott soon afterward visited her sister, who lived nearby, Elizabeth Cady Stanton went to see her. I poured out that day the torrent of my long accumulating discontent with such vehemence and indignation that I stirred myself, as well as the rest of the party, to do or dare anything. They together dared to write an announcement for a women's rights convention. Those who gathered in Seneca Falls in July 1848 were experienced reformers, women from the abolitionist and temperance movements. In advance of that first day, Cady Stanton had drafted a Declaration of Sentiments. Modeled on Jefferson's Declaration of Independence, it began, "We hold these truths to be self-evident, that all men and women are created equal." Borrowing from decades of writing that would later come to be called feminist, it offered a blistering revision to Jefferson's account of the history of tyranny. The history of mankind is a history of repeated injuries and usurpations on the part of man toward woman, having in direct object the establishment of an absolute tyranny over her. The Declaration of Sentiments demanded education for girls and women, the establishment of married women's property rights, an end to coverture, and the admission of women to all the rights and privileges which belong to them as citizens of these United States. Its resolution on suffrage, "It is the duty of women of this country to secure to themselves their sacred right to the elective franchise," was the only one of 11 resolutions that did not pass unanimously, and its narrow passage required the particular intervention of convention organizer Elizabeth Cady Stanton and of Frederick Douglass. It would take women decades to achieve any of the demands put forward at Seneca Falls, but the movement to achieve them had begun. Weeks after attending the Women's Rights Convention in Seneca Falls, Douglass traveled to Cleveland for the National Black Convention, where a woman whose name was recorded only as Mrs. Sanford became the first woman to speak at a black convention. "We ask for the elective franchise," she said on behalf of black women. No resolution was passed advocating what she proposed, but the delegates did debate whether to vote on a proposed resolution in favor of women's rights. Some delegates insisted it wasn't necessary, since they'd already passed resolutions in favor of colored persons, and they considered women persons. Douglass then proposed amending a resolution to make clear that the word persons be understood to include woman. This motion passed, with 3 cheers for women's rights, the delegates stating that they fully believe in the equality of the sexes, and they further resolved to invite females hereafter to take part in our deliberations. But in no meaningful sense had the convention actually supported female suffrage or incorporated it into the demands of the convention movement. Future state and national black conventions routinely excluded women. One New York convention went so far as to strike the name of Miss Barbary Anna Stewart from the roll of delegates, several gentlemen objecting to it on the ground that this is not a women's rights convention. A threatened boycott of the Ohio State Convention in 1849, led by Jane P. Merritt, resulted in the convention passing a resolution inviting the ladies to participate, but only very seldom were black women allowed to serve as delegates at black conventions. Nor did black women generally participate in women's conventions, which were overwhelmingly dominated by white women. Social reform and the convention movement did bring together abolitionists and women's rights activists, who, as was the case with Frederick Douglass, were often the same people. "Right is of no sex, truth is of no color," appeared as the motto of Douglass's newspaper, the North Star. At the first National Women's Rights Convention, held in Worcester, Massachusetts in 1850, Sojourner Truth spoke, and the convention resolved that the cause we are met to advocate, the claim for women of all her natural and civil rights, bids us remember the 1.5 million of slave women at the South, the most grossly wronged and foully outraged of all women. But on the whole, women's rights conventions were white and black conventions were male. The Black Convention in Cleveland in 1848 had been a particularly crucial one, as efforts of abolitionists to stop the extension of slavery into newly acquired territories had assumed new urgency. At the start of 1848, the United States acquired more than 300 million square acres of land under the terms of the Treaty of Guadalupe Hidalgo, ending the war with Mexico. The top half of Mexico became the bottom third of the United States. California, New Mexico, Nevada, and Utah, most of Arizona and Colorado, and parts of Oklahoma, Kansas, and Wyoming were all part of this acquisition. The Missouri Compromise would not survive this acquisition, yet neither of the 2 major party candidates for president, the Whig Zachary Taylor and the Democrat Lewis Cass, pledged to prohibit slavery in these new territories. It was this convention that brought Jones, appointed vice president to Douglass's president, to a national stage. With the U.S. presidential election only 2 months away, Jones, a veteran of political fights and constitutional arguments in Illinois, urged his fellow abolitionists to abandon moral suasion in favor of party politics. Jones drafted a preamble to a resolution endorsing the newly formed third party, the Free Soil Party, a statement that American slavery is politically as well as morally an evil of which this country stands guilty. And the 2 great political parties of the Union have, by their actions and nominations, betrayed the sacred cause of human freedom. The party endorsement failed, but the preamble passed. Within the meaning of the U.S. Constitution. In Congress, guns were drawn on the House floor over what to do about the territories acquired in 1848, the so-called Mexican Cession. In 1849, delegates from southern states met in a convention in Mississippi to denounce the Wilmot Proviso, a proposal to prohibit slavery in any territory acquired from Mexico. In June 1850, with the question still unresolved, 175 delegates from 9 slave states, including Jefferson Davis from Mississippi, met in a convention in Nashville to affirm the constitutionality of slavery and to consider seceding from the Union. The threat they posed led Congress to reach the Compromise of 1850, in which California would enter the Union as a free state, New Mexico and Utah would be able to decide for themselves on the question of slavery, and Congress would pass a formidable fugitive slave law. The fugitive slave law was passed on a Saturday night, Mary Jane Jones later recalled, about hearing the news in Chicago. And on Sunday, the Friends of Freedom chartered cars enough to send every fugitive slave from here and around the country out of this country and into Canada. Days later, blacks in Chicago held a mass meeting at the AME Church. John Jones then renewed the campaign against Illinois' black codes, writing and circulating a petition calling for the immediate and total repeal of all laws now existing upon the statute books of this state, whereby discriminations are made among the people on account of their complexion. Frederick Douglass's paper, announcing a new national convention, called the Fugitive Slave Act the most cruel, unconstitutional, and scandalous outrage of modern times. In Chicago, Mary Jane Jones hosted John Brown and Frederick Douglass and fugitives traveling on the Underground Railroad. As her granddaughter later wrote, "It was she who stood guard at the door when these pioneer abolitionists were in conference, with the slaves huddled below in her basement." 140 delegates, including Jones, met in Douglass's hometown of Rochester, New York, in July 1853. Douglass and Jones were elected vice presidents. "Within the meaning of the United States Constitution," Jones wrote in a statement, "we are American citizens." The debates for so long held on the floors of black convention halls, state by state, broke out onto the national stage. In May 1854, Congress passed the Kansas-Nebraska Act, crafted by the U.S. Senator from Illinois, Stephen Douglas, repealing the Missouri Compromise and allowing new states formed out of the Nebraska Territory to decide for themselves whether they would allow or prohibit slavery. Frederick Douglass then went to Illinois in hopes of debating Stephen Douglas on the subject of the Kansas-Nebraska Act. That debate did not come to pass. Instead, Douglass addressed an audience in Chicago's Metropolitan Hall that surely included Mary Jane and John Jones, at whose house he was likely a guest. "The U.S. Constitution," he declared, "knows no man by the color of his skin. The men who made it were too noble for any such limitation of humanity and human rights." He offered a brief history. The word white is a modern term in the legislation of this country. It was never used in the better days of the Republic, but has sprung up within the period of our national degeneracy. In Illinois in 1856, Jones served as president of a state convention in Chicago, where he organized a campaign against a state law banning the immigration of all blacks, free or slave. He organized a repeal association to overturn Illinois' black codes. At a state convention in Alton, he helped shape a declaration of sentiment that included a reading of the Constitution, insisting, in sovereign prose, that it was intended to establish justice, therefore opposed to injustice, to promote domestic tranquility, therefore opposed to domestic turmoil, to promote the general welfare, therefore opposed to the general misery, to secure the blessings of liberty to ourselves and posterity, and not eternal slavery. Jones and Douglass made their case, but the word white had entered the legal lexicon. The first American legal dictionary, published in 1839, defined a citizen as one who, under the Constitution and laws of the United States, has a right to vote for representatives of Congress and other public officers, and who is qualified to fill offices. By 1854, that dictionary included an entry explaining that all natives are not citizens of the United States, the descendants of the Aborigines and those of African origin are not entitled to the rights of citizens. No one is a citizen who is not white. What began as a proposed constitutional amendment had become a definition. Dread. What did the words in the Constitution mean? Was the writer of a dictionary to decide? Could the states decide? Could Congress decide? By 1857, the Constitution was 70 years old, a human lifetime. The men who had drafted it were dead. Was history to be used to discover the meaning of words these men had written in 1787? Or philosophy, or some other method of inquiry? The question had been brought to Roger Taney's Supreme Court by Harriet Robinson and Dred Scott. Dred Scott, born into slavery in Virginia about 1799, had filed a suit first in Missouri in 1846 and then in 1853 in a federal court, insisting that he was free because he had been in both Illinois and the Wisconsin Territory, and in both places slavery was illegal. He and his wife Harriet Robinson Scott had filed a suit as well. Filing freedom suits appears to have been her idea. Winning would have secured the freedom of the couple's 2 surviving children. And Harriet Scott, having been born in Pennsylvania, had a stronger claim. They won in the lower court, but when the Missouri Supreme Court overturned that ruling, the Scotts sent their daughters into hiding and filed an appeal. Freedom suits were common in the courts, but the Scotts' case took on broader significance when Taney read the case as turning on a single question. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all of the rights and privileges and immunities guaranteed by that instrument to the citizen? In Dred Scott v. Sanford, Taney wrote the court's 7-2 decision, 200 pages long, and issued on March 6, 1857, arguing that the answer to that question was no. Following Marshall, Taney began with the assumption that it was the court and no one else who decided what the words in the Constitution meant. And then he insisted that the only way to make such a judgment was to argue from a narrow historical record. The change in public opinion and feeling in relation to the African race, which has taken place since the adoption of the Constitution, cannot change its construction and meaning, he wrote, dismissing, for instance, the construction placed on the Constitution by abolitionists like John Jones. Instead, he insisted, it must be construed and administered now according to its true meaning and intention when it was formed and adopted. That meant referring to the Constitution itself, to the notes on the convention as recorded by James Madison, and to the Federalist Papers. Taney's reading of these documents led him to conclude that the framers of the 1787 Constitution believed that people of African descent have no rights which the white man was bound to respect, and therefore that they are not included, and were not intended to be included, under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. Taney went still further, arguing that the Missouri Compromise violated the Fifth Amendment, since it deprived slave owners of their property, a property affirmed by the Constitution itself. He therefore struck down the Missouri Compromise as unconstitutional, declaring it void. Taney's method rested on the notion that the intent of the framers of the Constitution was perfectly knowable and that the meaning of the words in the Constitution was unchanging. No one, we presume, supposes that any change in public opinion or feeling in relation to this unfortunate race in the civilized nations of Europe or in this country should induce the court to give to the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted, he wrote. To interpret the Constitution was not to change it. The only way to change it was by way of Article 5. If any of its provisions are deemed unjust, he wrote, there is a mode prescribed in the instrument itself by which it may be amended. But while it remains unaltered, it must be construed now as it was understood at the time of its adoption. The Constitution, Taney wrote, speaks not only in the same words, but with the same meaning and intent with which it spoke when it came from the hands of its framers. Dread was the first time since Marbury that the court had overturned a law passed by Congress. Taney's method of constitutional interpretation erased from any possible consideration the political will of people who were disenfranchised by the Constitution. His opinion also struck down every constitutional claim made in every black convention held in the United States since 1830. Abolitionists across the country denounced it. Frederick Douglass dismissed this edict of Taney as an act of despotism, and his constitutional analysis as nonsense, a most scandalous and devilish perversion of the Constitution and a brazen misstatement of the facts of history. Douglass also accused Taney of, in effect, amending the Constitution by way of a novel interpretation, in defiance of the framers' original intent and meaning. Taney purported to find in the Constitution words that were not there: slavery and white. At a black state convention in Troy, New York in September 1858, delegates adopted a resolution calling the decision a foul and infamous lie which neither black men nor white men are bound to respect, denying that the court had the authority to issue the ruling and declaring that we are citizens of the state of New York and consequently of the United States, the edict of Judge Taney, to the contrary, notwithstanding. Taney may have insisted that only the 9 justices on the court had the authority and knowledge to discover the meaning of the words in the Constitution. Black abolitionists believed otherwise. Taney had his framers, and they had theirs. No, it's murder, black men had written in 1788 in that long-ago petition to the Connecticut legislature addressed to all mankind. If the only evidence that mattered to constitutional interpretation was history and tradition, it was Taney whose collection of evidence was woefully incomplete. Frederick Douglass, delivering a speech about the decision, invoked Joseph's story. The well-known rules of legal interpretation bear me out in this stubborn refusal to see slavery where slavery is not, and only to see slavery where it is, he said. The word slavery was not in the Constitution. The rules of interpretation told us that the intention of legal instruments must prevail, and that this must be collected from its words, he went on, all but paraphrasing story. It has told us that language must be construed strictly in favor of liberty and justice. They told us that there is another rule of law as well of common sense, which requires us to look to the ends for which a law is made and to construe its details in harmony with the ends sought. Applying those rules, he reread the preamble. We the people, not we the white people, not we the citizens or the legal voters, not we the privileged class and excluding all other classes, but we the people, not we the horses and cattle, but we the people, the men and women, the human inhabitants of the United States, do ordain and establish this Constitution. Their duty to resist and change. Much has been written about the coming of the Civil War and its causes, but it was fundamentally a war over the nature of constitutional change. How can the Constitution be changed? Amendment or judicial interpretation? And when those methods fail, insurrection. Insurrection came first from the North. Mad-eyed John Brown had long been willing to bear arms in what he called a war against slavery, including in bloody Kansas. I want to have the inquiry everywhere raised, he'd written to Frederick Douglass in 1854. Who are the men that are undermining our truly Republican and democratic institutions at their very foundation? In 1856, he and his followers in Kansas had pledged themselves to preserve the right and liberties of the free state citizens of Kansas. But after Taney's ruling, Brown gave up on the Constitution altogether. He began planning an attack on the U.S. arsenal at Harper's Ferry, Virginia, to supply enslaved men in the South with guns to foment a revolution across the South. At some point, he stopped in Chicago. The first time I ever met John Brown, he came to our house one afternoon with Fred Douglass, Mary Jones later said, and they stayed up until late, and John Brown stayed all night. She disagreed with Brown's plan. "I did not think he was right," she said, "and I did not believe he could ever do what he wanted to do." In 1858, at Frederick Douglass's house in Rochester, Brown drafted a new constitution. Its opening lines both defied Taney's opinion and drew upon the declarations of black conventions. "We, citizens of the United States and the oppressed people, who, by a recent decision of the Supreme Court, are declared to have no rights which the white man is bound to respect, together with all other people degraded by the laws thereof, do for the time being ordain and establish for ourselves the following provisional constitution and ordinances, the better to protect our persons, property, lives, and liberties, and to govern our actions." He told Douglass he wished him to be the new government's first president. He then headed to the town of St. Catharines, Ontario, where he met with Harriet Tubman and secured her support. The next month, in Chatham, Ontario, Brown and his band of 34 black men and 12 white men held a secret convention in which they debated and approved the new Constitution. On the 4th of July, 1859, the date Brown had originally planned for the attack, he drafted a Declaration of Liberty by the representatives of the slave population of the United States of America. It was written on sheets of paper pasted to a bolt of cloth, wound around a wooden dowel like an ancient scroll. Biblical. "We hold this truth to be self-evident," he wrote, "that it is the highest privilege and plain duty of man to strive in every reasonable way to promote the happiness, mental, moral, and physical elevation of his fellow man." He asserted that governments are instituted to secure equal rights, privileges, and justice to all, irrespective of sex or nation, and that whenever a government fails to meet those ends, as for instance, when they have refused to grant petitions presented by numerous and respectable citizens, asking redress of grievances imposed upon us, demanding our liberty and natural rights, then it is the right of the people to alter, amend, or remodel it, and moreover, it is their duty to resist and change such government. With his Declaration of Liberty and Provisional Constitution, Brown aimed to replace the nation's founding documents with revised editions. But he was prepared to ratify these documents with force of arms. He and 5 black men and a dozen white men raided the Harper's Ferry arsenal in October 1859. Everything went wrong, and they were all, in the end, captured or killed. At Brown's trial in Virginia 9 days later, the prosecution introduced the Provisional Constitution as evidence that Brown had committed treason for having attempted to break down the existing government of the Commonwealth and establish on its ruins a new government. Brown's defense pointed to his Constitution's Article 46, which explained that nothing in the Provisional Constitution was to be construed so as in any way to encourage the overthrow of any state government. Instead, its entire purpose was amendment and repeal. If the Constitution was a machine in the minds of the framers, John Brown did not take out a wrench or a screwdriver to tinker with it. He took out a gun and a 7-foot pike. Here, Brown insisted, was not a new Constitution, but a series of violent improvements, long overdue. Nearly a century overdue. Ameliorations, corrections, adopted at a convention, amend and repeal, amend and mend, stitch the world together again. He was hanged. Chapter 5. The whole rebellion is beyond the Constitution. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. Failed amendment to the U.S. Constitution, passed by the Senate and by the House in 1861. Jefferson Davis, the half-blind ex-president of the Confederate States of America, leaned on a cane as he hobbled into the courtroom on the 3rd floor of the federal courthouse in Richmond, Virginia, on May 13, 1867. 2 years after Appomattox. "A gaunt and feeble-looking man," one reporter wrote, describing Davis, 58. He wore a soft black hat and a sober black suit. He looked like a corpse. Only days before, a reporter who met Davis on the boat ride to Richmond had written that his step was light and elastic. But in court, facing trial for treason, Davis gave every appearance of being bent and broken. He'd spent 2 years in military prison. He wanted to be released. A good many Americans wanted him dead. "We'll hang Jeff Davis from a sour apple tree," they sang, to the tune of John Brown's body. Jefferson Finis Davis was born in Kentucky in 1808. Finis, the end. As Robert Penn Warren would remark many years later, Davis dropped the middle name probably as early as he was put to his Latin, but who can so easily throw away his fate? He would be a man better known for his end than for his beginning. Davis had been first elected to the Senate from Mississippi in 1845. "Cold as a lizard," Sam Houston called him. A West Point graduate, he had fought in the Black Hawk War and the Mexican War and served as Secretary of War under Franklin Pierce. He believed the Constitution had established only a compact between states. He believed in slavery, states' rights, and secession, 3 ideas in one. Every state had a right to secede, he insisted in his farewell address to the Senate in 1861, and Mississippi had every reason to. "She has heard proclaimed the theory that all men are created free and equal, and this made the basis of an attack upon her social institutions, and the sacred Declaration of Independence has been invoked to maintain the position of the equality of the races." Because the principles of equality and liberty threatened Mississippi's social institutions, by which Davis meant slavery, Mississippi, he feared, was to be deprived in the Union of the rights which our fathers bequeathed to us. 2 weeks later, Davis was elected President of the Confederacy. The cornerstone of the new government, his Vice President Alexander H. Stephens said, rests upon the great truth that the Negro is not equal to the white man. These claims, like the argument for secession, were to be tested in the trial of Jefferson Davis for treason, where he was to face a jury drawn from a pool of 12 white men and 6 black men. They would be the Constitution's newest interpreters. The Civil War, Reconstruction, and even the trial of Jefferson Davis recast the Constitution, marking the end of an era and establishing the United States as the world's first multiracial democracy. 700,000 people had died in a war that lasted 4 wretched, miserable, terrifying years. The whole rebellion is beyond the Constitution, the constitutional scholar Francis Lieber wrote in 1864. The Constitution was not made for such a state of things. Decades before the war, Lieber had written a treatise called Legal and Political Hermeneutics, or Principles of Interpretation and Construction in Law and Politics, a closely argued guide for citizens on the methods of reading legal documents, including constitutions. Seek for the true spirit, which pervades the whole Constitution, Lieber advised. During the war, he would offer a new philosophy of amendment. Unlike the framers who wrote about the Constitution as a machine John Brown had attacked with a gun and a pike, Lieber described the Constitution as a creature, a living thing whose unplastic form is no longer able to contain the swelling life within, a living, pregnant thing. Lieber notably rejected Darwinism, which he described as an attempt to prove to you that your grandmother was a hideous gorilla. His notion of a living constitution had nothing to do with evolution. In the 1860s and 70s, the U.S. Constitution was rewritten. As Thurgood Marshall would one day say, while the Union survived the Civil War, the Constitution did not. By the end of Reconstruction in 1877, the Constitution of 1787 cast a shadow 9 decades long. But as W.E.B. Du Bois would later point out, The Civil War was unconstitutional, and so too were the 13th, 14th, and 15th Amendments. If one means by constitutional something provided for in that instrument or foreseen by its authors or reasonably implicit in its words. But this is hardly a sensible way to understand the meaning of constitutionalism, Du Bois argued. No more idiotic program could be laid down than to require a people to follow a written rule of government 90 years old if that rule had been definitely broken in order to preserve the unity of the government and to destroy an economic anachronism. Something had withered and died, and something else had been born. The Civil War gave birth not only to new amendments, but also to a new hermeneutics of interpretation and a revised philosophy of amendment. The Union gone. Abraham Lincoln, the lanky, log-splitting idealist from Illinois, was elected president on November 6, 1860, without having won a single Southern state. Many in the South simply refused to accept the outcome. "The election of Lincoln is the dissolution of the Union," a Charleston newspaper announced under the headline, "The Union Gone," and urged citizens, "The sooner we arm and organize, the better." Southerners believed that Americans opposed to slavery were now committed enough and powerful enough to end it. On November 13th, the South Carolina legislature called for a convention to consider secession. Could a constitutional amendment avert civil war? For decades, even as the states amended their constitutions again and again, Americans had steered clear of federal amendment. Hoping to avert the looming crisis over slavery in the form of nullification and secession, Congress had worked out a series of compromises over slavery and nullification in 1819, 1832, 1850, and 1854. So fearful had some white Southerners become of amending the U.S. Constitution that by 1850, a member of Congress from North Carolina had proposed an amendment to Article 5, providing that no amendment shall be made the object or tendency of which is to abolish or in any way affect the institution of slavery in any state without the concurrence of all the states in which such institution may exist. And then in 1857, the Supreme Court had stepped in with Dred Scott, rewriting the Constitution by faithfully rereading it, according, Tawney said, to the original intent of its framers. By November 1860, when Lincoln was elected, 3 generations had passed since the last time the Constitution had been amended, with the 12th Amendment in 1804. For all their ceaseless amending of state constitutions, Americans had never tried to end slavery by amendment. Neither passage in Congress nor ratification in the states would have been within reach. Nor was there ever any real chance that secession could be avoided by a federal constitutional amendment, but people tried all the same. In Congress, Northern Democrats hoped to appease the South by amending the Constitution in line with Southern demands. On December 3, 1860, when the 36th Congress opened its second session, outgoing President James Buchanan urged Congress to pass a clutch of constitutional amendments aimed at recognizing the right of property in slaves, the duty of the federal government to protect this right, and the right of the master to have his slave who has escaped from one state to another restored and delivered up to him. Buchanan's fellow Democrats proceeded to do exactly as he'd asked, sending more than 100 quisling amendments to a committee chaired by Ohio Representative Thomas Corwin. On December 18th, the day after South Carolina's secession convention opened, Kentucky Senator John J. Crittenden introduced a 5-part proposal known as the Crittenden Compromise that would have done everything Buchanan requested and one thing more. It provided that no future amendment could ever abolish either slavery or the 3/5 clause. On December 20th, South Carolina's convention voted to secede, 169-0. Amid the chaos, petitions submitted to Congress by citizens, and especially by religious groups, called for amendments either prohibiting slavery or at least not sanctioning it. One group of citizens from Michigan submitted a petition remonstrating against any constitutional amendment or compromise except on the basis of the abolition of slavery, while another group from the same state begged that no attempt be made to amend the Constitution of the United States during the continuance of the present unusual excitement in the country. And still Congress continued to debate appeasement amendments. On December 24th, Jefferson Davis offered up his proposal, the only constitutional amendment he ever introduced in his long career. It would have established ownership of human beings as a constitutional right, guaranteed the extension of slavery to the territories, and reinforced the Fugitive Slave Clause. Property in slaves, recognized as such by the local law of any of the states of the Union, shall stand on the same footing in all constitutional and federal relations as any other species of property so recognized, Davis's amendment read. There were more desperate pro-slavery ideas, too, including a proposal introduced by Tennessee Congressman Andrew Johnson that half the judges on the Supreme Court should be from slave states and half from free states. Like the Crittenden Compromise, most efforts at appeasement included what are sometimes called never-never amendments, provisions that amendments protecting slavery shall be forever irrepealable and unamendable, and that no amendment shall be made to the Constitution which will authorize or give to Congress any power to abolish or interfere with slavery. The position of Democrats in Congress who wished to conciliate secessionists then was the abdication of the very idea of amendment, the forbidding of amendment. Even as Democrats in Congress offered the suggestion that, in the matter of human bondage, the Constitution was to sanction it and then become unamendable, Southerners at secession conventions proposed what might be called blackmail amendments, laying out the terms under which they would agree to remain in the Union. At Alabama's convention in early January, delegates opposed to secession issued a minority report advocating a series of amendments along the lines of the Crittenden Compromise, and including a never-never amendment. But the firebrand secessionist William Lowndes Yancey thundered that no amendments of the Constitution can afford the least inducement to consider even a proposition to reconstruct our relations with the non-slaveholding states. Alabama seceded 4 days later. Within the week, at Georgia's secession convention, delegates proposed 9 indispensable amendments to the Constitution of the United States, whose immediate ratification, they said, was the only condition under which Georgia would remain in the Union. These included those proposed in Congress, with some notable additions. The Supreme Court having decided that Negroes are not citizens of the United States, no person of African descent shall be permitted to vote for federal officers nor to hold any office or appointment under the government of the United States. Georgia seceded the next day, and so it went. Mississippi having seceded, Jefferson Davis delivered his farewell address to the Senate on January 21st. 3 days later, delegates to Louisiana's secession convention in Baton Rouge moved to fix upon and determine what amendments of the Constitution of the United States are necessary and proper to secure the rights of the slaveholding states of the Union. This motion was defeated the next day, 24 to 106. Louisiana seceded on January 26th. The Union was gone. No amendment shall be made. In January 1861, as the South seceded, Francis Lieber, a curly-haired Prussian-born professor of history and political science, began his course of lectures on the modern state at Columbia College of Law. The law school had opened only 3 years before, and it didn't quite yet have a home. Classes were held in rented rooms at a building at Lafayette Place, across the road from an African burial ground that had closed in 1795 and contained the remains of 15,000 black New Yorkers who built New York, and whose memory was daily being forgotten as the city grew up on top of their graves. Their coffins bore the marks of their beliefs, beads and brass tacks, and their bones bore the marks of their suffering, bowed and broken limbs and musket balls lodged in rib cages. Many had been carried from West Africa. They were buried with hundreds of shells, in hopes of going home. "The shells stand for the sea," it was said. "The sea brought us, and the sea shall take us away." Night after night, across from that graveyard, Lepore lectured by gaslight on the Constitution and inquired into the constitutionality of secession. He likened the experience to an ocean voyage, telling his students he felt much like a man obliged to discourse on navigation aboard a threatened craft in foul weather when the ghastly foam of breakers is spied and the turmoil on the shoal is heard to the leeward. The ship of the modern state was running aground. By the start of February, all 7 states of the Lower South had seceded. They insisted on their right to withdraw from a constitution that, according to their reading of the original intent of its framers, was no more than a compact. "What is the Constitution of the United States?" Professor Lepore asked. "Do the states form a league? Or is the Constitution a pact, a contract, political partnership of contracting parties? Do we live in a confederacy? And if so, in a confederacy of what degree of unitedness? Or is the Constitution a framework of government for a united country, a political organism of a people with its own vitality and self-sufficing energy? Do we form a union or an aggregate of partners at pleasure?" Lepore believed the Constitution had established a national government, and he believed secession to be treason, and that any contention that the Constitution was a contract was altogether without historical proof. On February 9th, delegates from the seceding states met in a convention in Montgomery, Alabama, formed the Confederate States of America, and elected Jefferson Davis as their president. In another convention, they drafted a new constitution to make explicit what the framers in 1787, they argued, had always intended. The Confederate Constitution forbade the passage of any law denying or impairing the right of property in Negro slaves. This new frame of government, Alexander H. Stephens declared, has put at rest forever all the agitating questions relating to our peculiar institutions, African slavery as it exists among us, the proper status of the Negro in our form of civilization, by establishing that slavery, subordination to the superior race, is his natural and moral condition. In his inaugural address as President of the Confederacy, Davis invoked Taney's opinion in Dred Scott and his original intent method of constitutional interpretation. The Confederacy's Constitution, Davis insisted, differed from the U.S. Constitution only insofar as it is explanatory of their well-known intent to sanction slavery. But there were more differences, too, including the fact that the Confederate Constitution had not been popularly ratified. Davis, in his address, celebrated secession as an expression of the will of the people through a peaceful appeal to the ballot box. But no state in the Confederacy, except Texas, submitted the new Constitution to the people for ratification. 8 slave states, North Carolina, Virginia, Maryland, Delaware, Kentucky, Tennessee, Arkansas, and Missouri, had yet to secede, and 4 never would. Beginning on February 4th, 131 delegates from 21 states met in a peace conference at Washington's Willard's Hall, an old theater. John Tyler, the former American president, served as presiding officer. The convention proposed 7 amendments, including the Crittenden Compromise, which extended the 36 degrees 30 minutes all the way to California. But Virginia wished to extend that line to any territory now held or hereafter acquired, which would have allowed, for instance, extending slavery to Cuba, Mexico, or Nicaragua if conquered or acquired by the United States. The Crittenden Compromise passed, but without the hereafter clause. A never-never amendment also passed 12 states to 7. Indiana, Iowa, and all 5 New England states voted against it. None of these proposed amendments had any chance at ratification. The convention adjourned on February 27th. In a measure of the weakness of Tyler's own commitment to amendment, the next day he delivered a public address in Richmond, calling on his home state, Virginia, to secede. Between January and March 1861, the legislatures of 6 states Illinois, Indiana, Kentucky, New Jersey, Ohio, and Virginia asked Congress to call for a constitutional convention, hoping to keep the Union together. Most resolutions, like New Jersey's, urged forbearance and compromise, but appeasement had not exhausted itself. One element of the Crittenden Compromise, a never-never amendment introduced by Ohio Representative Thomas Corwin, no amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere, within any state, with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state, found sufficient support in Congress. On February 28th, it passed the House 133 to 65, and on March 2nd, 2 days before Lincoln's inauguration, it passed the Senate 24 to 12. Abolitionists considered the Corwin Amendment an abomination, and really, it was more an anti-amendment than an amendment. Ohio Congressman John Bingham called it a tool of perpetual despotism that undermined the Constitution by striking at the inherent right of the people to alter or amend it at their pleasure. But Lincoln endorsed it, and in his inaugural address vowed not to interfere with slavery where it already existed, even though he objected to its extension. If there were to be amendments, Lincoln said, he'd rather Congress not propose them. To me, the convention mode seems preferable in that it allows amendments to originate with the people themselves. Still, as for the constitutionality of secession, Lincoln agreed with Francis Lieber. Plainly, the central idea of secession is the essence of anarchy, he said. Anarchy came. Illegal, unjuridical, unphilosophical, and unethical. On April 12, 1861, Confederate forces fired on the U.S. garrison at Fort Sumter, off the coast of Charleston, South Carolina. 2 days later, Lieber forwarded a copy of his lectures on the Constitution to Lincoln's Secretary of State, William Seward. Seward read them, and Lincoln read them, and then Lieber, taking a leave of absence from Columbia, went to Washington, where he propounded not only a theory of secession as treason, but also a manual on the laws of war, and a treatise on the philosophy of amendment. Lieber, a man unopposed to self-flattery, considered himself America's leading political philosopher. My work belongs to the list which begins with Aristotle, and in which we find the names of Thomas More, Hobbes, Hugo Grotius, Pufendorf, he puffed. In truth, his work proved enormously influential. Into the 1950s, graduate students in at least one seminar in American political thought were required to read his Civil Liberty and Self-Government. Born in Prussia in 1798, the 10th of 12 children, he'd studied in Berlin and Jena, where he earned a Ph.D. in mathematics. He fought in the Battle of Waterloo, was wounded fighting for Greek independence, and was twice imprisoned for his political beliefs, once for a year, before emigrating to the United States in 1827. Landing in Boston, he took up teaching and literary work. In the 1830s, he conducted research for Alexis de Tocqueville. Sometimes referred to as a German Tocqueville, he published, beginning in 1829, the best-selling Encyclopedia Americana. In 1832, he became an American citizen. He spent much of his career studying American citizenship. In Boston, Lieber befriended Charles Sumner and advanced abolitionist views, writing in 1835 in a book called The Stranger in America, I hold slavery to be philosophically an absurdity. Man cannot become property. Morally a bane both to the slave and his owner, historically a direct violation of the spirit of the times we live in, and with regard to public economy, a great malady to any society at all advanced in industry. Unable to secure an academic appointment in the North, he reluctantly accepted a professorship at South Carolina College, now the University of South Carolina. Lieber and his wife, Matilda Oppenheimer, moved there with their very young family. Their oldest son, Oscar, was 5 years old. For his inaugural lecture in South Carolina in 1835, Lieber denounced the school of thought that considers everything which has been handed down through generations as lawful, good, wise, and not to be touched, perhaps not even to be judged and freely examined merely because it has been handed down. This view of change would inform, too, his understanding of the Constitution. "The Constitution is not a deity," he wrote, rather daringly. A strong nationalist and an equally strong Republican, Lieber wrote a string of books during his years in South Carolina, including a popular textbook on civil liberty and self-government, 1853. But one of his most influential works was Legal and Political Hermeneutics, or Principles of Interpretation and Construction in Law and Politics, published in Boston in 1839, the year before Madison's Notes on the Constitutional Convention first appeared in print. Lieber introduced German hermeneutics into American law. His wife nicknamed the book Hermie. The work also reflects the influence on Lieber of his intimate friendship with Joseph Story. The two men had become friends when Lieber lived in Boston, and they remained close correspondents. Story spent only part of the year in Washington when the court was in session. Story had also contributed all 18 of the major legal essays that appeared in Lieber's 13-volume Encyclopedia Americana, work he did for free out of his love for Lieber. After Lieber moved to South Carolina, the two men maintained a lively correspondence, and when Lieber traveled, he regularly met with Story, reading drafts and portions of his books. "Last Saturday I was at Cambridge," he reported to his wife Matilda in 1839, "and read to Judge Story my chapter on the judge, juror, advocate, and witness, and he said it was by far the best he had ever seen upon these important subjects." Lieber's credibility on this point is perhaps to be doubted, since in the same letter he boasted that Story was working hard to find someone to endow a professorship for him at Harvard's law school, and wanted me there beyond any man in America, and they must have me. He'd written the book not only for lawyers, but for citizens. Having himself spent a year in a Prussian jail as a political dissident, Lieber believed the capacity for reading legal documents was a requirement of every citizen of a republic. Lieber, who claimed, in error, to have coined the words nationalism, internationalism, and individualism, brought to his theory of interpretation not only German hermeneutics, but also fluency in German, Italian, English, Spanish, Greek, Latin, and French, and knowledge of Chinese, Danish, Russian, Swedish, Hebrew, and Sanskrit. Interpretation, Lieber argued, is the discovery of the true sense of words, which requires determining that meaning which those who use them were desirous of expressing. The book is a set of rules and principles to use to interpret many different kinds of evidence, from conversations and speeches to diaries, statutes, and treaties. He had a strikingly organic conception of the law. "A code is not a herbarium in which we deposit law like dried plants," Lieber wrote. "Let a code be the fruit grown out of the civil life of a nation and containing the seed for future growth." Yet he had surprisingly little to say about constitutions, and most of what he said was comparative, with attention to the constitutions of Prussia, Belgium, Sweden, Brazil, and France. He said hardly anything at all about the U.S. Constitution. As to what he did say, beyond that Constitution should be interpreted closely, it came down to this: liberty is not decreed in so many words on parchment, since parchment may be eaten by the worms, may be torn by any daring hand. Liberty is decreed by constitutions only insofar as their words are the pronouncing and solemn expression of that which lives within the nation, its living essence. It was always possible to offer what Lieber called a faithless interpretation. The Constitution of the United States bestows prerogatives upon the president which might deprive the people of all liberty the moment they should become indifferent enough to allow it. The best rule, therefore, was to seek for the true spirit which pervades the whole Constitution and interpret it in good faith accordingly. That Lieber declined to offer more precise methods of constitutional interpretation in a lengthy and otherwise comprehensive treatise on legal hermeneutics is best explained by the fact that he was writing from South Carolina, shortly after the nullification crisis. During his years in South Carolina, he wrote a great deal that he did not publish, including a series of letters to John C. Calhoun opposing nullification and states' rights, letters he did not send. "It is not the North that is against you," Lieber wrote Calhoun. "It is mankind, it is the world, it is civilization, it is history, it is reason, it is God that is against slavery." He hated the South. "I loathe it from the inmost of my heart," he wrote. Yet, year in and year out, he remained unable to secure an academic appointment in the North. For all that Lieber and his wife opposed slavery, they bought, hired, or rented out at least 5 people during their 21 years in South Carolina. In 1836, Lieber bought a 13-year-old girl named Elsa for $475 and insisted on buying her mother Betsy for $675 to keep the two together. In his diary, he listed the reasons why we bought them, including, "It is no injustice to have slaves where slavery exists and emancipation does not happen. Also, we believe it will be cheaper for us." And his wife wanted to thoroughly educate the slave women. Elsa died in 1841, giving birth to a child who was white. The baby also died. Yet it may have been Lieber's close knowledge of slavery that made him later such an ardent opponent of it. Had Lieber publicly propounded his anti-slavery views while living in South Carolina, he would have lost his appointment. Having kept them quiet, he lost his friendship with Sumner. But while he was unwilling to publicly oppose slavery, he did publicly oppose secession, as in his lectures on the Constitution in 1851, after South Carolina threatened to leave the Union. In an address for a 4th of July celebration in Greenville that year, he celebrated the Union. "There has never been a union of free states like ours, cemented by a united representation of the single states and of the people at large, woven together into a true government like ours." Warned of war, "No great institution, and least of all a country, has ever broken up or can break up in peace," and mocked secession as about as good a remedy for political disagreement as cutting your throat is a remedy for a migraine. Lieber campaigned for the presidency of the college, but was denied the post on the suspicion that he was an abolitionist. In 1856, finding his political situation untenable, he resigned and left South Carolina for New York, leaving behind his oldest son, 26-year-old Oscar. The next year, just before the Supreme Court issued its decision in Dred Scott, a decision Lieber called illegal, unjuridical, unphilosophical, and unethical, he finally secured his long-sought faculty position in the North, at Columbia. He had by now been denounced across the South. On November 7th, 1860, when the Charleston Mercury announced Lincoln's election on its front page, a story about Lieber appeared just below it, titled, "Dr. Lieber, a Renegade." It noted that he had dishonored himself by becoming an abolitionist and reported that a literary society at South Carolina College, which counted John C. Calhoun and Jefferson Davis among its members, had disenrolled him. Later, the club would take his portrait down from the wall and throw his bust out the window. Secessionists considered secession merely an exceptionally radical form of amendment, the abolish in the phrase to alter or abolish. But when South Carolina seceded, Lieber declared secession unconstitutional. He then set about revising his treatise on legal hermeneutics, to a passage in which, in the 1839 edition, he had remarked on the Postal Service's banning of the transmission of abolitionist literature through the mail. He added, in 1860, this question: where is it to stop? The Lieber Code. In June 1861, Lieber traveled to Washington and, on behalf of Columbia, visited the White House to deliver an honorary degree to Lincoln. That fall, back at Columbia, he began teaching a new course at the law school, The Laws and Usages of War. The New York Times reprinted each of his lectures. They were picked up by newspapers all over the North. Even as Lieber meditated on the laws of war, his sons took up arms, one for the Confederacy and two for the Union. "Behold in me the symbol of civil war," Lieber wrote. By June 1862, his son Oscar had died of injuries sustained while fighting in the Confederate Army, while another son had lost an arm, fighting for the Union. That summer, Lincoln's administration called on him to prepare an essay distributed to Union troops called Guerrilla Parties Considered with Reference to the Laws and Usages of War. If the Union were to conduct the war lawfully, the laws it would obey would be laws devised by Lieber. In September, Lincoln issued a preliminary Emancipation Proclamation, announcing that as of New Year's Day, 1863, he would declare the freedom of all people held as slaves in any state in rebellion against the United States. It was a military measure, an act of war. The month before it was to go into effect, Lincoln's Secretary of War, Edwin Stanton, telegrammed Lieber in New York, calling him back to Washington. There, Lieber adapted his Columbia lectures for the War Department, moving from the specific urgent request to establish a policy with regard to emancipated and escaped slaves and black soldiers to a wholesale code of law. When, on New Year's Day, Lincoln issued the Emancipation Proclamation, Jefferson Davis and Southern newspapers denounced it as an attempt to incite a slave rebellion. The Confederate Congress entertained a retaliatory resolution that all rules of civilized warfare should be discarded in the future defense of our country. Lieber, meanwhile, was completing a work on a manual of 157 provisions published in May 1863 as a 36-page Code for the Government of Armies in the Field as authorized by the Laws and Usages of War on Land, 1863. It was issued by Lincoln to the Union Army as General Orders No. 100, but it is better known as the Lieber Code. The Lieber Code called for restraint in war. Men who take up arms against one another in public war do not cease on this account to be moral beings, responsible to one another and to God, Lieber wrote. The Lieber Code, like his later philosophy of amendment, was avowedly nationalist. To save the country is paramount to all other considerations, he wrote in Article 5. He argued for the vigorous pursuit of victory. The more vigorously wars are pursued, the better it is for humanity. Sharp wars are brief. He called for treating rebel soldiers not as criminals, but as lawful combatants, insisting that this does in no way imply a partial or complete acknowledgement of their government. Any escaped slave, whether from a rebel state or not, was to be immediately entitled to the rights and privileges of a freeman. Color could not bar a soldier from combat. Moreover, the law of nations knows no distinction of color, and anyone who sold a black soldier into slavery was to be put to death. Lieber wrote, to return such persons into slavery would amount to enslaving a free person, and neither the United States nor any officer under their authority can enslave a human being. Lieber is best remembered for the Lieber Code. It became the model for later laws of war, including the Geneva Conventions. Yet nearly as critical, if not to the war, then to the peace, were Lieber's hermeneutics of constitutional interpretation and his philosophy of constitutional amendment. The simple fact is, he wrote to Charles Sumner, the Constitution stopped short some 500 miles this side of civil war like ours. Lieber sought to close that distance. This altered society. In the spring of 1863, long before members of Congress and even many abolitionists reached this conclusion, Lieber had become convinced of the need for a series of constitutional amendments to end slavery, guarantee black citizenship, redefine treason, and reconstruct the nation. He was particularly keen to establish the implications, under the laws of war, for the former Confederacy. He wrote a note to himself, Amendment of Constitution. Either you must execute, banish, burn, etc., or you must carry off as the prize of victory a change of the Constitution. The war had cost so much. Mass executions of the leaders of the defeated Confederacy would be a terrible, terrible thing. Instead, the victor's spoils, Lieber believed, should come in an altered and improved Constitution. The Emancipation Proclamation freed only those people held as slaves in the rebel states. What of slaves in the rest of the country? Many abolitionists had maintained that no amendment would be necessary for a general emancipation because, as they argued, the Constitution had never sanctioned slavery and therefore did not need to be altered to end it. But now that it could be changed, the South no longer held the ability to defeat ratification. There was little reason that it shouldn't be. In October 1863, an abolitionist from Missouri, speaking at a mass meeting at the Cooper Institute, reportedly said that if the Constitution of the United States recognized slavery, though he didn't believe it did, he wanted it amended. In December, the abolitionist Wendell Phillips delivered a lecture on the same stage in which he insisted on the power of amendment. "You may say we have no power so to amend the Constitution," he expected his audience to complain. But, he countered, the people do retain that power. Conjuring the most extreme amendments he could think of, you could make Lincoln hereditarily president. If you choose, give it to his son. You could make the Senate hereditary. You could give women the ballot. You could take it from men under 50. You can do anything. Phillips proposed 2 amendments. First, hereafter there shall be neither slavery nor involuntary servitude in any state of this Union. And second, no state shall make any distinction among its citizens on account of race and color. The constitutional arguments made at decades of black conventions had at last been heard. Lincoln asked his Attorney General, Edward Bates, to inquire into the constitutional question that had since 1829 dominated black conventions. Are colored men citizens of the United States? Bates answered definitively yes, concluding, "If I have succeeded in placing upon impregnable grounds of law and logic the proposition that a person may be a citizen without being white, that is all I aimed at." He'd followed the logic of black abolitionists, like John Jones, in Lincoln's home state of Illinois. In 1864, Jones published The Black Laws of Illinois and a Few Reasons Why They Should Be Repealed. The state's 1848 Constitution declares that all men are born free and independent and have an indefeasible right to enjoy liberty and pursue their own happiness, Jones wrote. But this section denies the colored man equal freedom to settle in this state. Moreover, the U.S. Constitution declares that the citizens of each state shall be entitled to all the privileges and immunities of the several states. But are not black people citizens? If being natives and born on the soil of parents belonging to no other nation or tribe does not constitute a citizen in this country, under the theory and genius of our government, I am at a loss to know in what manner citizenship is acquired by birth. And now, the U.S. Attorney General agreed. Lieber believed the time had come for a cache of amendments. Early in 1864, he circulated to members of Congress an essay that offered both a philosophy of amendment and 7 proposals that he believed necessary to secure the future of the Union after the defeat of the Confederacy. He began by articulating the idea of amendment as peaceful revolution, the Constitution's means to prevent violent eruptions. The Constitution was alive, Lieber argued, and the condition of life is change. And for constitutions, as for people, cessation of change is death. This, in 1865, was particularly freighted language. Death at the time was everywhere. The dead lay on battlefields and in graveyards, rotting and decayed, on church altars and in funeral parlors, embalmed and pallid and waxen as candles. Dire illustrations of the consequences of constitutional failure. Cessation of change is death. To those who would defer to the framers and their original intent as if they were divinely inspired, Lieber countered that men who wrote the Constitution were instead finite and imperfect beings, men like ourselves, to whom the future state of our country was not revealed. And in any case, such deference to the past was nonsense. Shall a house not be repaired, though it have become ever so damp, simply because an ancestor built it? Amendment rests on a theory of change, he argued, and no country or people of antiquity or modern times has changed in circumstances and condition, in national consciousness, and in great public opinion, as the United States had in the last 60 years. Echoing the rhetoric of progress so frequently heard at state constitutional conventions, he offered a litany of changes. The extension of our territory from sea to sea, the magnitude of our commerce, the unparalleled growth of our population, the internal union and mutual necessity of all its parts, our relation to foreign nations, our literature, our school systems, our wealth, and our knowledge of far greater, though undeveloped wealth, the consciousness of nationality on the one hand, and the development on the other of an extravagant idea of states' rights. The outspoken disgust at slavery, its dangerous character here, and its exaltation as a blessing there. Who can tell all the changes which have taken place, for weal or woe, within the last half-century in this country? Amid this flurry of change, slavery stood as a deplorable anachronism. And then the war itself offered sufficient proof that practical changes have taken place, that plainly required changes in the political framework of society. Lepore wished the country were in a position to hold a second constitutional convention, to start all over again. But neither the times nor the country would allow it. Lepore's 7 proposed constitutional amendments, published as Amendments of the Constitution submitted to the consideration of the American people, included an amendment prohibiting slavery in the United States. "Let us have no slavery is dead," Lepore wrote to Sumner, as the 13th Amendment awaited passage in the House. "It is not dead. Nothing is dead until it is killed." So many men had gone to their deaths on so many battlefields. So many had lingered and suffered. Might not this one great evil, the cause of it all, be finally dispatched? On January 31st, 1865, the House passed the 13th Amendment and sent it to the states for ratification. Lepore, on hearing the news in the morning, was so excited that he could not shave. John Jones's long fight to repeal black laws in his home state finally came to an end when the Illinois legislature became the first state to ratify the 13th Amendment. Illinois also at last repealed its black codes. In Chicago, Jones, now an old man, ignited the fuse on a cannon that was fired to celebrate, with a thundering blast, the conclusion of a campaign he had begun decades before, with a whisper. To stamp treason as treason. Slavery had ended, but not the war. A desperate and haggard Jefferson Davis fled Richmond, the capital of the Confederacy, on April 2nd, 1865, as the city fell to advancing Union troops. During the war, the Confederacy had used the federal courthouse in Richmond as the government's headquarters. Davis and his cabinet had used the courtroom as a war room, covering its walls with maps while they plotted battles and moved troops. The judges' chambers had served as Davis's presidential office. As Confederate forces retreated, they set fire to the city. The courthouse, built of brick and granite, was one of only a handful of buildings to survive the blaze. 7 days after Richmond fell, Robert E. Lee surrendered to Ulysses S. Grant at Appomattox. Davis, meanwhile, headed south, apparently hoping to escape to Mexico. Lincoln hoped that Davis and other Confederate leaders might manage to cross the border, because what to do with them if captured would present all kinds of problems. "I'm bound to oppose the escape of Jeff Davis," Lincoln is alleged to have told General William T. Sherman, "but if you could manage to have him slip out unbeknownst-like, I guess it wouldn't hurt me much." On April 11th, Lincoln gave a speech from the White House in which he touched on a series of questions his administration was facing at war's end, including 2 issues generally seen as a matched pair: amnesty for white men who had fought for the Confederacy, and voting rights for black men who had fought for the Union. "If universal amnesty is granted to the insurgents, I cannot see how I can avoid exacting in return universal suffrage, or at least suffrage on the basis of intelligence and military service," Lincoln said. John Wilkes Booth, a Shakespearean actor in the crowd that night, seethed, "That means nigger citizenship." 3 days later, Booth shot and killed Lincoln. "That even this should befall us," Lepore wrote, devastated, laying the blame where he believed it belonged. "It is slavery. Slavery!" Jefferson Davis was suspected of having orchestrated Lincoln's assassination. Lepore hastened to Washington. He stayed at the home of Attorney General James Speed, who had replaced Edward Bates, and met with Secretary of War Stanton, with Seward, who, at home in bed, had been stabbed by one of Booth's co-conspirators, and with Lincoln's successor, Andrew Johnson, who was besieged by a parade of Confederates seeking pardons. On May 2nd, Johnson issued a proclamation charging that Lincoln's assassination had been incited, concerted, and procured by Davis and 5 other Confederate agents, and offering a reward of $100,000 for Davis's capture for the purpose of bringing him to trial. Lieber was especially keen to see that happen, despite the fact that Lincoln, had he lived, would almost certainly have issued an amnesty to bind up the nation's wounds, as he'd promised in his second inaugural address. Booth, wounded and hounded, hiding in a barn not many miles from Washington, was shot and killed on April 26th. In July, 4 people convicted of participating in a conspiracy to assassinate Lincoln, his vice president, and his cabinet were hanged in Washington. Union troops captured Davis in Georgia on May 10th as he attempted to sneak out of a tent, cloaked in his wife's shawl. He was carried to a military prison in Virginia. A rope maker from Illinois wrote to Johnson, volunteering to make the rope to hang him. Captain Henry Wirtz, who had served as a commander of the infamous Confederate prison in Andersonville, Georgia, where 13,000 Union soldiers died of starvation and exposure, had been captured 3 days before Davis. He was charged with murder and with conspiring with Davis and others traitorously and in violation of the laws of war to impair and injure the health and to destroy the lives of large numbers of federal prisoners. Tried before a military commission, Wirtz was found guilty on both counts and hanged in Washington on November 10, 1865. From the start, the prosecution of Jefferson Davis was more complicated. "I never cease to regret that Jeff Davis was not shot at the time of his capture," the dauntless and uncompromising radical Republican and Massachusetts Senator Charles Sumner said. Sumner and Stanton wanted Davis tried, like Wirtz, for war crimes before a military commission and a jury of Union soldiers. During the war, the military, operating under the Lieber Code, had conducted nearly 1,000 war crimes trials. In a cabinet meeting in July, Johnson, persuaded by Lieber, decided he wanted Davis tried not for war crimes, but for treason. That same day, Stanton appointed Lieber to head an archive office charged with collecting the records of the Confederacy. Lieber fully expected to find evidence showing a perfect connection between Davis and the assassination. This evidence was not forthcoming. Much appeared to turn on the definition of treason. If Davis couldn't be convicted of treason, the Philadelphia Inquirer remarked, "We may as well expunge the word at once from our dictionaries." The Constitution defines treason against these United States as consisting only in levying war against them or in adhering to their enemies, giving them aid and comfort. In 1842, Joseph Story argued that for a crime to be treason, it is not necessary that it should be a direct and positive intention entirely to subvert or overthrow the government. It will be equally treason if the intention is by force to prevent the execution of any one or more general and public laws of the government, or to resist the exercise of any legitimate authority of the government in its sovereign capacity. The definition of treason had been modified by Congress in 1862, but there remained ambiguity about the difference between treason, rebellion, and insurrection. It had been with this in mind that Lieber had in 1864 drafted and circulated an insurrection amendment, which foreshadowed Lieber's drift toward authoritarianism. "It shall be a high crime directly to incite armed resistance to the authority of the United States, or to establish or to join societies or combinations, secret or public, the object of which is to offer armed resistance to the authority of the United States, or to prepare for the same by collecting arms, organizing men, or otherwise." While Congress entertained that amendment proposal, Lieber hoped trying Davis for treason would stamp treason as treason and bring Davis to the gallows. "I am anxiously looking forward to Jefferson Davis's trial," he wrote Sumner at the close of Wirtz's trial. "But suppose he is not found guilty, is he not, in that case, completely restored to his citizenship? And will he not sit by your side again in the Senate and be the Democratic candidate for the next presidency? I do not joke." Keeping Davis from holding office again, even from seeking the presidency, would require either convicting him or passing another constitutional amendment. The question was how either could possibly be accomplished. The right of this government to exist. Andrew Johnson, who succeeded to the presidency at Lincoln's death, pursued a policy known as presidential reconstruction, welcoming the former Confederacy back into the Union and pardoning Confederate leaders. The states that had seceded held new constitutional conventions to re-enter the Union, but they also began passing black codes, all but reestablishing slavery through racial statutes. Jefferson Davis, like other high-ranking Confederate officers and officials, was not eligible for the pardon Johnson issued in May 1865. Republicans and Northerners wanted the Davis trial to happen fast. If you promptly put Davis on trial for treason, your popular triumph will be complete, Indiana Governor Oliver Morton wrote to Johnson in November 1865, urging him to stand firm by the doctrine that rebellion is treason, that treason is a crime, that a state cannot secede. The trial of Davis, the Philadelphia Inquirer agreed, was needed to render traitors infamous and to have it judicially settled that secession is illegal. But U.S. Attorney General James Speed, belying his name, wanted to slow things down. Americans were still mourning Lincoln and all they had lost in the war. Speed, cautious by nature, wanted temperatures to cool. More, he worried that Davis would use his trial to advance the cause of the Confederacy. And like Lieber, he was especially worried about the consequences were Davis to be acquitted. Bringing Davis to trial risked handing a rather stunning victory to the defeated Confederacy. To a charge of treason, Davis was expected to argue that he had forfeited his American citizenship when Mississippi seceded from the United States, and you cannot commit treason against another country. Were a jury to acquit him on this defense, some feared, Davis's trial would have established the constitutionality of secession. Worse, the men involved in the prosecution had towering political ambitions and were unwilling to risk losing so prominent a case. The first hurdle the prosecution faced had to do with venue. Legal authorities disagreed about whether a military commission could conduct a trial for treason. For the sake of both fairness and political legitimacy, it seemed safest to conduct the trial in a civilian court. That would require holding the trial where Davis had allegedly committed the crime, which meant Richmond. But what jury in the former capital of the Confederacy would possibly convict Davis of treason? Lieber had in 1864 proposed a constitutional amendment, quite a draconian one, to deal with this problem, too. Trials for treason or sedition shall be in the state or district in which they shall have been committed, unless the administration of justice in the respective state or district shall have been impeded by the state of things caused by the commission of the criminal acts which are to be tried. That is to say, you shouldn't have to try someone for treason in a state where you can't convict anyone of treason. That proposal went nowhere. A doctrine called constructive presence that dated to the 1807 trial of Aaron Burr might have been construed to allow for holding the trial in a northern state. Indiana Governor Oliver Morton, for instance, volunteered to try Davis in his state, where the Confederate Army had marauded. But Speed, exercising the greatest possible caution, resolved that the case would be tried in Richmond, partly because Salmon P. Chase, Chief Justice of the U.S. Supreme Court, attended the U.S. Circuit Court in Richmond. At the time, Supreme Court justices rode circuit. Chase, a former U.S. Senator and Governor of Ohio, was best known for, one, his abolitionism — people called him the Attorney General for fugitive slaves — and two, his ambition. He was, it was said, as ambitious as Julius Caesar. In 1864, even while serving as Lincoln's Secretary of the Treasury, he had sought the Republican nomination for president, after which Lincoln accepted his resignation and appointed him to the Supreme Court. Speed hoped Chase's presence on the bench at the Davis trial, alongside the district court judge, would provide the proper degree of authority and solemnity. But while Speed expected to conduct the prosecution himself, he assigned the case to the federal district attorney for the Eastern District of Virginia, Lucius H. Chandler, who had virtually no trial experience. Having moved to Virginia from Maine and never having joined the Confederacy, Chandler was one of only 2 lawyers in all of Virginia who by November 1865 had not been disqualified due to disloyalty. Speed appointed the learned Massachusetts lawyer and father of 12, William Evarts, to assist him. Evarts, nearly as ambitious as Chase, was quite happy to have been put on retainer by the government for what he called the greatest criminal trial of the age. But Evarts left the legwork to Chandler, who, it turned out, had either no idea how to do it or no inclination. Given that all Southern lawyers had lost their licenses, Davis instructed his wife Verena to hire the celebrated New York trial lawyer and pro-slavery Southern sympathizer Charles O'Connor. "I have not left a stone unturned under which there crept a living thing," O'Connor liked to say about how he prepared for a trial. O'Connor was the most famous lawyer in the United States. He was also despised by blacks for his pro-slavery, pro-Confederacy views. An editorial in a black newspaper from San Francisco maintained that he was as great a traitor as Jeff Davis. O'Connor's strategy for his new client was to delay a trial for as long as possible while the national mood cooled. Luckily for O'Connor, this was what Speed wanted too. But everything about the delay alarmed Lieber. "The trial of Jeff Davis will be a terrible thing," he wrote. "Volumes, a library of the most infernal treason will be brought to light, but Davis will not be found guilty, and we shall stand there completely beaten." Frederick Douglass blamed the president, predicting that Davis would never be punished simply because Mr. Johnson had determined to have him tried in the one way that he could not be tried, and had determined not to have him tried in the only way he could be tried. And even if he were tried, any verdict would be appealed to the Supreme Court, which in the aftermath of Dred Scott can hardly be said to have enjoyed the public trust. Asked Harper's Weekly, "Does anybody mean to assert that the right of this government to exist is a question for a court to decide?" Equal protection. If the trial of Jefferson Davis proceeded at a slow and stumbling pace, the amending of the Constitution seemed to proceed faster than anyone could have imagined. "Whole generations of time are now crowded into the span of a few years," said an Indiana congressman. "Growth, development, progress are the expressive watchwords of the hour." As Lieber put it, more vividly, "I, for one, would never have dared to believe it possible that but yesterday a tawny could give his opinion boldly, and an abolitionist was treated like a leprous thing, and that today a member of Congress can declare that the Constitution of the United States never acknowledged man as property. I rub my eyes and I say, where are we?" Aside from the urgent matter of the states that belonged to the Confederacy re-entering the Union, a leading question confronting Congress at the end of the war had to do with the citizenship status of people who had supported the Confederacy and also of people who were not white. For Lincoln and for Lieber, the fates of these two groups of people were linked. Amnesty for Confederates required equal citizenship for blacks. This quid pro quo arrangement also seemed politically possible. Confederate amnesty pleasing Democrats and equal citizenship Republicans. The hitch was making it happen. Beginning in July 1865 and continuing for 9 months, the National Anti-Slavery adopted as its motto and printed in every issue a call for a colorblind constitutional amendment. Proposed amendment of the United States Constitution. No state shall make any distinction in civil rights and privileges among the naturalized citizens of the United States residing within its limits or among persons born on its soil of parents permanently resident there on account of race, color, or descent. This amendment, if ratified, might have been read to guarantee black men the right to vote throughout the United States at a time when black men could vote in only 5 states, all of them in New England. The 39th Congress began its second session on December 4th, 1865. In elections that fall, 2 former Confederate senators and 4 Confederate congressmen were elected to Congress. And the Georgia legislature elected Alexander H. Stephens, former vice president of the Confederacy, to the Senate. The clerk refused to call their names at roll call, and they were never sworn in, but their presence made abundantly clear the need for measures keeping former Confederates from positions of public trust, of at least a portion of those whose crimes have proved them to be enemies of the Union and unworthy of public confidence. And many radical Republicans were not persuaded that the former Confederacy could be trusted to be loyal to the Union, no matter how many oaths they were required to take. One South Carolinian warned Thaddeus Stevens, "If you value the safety of the government and the peace, freedom and happiness of the people, trust them not, though they be willing to swear fealty and devotion morning, noon, and night." In 1865 and early 1866, reports reached Washington that calls for secession were rampant again in the South, and that white Southerners were more out-and-out rebels than they were in 1861. Ex-Confederates founded the Ku Klux Klan in December 1865. Treason does, under existing circumstances, not appear odious in the South, former Union Major General Charles Schurz reported. And there is as yet among the Southern people an utter absence of national feeling. Reports circulated wildly about the suppression of freedom of speech. Northern men have been subjected to the gun, knife, the pistol, the rope, and tar and feathers for opinion's sake all over the South, one correspondent informed Ohio Senator John Sherman. Southern states began passing black codes restricting the rights of freed people. Equally common were reports of white Southerners' violent campaign to reduce newly freed black Americans, as one Union commander testified, to a condition which will give the former masters all the benefits of slavery. The public was by now clamoring for a means to disqualify ex-insurrectionists from office and to guarantee equal rights, regardless of race. Groups of citizens from all over the country presented petitions to Congress urging security against a renewed attempt to secede and against any distinction on account of color or descent, many signed by hundreds of people from Illinois, Indiana, Maine, Massachusetts, New Jersey, New York, Ohio, and Wisconsin. 151 citizens of Bucksport, Maine, submitted a petition requesting that the House impose such conditions upon the rebel states as shall punish treason, at least with ineligibility to office and loss of power, and reward loyalty with confidence and honor. Other petitions adopted different language. One asked Congress to devise a constitutional amendment providing that no person who has been engaged in the late rebellion shall ever be eligible to any office of honor, trust, or profit under the government. Haunted by their terrifying losses in the war, Congress faced the challenge, according to Massachusetts Senator Henry Wilson, of depriving the leaders of the former Confederacy, as well as any future insurrectionists, of power in such a way and with such permanence that the curse of civil war may never be visited upon us again. The day anticipated by the framers of the Constitution has come. With the 14th Amendment, the 39th Congress founded the United States anew. No other amendment so wholly recast the original document, and none has had more consequences for American political and constitutional development. The amendment has 5 sections, each of enormous weight, each the product of compromise. Early in 1866, Congress began considering proposals to guarantee the equal citizenship of freed people alongside proposals to disenfranchise or disqualify Confederate rebels and to recast congressional apportionment, given that the 13th Amendment effectively abolished the 3/5 clause. Thaddeus Stevens proposed a constitutional amendment consistent with the one printed in the National Anti-Slavery Standard. All national and state laws shall be equally applicable to every citizen, and no discrimination shall be made on account of race and color. Ohio Republican and longtime abolitionist John Bingham introduced his own amendment proposal on December 6th, empowering Congress to pass all necessary and proper laws to secure all persons in every state of the Union equal protection in their rights of life, liberty, and property. The next week, the House and Senate established a 15-man Joint Committee on Reconstruction that operated effectively as a second constitutional convention. One of its tasks would be to reconcile these two very different versions of what would become part of the 14th Amendment, Stevens's more radical anti-discrimination amendment and Bingham's more moderate Equal Protection Amendment. On January 25, 1866, Bingham rose to argue for the importance of his equal protection provision in one of the greatest speeches ever delivered in Congress. He began by celebrating the 13th Amendment ratified the year before. Mr. Speaker, the Constitution of our country has been amended. The day anticipated by the framers of the Constitution has come, when there are none but free citizens in the Republic, the bond having become free. The day of the freedman's deliverance has come not without suffering, not without sorrow, not without martyrdom, not without broken altars and broken hearts, not without storm and tempest, such as had not been seen since man was upon the earth, not without darkness, thick darkness that might be felt, and fire running along the ground. Though in terror, though in anguish, the day has come, and all are free in the Republic by the sovereign will of the whole people. And with what result? Simply this, that the Constitution must be amended, because without amendment, the late rebel states would not grant to the freed people all the immunities and privileges of citizenship, nor guarantee to them the equal protection of the laws. Bingham agreed with the resolutions passed over decades at black conventions, pointing out that whenever the word white as a condition of the elective franchise had been inserted into state constitutions, that put those states in violation of the U.S. Constitution. I believe that the free citizens of each state were guaranteed, and intended to be guaranteed by the terms of the Constitution, all, not some, all the privileges of citizens in the United States in every state. As Congress debated these different approaches to what would become the 14th Amendment, the Joint Committee on Reconstruction heard testimony from 145 witnesses, including military leaders, elected officials, federal judges, former Confederates, and black freedmen. It sought to determine whether the readmission to the Union of the states of the former Confederacy should only be granted upon certain conditions and guarantees which would effectually secure the nation against a recurrence of evils so disastrous as those from which it escaped at so enormous a sacrifice. A representative example from its more than 800 pages of testimony is that of J.W. Alvord, who worked for the Freedmen's Bureau. He was questioned about conditions in Virginia and in other southern states. Question. Now state, what among the rebel people is the general feeling towards the government of the United States? Answer. It is hostile, as it seems to me, in the great majority of the southern people. I mean that part of them who were engaged in the rebellion. There is evidently no regret for the rebellion, but rather a defense of it. Question. What great object do they seem to contemplate in their being readmitted to Congress by their senators and representatives? Answer. They seem to suppose that by readmission they can get political power and obtain again the supremacy which they once had, and with the exception of slavery, they expect to be still a prosperous and dominant portion of our government. Slavery they have given up on in the old form, but they want to subdue and keep in a low place the Negroes by some compulsion, which it seems to me they are trying to effect, not only privately, but by all the legislation that I learned of or witnessed. From across the South, the testimony tended in the same direction. To the question, if they could have their way, would the rebel people generally remain in the Union? A tax commissioner answered, No, I think they have a stronger aversion and dislike of the Union than when they seceded. Asked what accounted for this aversion in Mississippi, a major general answered, Their greatest antipathy seems to arise from the fact that the Negro has been employed against them, and that they cannot control them now as they please. The Joint Committee inquired, too, into the delay in the prosecution of Jefferson Davis. It called the Virginia judge presiding over the case, John C. Underwood, a New York-born abolitionist and radical Republican appointed to the bench by Lincoln in 1864. Underwood, in his tenure, would issue a series of rulings protecting equal rights, declaring in one opinion that all distinction of color must be abolished. Despised by white Virginians, he had not been quiet about his views regarding the villainy of Jefferson Davis. He said, for instance, that he intended to sell Davis's Mississippi plantation to ex-slaves for $50 an acre. The committee asked Underwood whether any jury in Virginia would convict Davis of treason. "Not unless it is what is called a packed jury," he answered. The committee then summoned Robert E. Lee, who offered a similar assessment. Question. Suppose the jury should be clearly and plainly instructed by the court that such an act of war upon the United States on the part of Mr. Davis, or any other leading man, constituted in itself the crime of treason under the Constitution of the United States. Would the jury be likely to heed that instruction? And if the facts were plainly in proof before them, convict the offender? Answer. I do not know, sir, what they would do on that question. Question. They do not generally suppose that it was treason against the United States, do they? Answer. I do not think they so consider it. The obstacles to trying Davis for treason only further convinced the committee of the need to disqualify insurrectionists. This measure would go hand in hand with guarantees of equal protection, regardless of race, and with another critical adjustment, reckoning with the consequences of the end of the 3/5 clause. Thaddeus Stevens arrived with a proposed amendment making representation proportionate not to the population of a state, but to the number of eligible voters. As Seward had told Congress, when the Great Amendment was passed, the 13th, unfortunately a clause was not coupled with it adjusting the rule of representation. With the end of slavery, black people now counted toward representation not as 3/5 of a person, but as 5/5, yet they still could not vote. Unless the basis of representation were amended, the Southern states, as they re-entered the Union, would have even greater political power than they had before the war. Stevens's proposal gave these states an incentive to grant the right to vote to black men and women until Roscoe Conkling added the word male to the proposed amendment. Other proposals were more explicit, apportioning representation in the states to exclude from the count Negroes, Indians, Chinese, and all persons not white who are not allowed the elective franchise under their states' constitutions. The proposals on the table sorted into three possibilities. Stevens's amendment barred discrimination on the basis of race, color, or creed, and tied representation to enfranchisement. That is the one I love, Stevens said. That is the one which I hope, before we separate, we shall have educated ourselves up to the idea of adopting, and that we shall have educated ourselves up to the point of ratifying. A second proposal used the eligible electorate to calculate representation, but offered no further obstacle to discrimination. Sumner called this proposal a political obscenity. A third was a version of Bingham's Equal Protection Amendment. Weeks passed as the committee and Congress debated these competing proposals. Meanwhile, Congress passed a civil rights bill containing several of the provisions in the Working Amendment. When Johnson vetoed it, Congress, for the first time in American history, overrode the veto. By April, Stevens had proposed an additional section to an omnibus amendment, Section 3, disenfranchising until 1870 anyone who had taken part in the late insurrection. When Stevens opened the floor for debate on May 8th, he suggested about Section 3 that among the people I believe it will be the most popular of all the provisions, confessing that he himself found it too lenient. Here is the mildest of all punishments ever inflicted on traitors. Section 3 passed the House on May 10th, but in the Senate it was rewritten. On May 23rd, Michigan Senator Jacob Howard said that he should prefer a clause prohibiting all persons who have participated in the rebellion and who were over 25 years of age at the breaking out of the rebellion from all participation in offices, either federal or state, throughout the United States. New Hampshire Senator Daniel Clark proposed limiting the measure to previous oath-takers, that no person shall be a senator or representative in Congress or permitted to hold any office under the government of the United States, who, having previously taken an oath to support the Constitution thereof, shall have voluntarily engaged in any insurrection or rebellion against the United States, or given aid or comfort hereto. Ultimately, the Senate chose to disqualify from federal or state office anyone who had taken an oath to support the Constitution and then participated in an insurrection against it. There followed much discussion of who exactly was to be disqualified. One version specifically stated that the President and Vice President of the late Confederate States of America, so-called, are declared to be forever ineligible to any office under the United States. This was abandoned in favor of more generic language. The 14th Amendment passed the Senate on June 8th and was concurred in by the House 5 days later. Nearly all Republicans voted for it, and nearly all Democrats against. Congress sent the 14th Amendment to the states on June 13th, 1866. It occasioned no celebrations, either in Congress or outside it. It was the product of a grueling political battle, of strenuous and painful compromise, and its ratification was by no means assured. The 14th Amendment was revolutionary, both in its scope and in its complexity. It also lacked Stevens's anti-discrimination language and came without any guarantee of voting rights. Wendell Phillips and some other radical Republicans refused to support it, denouncing it as a mean and cowardly abandonment of the Negro. In Southern states, Section 3 turned out to be particularly contentious. It had been drafted and voted on without their participation. It was humiliating. It was degrading. Southern legislators objected strenuously to Section 3. The Texas legislature decried the amendment as involving the loss of our honor as a people and our self-respect as individual men. The Arkansas legislature complained that Section 3 would lead to the disqualification of many of our best and wisest citizens, and the North Carolina legislature proposed an alternative amendment, omitting Section 3. With the 14th Amendment, said one North Carolinian, Congress wanted Southerners to drink our own piss and eat our own dung. With the exception of Tennessee, every state in the former Confederacy refused to ratify it. The mistrial. The long-delayed trial of Jefferson Davis cast a shadow over the drafting of the 14th Amendment, and its ratification as well. While the states debated the amendment, many in the North expressed gratitude for Section 3. Not having it, Northern newspapers warned, again and again, would render Jefferson Davis eligible to be President of the United States. The trial date for Davis had been set for June 5th, 1866. When the day came and Judge Underwood called the court into session at 2 o'clock, Davis wasn't there. He was still in military prison. The Virginia lawyer appointed to the prosecution, Lucius Chandler, who had neither conducted an investigation nor spoken to any witnesses, stayed home. He said he was sick. Chief Justice Chase spent the day in his library in Washington, where he wrote a letter to his daughter. Outside his window, he could hear a newsboy crying, "Daily Chronicle, full account of something I don't understand what, and trial of Jeff Davis." Davis's lawyer, Charles O'Connor, knowing Chase wouldn't be there, didn't bother to show up either. Chase maintained that he could not possibly attend a civilian court in Virginia because the state was still under military rule. Chase planned to run for president in 1868, and he wanted no part of the trial of Jefferson Davis. The Julius Caesar of ambition had his eye on the election. Underwood rescheduled the Davis trial for the first Tuesday in October 1866. But the Chief Justice had no intention of showing up then either. And over the summer, Speed resigned, unable to work any longer for Johnson. Speed supported the 14th Amendment. Johnson opposed it. In Speed's place, Johnson appointed Henry Stanbury, whose politics aligned with his own. Stanbury had prepared Johnson's veto of the Civil Rights Bill. Republicans, billing themselves as the party of progress, made great gains in the November elections. They took that as a mandate to press forward with the 14th Amendment, despite the South's failure to ratify it. In March 1867, Congress passed a bill introduced by Thaddeus Stevens, the Military Reconstruction Act, once again over Johnson's veto. It called for the occupation of the former Confederacy by the U.S. Army, and stipulated that no state could re-enter the Union without first ratifying the 14th Amendment and rewriting its constitution to include black male suffrage. Military rule would be in effect, John Bingham pledged, only until the people, by a solemn vote at the polls, under the authority of the national law and the protection of the national army, shall have assented to the constitutional amendment and set up a just and republican government. Under what became known as congressional Reconstruction, there would be black voters, black delegates to constitutional conventions, black legislators, and black jurors. So it was that on May 13, 1867, when Jefferson Davis hobbled into that courtroom in Richmond, he was entering a room he knew well. It had been his headquarters, but the people in that room were unfamiliar. Black freedmen sat as spectators. And then the grand jury filed in. 6 of its 18 members were black, the first black men to serve on a federal grand jury. Fields Cook, born a slave, was a Baptist minister. John Oliver, born free, had spent much of his life in Boston. In one of the more extraordinary ironies of American history, one of the jurors sitting in judgment of Jefferson Davis, the first and last president of the Confederate States, was George Lewis Seton, the son of Lucinda, who had been enslaved at Mount Vernon, the plantation home of the first president of the United States. I was a member of the grand jury which indicted Mr. Jefferson Davis. A black grand juror named Cornelius Ligon Harris, a shoemaker, would later write. As Harris took a seat, he eyed Davis. Harris remembered. He looked on me and smiled. Black men had not served as jurors anywhere in the United States before 1860. By the mid-1860s, black newspapers had begun to advocate for this reform. "Why have we no representatives on the jury?" asked the editor of the New Orleans Tribune in 1864. "Are our lives, honor, and liberties to be left in the hands of men who are laboring under the most stubborn and narrow prejudice? Is there any protection or justice for us at their hands?" The issue had come up in Congress in 1866 during the debate over the Civil Rights Bill, which had guaranteed black men the right to testify at criminal trials. This provision was among the reasons Johnson had cited for vetoing the bill, objecting, in a statement prepared by Henry Stanbury, not to what the bill actually did, but to what it might lead to. If Congress can declare by law who shall testify, then Congress by law can also declare who, without regard to color or race, shall have the right to sit as a juror or as a judge, to hold any office, and finally to vote. Meanwhile, widespread violence in the former Confederacy called attention to the problem of all-white juries. In 1865 and 1866, in 500 trials of whites accused of killing blacks in Texas, all white juries found all 500 defendants not guilty. Congress addressed the question more squarely in 1867 regarding a proposed law allowing black men to serve on juries in the District of Columbia. The bill ultimately passed. In 1867, when the military general commanding Texas announced that black men would be allowed on juries, some judges simply refused to hold court. Military Reconstruction had fateful consequences for the trial of Jefferson Davis. Congressional Reconstruction involved treating the former Confederacy as a conquered nation, which allowed for its military occupation and military rule. If Davis were tried and argued that he could not have committed treason because, after Mississippi seceded, he was no longer a U.S. citizen, the government would have to argue that he had always been a U.S. citizen. But if he had been a U.S. citizen during the war, then the Confederacy had not been a foreign belligerent, and the U.S. could not justify its occupation of it as a conquered province. In these circumstances, a handful of radical Republicans became some of Davis's most ardent defenders. Gerrit Smith, a radical abolitionist and member of the Secret Six who had financed John Brown, helped put up bail. "I have ever held that a sufficient reason why we should not punish the conquered South is that the North was quite as responsible as the South for the chief cause of the war," Smith explained. "The mercenary North coolly reckoned the political, commercial, and ecclesiastical profits of slavery, and held to it." And after Thaddeus Stevens's death in August 1868, it came out that Stevens, the fiercest of congressional radicals, had secretly offered to represent the former president of the Confederacy. In Virginia in 1867, Judge Underwood had pledged that Davis would be investigated by a mixed-race grand jury and tried by a mixed-race petty jury. From 1862, jurors, like federal officers, were required to take the ironclad oath, in effect a precursor to the 14th Amendment's disqualification clause, swearing that they had never in any way aided persons engaged in armed hostility with the United States, which meant that former Confederates were excluded. Some Northerners approved. The trial of Jefferson Davis for leading the rebellion in behalf of slavery should be before a jury made up in part of freedmen, if only for the historic justice, not to say the dramatic beauty and harmony of such a denouement, the New York Tribune wrote. Predictably, Southern newspapers expressed disgust at the 3 Negroes supposed to be the African quota of the grand jury, describing these men, swearing an oath on the Bible, as having smacked their lips over the sacred volume when permitted to get at it. A Richmond observer referred to the Davis grand jury as Underwood's packed jury of ferrets and Yankees. But the idea of black men convicting a white man to hang had elicited outrage in both the North and the South. An editorial published in both New York and Virginia asked, "If Davis is to stand before a nigger jury, what becomes of the notion that a man is to be tried before a jury of his peers?" When Davis walked into the federal courthouse in Richmond on May 13, 1867, eyed the grand jury and smiled. He had reason to. Days before, Lucius Chandler had traveled to Washington to confer with Evarts and Stanbury, where the new Attorney General had explained that not only did he not intend to lead the prosecution, he did not intend to attend the trial. The 3 men decided not to object to O'Connor's request that Davis be released on bail. The prosecution seemed to be abandoning the case. There were plenty of reasons and plenty of problems with the prosecution, but the point at which the prosecution truly fell apart was exactly when Underwood impaneled black jurors. The jurors seated, Underwood addressed the courtroom. In the very rooms we now occupy dwelt the fiery soul of treason, rebellion, and civil war, he said. But the jury itself furnished ocular evidence that the age of caste and class cruelty has departed, and a new era of justice and equality was dawning. Underwood warned jurors that they would likely face threats and even violence, especially in Richmond, given that this city has long been the center and seat of the greatest traffic in human beings that has ever disgraced the world. They were heated remarks. Critics deemed him as unfit to sit on the bench. The prosecution stating that it was not prepared for trial, Underwood agreed to release Davis on bail. "The business is finished," O'Connor wrote to his wife. "Mr. Davis will never be called upon to appear for trial." A new trial date was set for November 25, 1867. No one expected the prosecution to be ready. 2 years after Davis's arrest, Chandler had still conducted no investigation, nor prepared a superseding indictment. Quite why is hard to say. Even incompetence and inexperience seem hardly to cover it. Underwood told Speed that he believed Chandler was a Confederate sympathizer who was making money by selling pardons. Underwood called a petty jury. O'Connor wrote to Davis, "Chandler professes the kindest disposition and says he will try to get a white jury. But this is impossible. Underwood is a devoted courtier at the feet of Sambo, and there is no appeal from his decisions. The jury," O'Connor warned, "will be composed of 8 or 9 Negroes and 3 or 4 of the meanest whites who can be found in Richmond." O'Connor very much doubted the trial would ever take place. "I find it impossible to believe we are destined to play parts in a farce so contemptible as a trial before Underwood and a set of recently emancipated Negroes," he wrote to Verena Davis. "But it is equally impossible to assert with confidence that the thing will not happen." And the thing did not happen. On the day the trial was to begin, a crowd assembled at the train station in Richmond to wait for the train from Washington. The colored population seemed to take a deep interest in the proceedings and were on hand en masse, a correspondent for the New York Times reported. The train pulled up. "Has Mr. Chase come?" came the cry. Mr. Chase had not. At the courthouse, a marshal announced that the court was adjourned. It was one of the sorriest moments of the whole sorry history of the failed prosecution. A newspaper reported that there had been a tremendous crowd outside the courthouse, consisting chiefly of blacks. But when the marshal made the announcement, the crowd quietly dispersed. As to history, Republicans in Congress sought to continue the work of amendment. Having failed to include suffrage in the 14th Amendment, they wanted to provide for it in a 15th Amendment. But they had more on their docket, and not much time to do it before the November elections. In February 1868, the House impeached President Johnson after investigating him for, among other things, intentionally derailing the Davis prosecution. Francis Lieber favored impeachment, not least for the precedent it would establish. As to history, it will be a wonderful thing to have the ruler over a large country removed for the first time without revolution. The same reticence that derailed the Davis prosecution derailed the Johnson impeachment. Did this not look like vengeance rather than justice? In any event, the Johnson impeachment trial grossly interfered with the Davis treason trial. At the Senate impeachment trial, Chase presided as Chief Justice, and Evarts led Johnson's defense, joined by Stanbury, who resigned his position as Attorney General, which led to yet more postponements of the Davis trial, from March to May, from May to June, from June to November. The 14th Amendment was ratified in July. Chandler's term as district attorney having expired in June, Evarts recruited Boston lawyer Richard Henry Dana to join the prosecution. Dana worked hard to prepare for trial. In a Richmond hotel, he and Evarts drafted a new 14-count indictment based on the testimony of multiple witnesses, including Robert E. Lee, who had testified against Davis before the grand jury. Evarts wrote a parody of Chandler's earlier single-count indictment. I have arrived at the fact that J.D. used to wear a Confederate uniform on great occasions and have a witness who can prove it in the person of a colored waiter who came to me last evening. But Dana reluctantly came to the conclusion that the trial ought not to proceed. For plenty of reasonable people, the urgent matter seemed to be to disqualify Davis from ever again holding public office. Sending him back to prison, or God knows, hanging him, could have been almost as bad for the country as acquitting him. Dana drafted a letter of resignation addressed to Johnson and sent it to Evarts, who pocketed it, unsure what to do. By the time Chase and Underwood finally sat in court together in Richmond in December 1868, Chase had quietly suggested to the defense a new line of argument, which O'Connor happily deployed. O'Connor claimed that Davis could no longer be prosecuted for treason because, having been disqualified for office upon the amendment's ratification, it needs no legislation by Congress to give it effect, the defense said. He had already been punished. Dana argued that the Constitution was not a criminal code and that being disqualified for office was not a penalty. Chase agreed with O'Connor. Underwood agreed with Dana. The case would have gone to the Supreme Court. On December 7th, after Ulysses S. Grant, a military hero and Illinois Republican, won the presidency, the lame duck 40th Congress passed the 15th Amendment over the objections of Democrats. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. It would be the last of the Civil War amendments. On Christmas Day, the lame duck president, Andrew Johnson, pardoned every person who directly or indirectly participated in the late insurrection or rebellion. Not long afterward, the prosecution entered a nolle prosequi. The trial of Jefferson Davis was over, and the constitutional door that the war had opened was closed. Next, we want the jury box. The city of Baltimore held a jubilant Mammoth parade in May 1870 to celebrate the ratification of the 15th Amendment. Maryland's governor had opposed ratification, and so had the state's legislature. Maryland had voted against the amendment in February. But the necessary bar of 28 states had been reached later that month all the same, and Black Baltimoreans decided to hold a celebration to beat all others. Maryland would not ratify the 15th Amendment for more than a century, finally voting for it in 1973. 20,000 spectators came to the city to watch a parade so long its passage, syncopated by marching bands and a troupe of zouave drummers, lasted 5 hours. It moved from Broadway up Orchard Street, known as the Black Fifth Avenue, up Washington Boulevard, through the Mount Vernon neighborhood, and ended in Monument Square. Black families traveled for miles from Philadelphia and Washington, from New York and Richmond, to attend this largest celebration in the country. Black Union soldiers marched in uniform. Frederick Douglass, Maryland's most celebrated son, climbed to a stage erected in Monument Square to deliver a rousing address before a rapturous crowd. Black men had gotten the ballot box, Douglass said, and next we want the jury box. The abandonment of Reconstruction and of the Reconstruction amendments that Black Americans celebrated in Baltimore on that dazzling day in May 1870 began even before Reconstruction itself was underway. The abandonment of the promise of Reconstruction started with the failure to prosecute Jefferson Davis. Aside from Davis's single appearance in a courtroom in Richmond in May 1867, the ex-president of the Confederacy never appeared in a courtroom to defend himself against the charge of treason. Instead, for Confederates, the United States offered amnesty. Amnesty is a kind of charity. It is not usually given with malice toward none. More than 6 years having elapsed since the last hostile gun was fired between the armies then arrayed against each other, Ulysses S. Grant told Congress in 1871, it may well be considered whether it is not now time that the disabilities imposed by the 14th Amendment should be removed. Over the objections of the first Black members of Congress, including Robert Elliott of South Carolina, Congress voted for a general amnesty. In the Senate, Sumner tried to attach civil rights provisions to that bill, on the ground that both measures involved the removal of disabilities and the guarantee of equal rights. Now that it is proposed that we should be generous to those who were engaged in the rebellion, Sumner said, I insist upon justice to the colored race everywhere throughout this land. Or, as another Black congressman, Joseph Rainey, put it about ex-Confederates, we are willing to accord them their enfranchisement, and here today give our votes that they may be amnestied. But there is another class of citizens in this country who have certain dear rights and immunities, which they would like you, sirs, to remember and respect. Sumner and Rainey did not prevail. The amnesty bill passed, but there would be no new civil rights bill until 1875, and 8 years later the Supreme Court would declare it unconstitutional. Salmon P. Chase ran for president in 1868 and 1872, and lost. Francis Lieber died in 1872, Chase and Underwood in 1873, and Sumner in 1874. Underwood's close friend, Harriet Beecher Stowe, wrote his obituary. The Supreme Court would fail to enforce the 14th Amendment, and Congress would abandon Reconstruction. In 1876, Lucius Chandler put stones in his pockets and drowned himself. Jefferson Davis, who presented himself during his only day in court in 1867 as being at death's door, lived for many years more. He died of a cold in 1889 at the age of 81. In the decades after the abandonment of Reconstruction, the fight to realize the promise of the Reconstruction amendments would move from Congress to the courts. Frederick Douglass wanted that jury box, and he wanted judgeships, too. But it would be more than a century before a Black man would take a seat on the Supreme Court when Lyndon Johnson nominated Thurgood Marshall, another Marylander, in 1967. Looking back, the 1860s and 1870s appear to have been as much a tragedy as a triumph. The story of 3 amendments that passed and yet somehow failed, too. Even the trial of Jefferson Davis was a chance for a kind of justice that never came. But for the trial of the former president of the Confederacy that never took place, 24 men had been assembled as a jury pool. 12 of them were black. So momentous was the occasion of a mixed-race jury, here to weigh in not only on Davis's guilt or innocence, but in effect on the very meaning of the Constitution, that the 24 men had sat for photographer, 12 white men, 12 black men, posed cheek by jowl, hands on one another's shoulders, the picture of a promise. Joseph Cox was a blacksmith who, like his fellow juror, Lewis Lindsay, had been elected in October as a delegate to Virginia's 1867 Constitutional Convention. At that convention, where Underwood was elected president, Lindsay proposed a disqualification clause barring former supporters of the Confederacy from holding office. That part of the new Constitution was never ratified. John B. Miller, born free, worked as a barber. He was later elected to the Virginia House of Delegates. Albert Brooks, born into slavery in 1817, had bought his freedom for $1,100, and in 1862 had bought his wife, Lucy Good, their 3 youngest children, and the increase in the future of the females for $800. Lucy Good Brooks had a cameo made, a silhouette of her husband, taken from that photograph of him as a juror called to determine whether Jefferson Davis had committed treason against the United States. She wore it for the rest of her life. Chapter 6. No amendment is necessary. The right of suffrage in the United States shall be based upon citizenship and shall be regulated by Congress, and all citizens of the United States, whether native or naturalized, shall enjoy this right equally, without any distinction or discrimination whatever founded on race, color, or sex. Failed amendment to the U.S. Constitution, introduced into the House, 1868. At 10 in the morning on January 11, 1871, Victoria Woodhull, 33, appeared before the House Judiciary Committee, the first American woman to formally address a congressional committee. The committeemen sat on one side of the room, Woodhull and an ardent train of feminine adherents, as the New York Tribune put it, on the other. John Bingham, chair of the committee and a principal author of the 14th Amendment, took his seat at the head of the table. Susan B. Anthony, wearing a black velvet gown, was seated alongside other leading female suffragists. They were in the city for a women's rights convention and had come to hear Woodhull, who had upended the female suffrage movement by calling for the abandonment of its long struggle in favor of simply declaring victory. Woodhull spoke quietly, reading a petition she had earlier submitted to the House and Senate, in which she argued that women already had the right to vote and needed only to seize it by convincing Congress to pass enabling legislation to put into execution the rights vested by the Constitution in the citizens of the United States to vote without regard to sex. No constitutional amendment was necessary. Woodhull was dazzling, an iconoclast, a rebel. She was not, however, the first to take this position. Black freedwomen in the South had attempted to vote in 1870. Their rebellion had not gone unpunished, and neither would Woodhull's. And yet, however ingenious, her declaration was utterly out of place with the spirit of amendment of the post-war decades, in which revising the Constitution became the subject of ceaseless moral crusades, amendment as salvation. Abolition had begun as a moral crusade, and so had suffrage, and temperance, and vegetarianism, and peace. Most women came to the cause of women's rights by way of other causes. Frances Ellen Watkins Harper, born free in Maryland in 1825, had been a lecturer for the Anti-Slavery Society for years before she took up the cause of female suffrage. Susan B. Anthony became a suffragist after she was told she was not allowed to speak at a temperance convention in 1852. Well before the Civil War, the moral crusade had become a well-established political form, nothing less than the reigning female political tradition, the chief means by which middle-class white women especially sought to drive legal, social, political, and constitutional change. The Crusaders' tools were the petition, the convention, the pledge, and the pamphlet. Party politics, elections, court cases, appearances before congressional committees, these were the tools of the powerful, not the powerless. The avenue of federal constitutional amendment had been closed for decades. Now that it was open, Crusaders pleaded with Congress to change the Constitution by petition. Woodhull's style was altogether different, bolder, more direct, more confrontational. It was something closer to a litigation strategy, like filing a series of lawsuits with the aim of bringing a case to the Supreme Court, seeking constitutional change by arguing for your own interpretation of the Constitution. Original intent be damned. The original intent of the framers, after all, had been to deem women to be something other than persons. Woodhull launched her amend at will approach at a pivotal moment in the history of the campaign for female suffrage. In 1865, as the 39th Congress opened and began considering possible amendments, Elizabeth Cady Stanton recommended that when the constitutional door is open, women ought to avail ourselves of the strong arm and blue uniform of the black soldier to walk in by his side. As Congress began to tinker with the language of what would become the 14th Amendment, Stanton warned that if that word male be inserted into the Constitution, it will take us a century at least to get it out again. It had, after all, taken a half-century for people like John Jones to get the word white out of state constitutions after it was inserted beginning in the 1810s. Early in 1866, Stanton and Anthony, relying on their experience petitioning Congress to pass the 13th Amendment, organized a massive petition campaign for the new amendment to grant women the right to vote too, as part of what Anthony described as the new order of things. Unfortunately, the petitions backfired. Before the petition campaign began, the word male hadn't much appeared in drafts and discussions. Only after the women's rights petitions drew attention to the absence of the word and to the fact that women considered themselves to be eligible to vote was the word routinely included. Sumner later professed that he tried his best and wrote over 19 pages of foolscap to get rid of the word male and yet keep Negro suffrage intact, but it could not be done. And the battle itself divided the suffrage movement. In 1866, Frances Watkins Harper electrified the National Women's Rights Convention. "You white women here speak of rights," she said from the podium. "I speak of wrongs." Inspired by Harper, suffragists and abolitionists had formed the American Equal Rights Association, with Lucretia Mott as president, and with the aim of securing equal rights to all American citizens, especially the right of suffrage, irrespective of race, color, or sex. Under its aegis, suffragists, who had also long been abolitionists, fought for both the 13th and 14th Amendments. But by the time Congress sent the 15th Amendment to the states, it was clear that the framers of both amendments had set aside the cause of women's rights to guarantee equal protection and the franchise regardless of race, a decision that would splinter the women's suffrage movement. After Section 2 of the 14th Amendment, the apportionment clause, introduced the word male into the Constitution, suffragists hoped that the 15th Amendment would declare that the right of citizens of the United States to vote shall not be denied or abridged by the United States by any state on account of race, color, sex, or previous condition of servitude, but no version specifying sex passed either the House or the Senate. This failed, too. Instead, the suffrage movement divided in 1869 at the third annual meeting of the American Equal Rights Association over some suffragists' insistence that they would not support the 15th Amendment unless it guaranteed women the right to vote. Frederick Douglass rose to speak against this position. "I do not see how anyone can pretend that there is the same urgency in giving the ballot to woman as to the Negro," he said. "When women, because they are women, are hunted down through the cities of New York and New Orleans, when they are in danger of having their homes burnt down over their heads, when their children are not allowed to enter schools, then they will have an urgency to obtain the ballot equal to our own." Susan B. Anthony rebutted him, betraying her belief that educated white women were more deserving of the vote than uneducated black men. "Let the question of women be brought up first," and that of the Negro last, Anthony said. Mr. Douglas talks about the wrongs of the Negro, but with all the outrages that he today suffers, he would not exchange his sex and take the place of Elizabeth Cady Stanton. The rift was impossible to repair. The suffrage movement fractured into two organizations. The American Woman Suffrage Association, led by Frances Watkins Harper and Lucy Stone, would fight for passage and ratification of the 15th Amendment as urgently necessary, with the idea that female suffrage would follow state by state. The National Woman Suffrage Association, headed by Susan B. Anthony and Elizabeth Cady Stanton, put suffrage for white women above all other causes, and, arguing against the 15th Amendment, sought support for their position by demeaning black men and immigrants from Ireland, Germany, and China. Patrick and Sambo and Hans and Young Tung, who do not know the difference between a monarchy and a republic, who never read the Declaration of Independence or Webster's spelling book, wrote Stanton, who believed they ought not to be making laws for Lucretia Mott. 2 weeks after the passage of the 15th Amendment, Indiana Congressman George Julian introduced a proposed 16th Amendment at their urging, declaring suffrage to be based on citizenship without distinction of sex. Woodhull attended a suffrage meeting but found it too timid for her taste. The splintered suffrage organizations scheduled a meeting for a possible reunion under a new Equal Rights Association for April 6, 1870, but 4 days before the meeting, Woodhull published an announcement in the New York Herald. As I happen to be the most prominent representative of the only unrepresented class in the Republic, and perhaps the most practical exponent of the principles of equality, I request the favor of being permitted to address the public, she began. She touted her accomplishments. She had founded a stock brokerage in New York and become independently wealthy. While others of my sex devoted themselves to a crusade against the laws that shackle the women of the country, I asserted my individual independence. While others prayed for the good time coming, I worked for it. While others argued the equality of woman with man, I proved it by successfully engaging in business. While others sought to show that there was no valid reason why women should be treated socially and politically as being inferior to men, I boldly entered the arena of politics and business and exercised the rights I already possessed. Americans were living through revolutionary times in which much that had only recently seemed impossible had become very possible. The blacks were cattle in 1860. A Negro now sits in Jeff Davis's seat in the United States Senate. Woodhull then dropped a bombshell. I now announce myself as a candidate for the presidency. As Woodhull began her campaign for the presidency, suffragists were pressing for a 16th Amendment guaranteeing women the right to vote. Woodhull's declaration at first advanced that cause. In an editorial about Woodhull's presidential bid, the Herald celebrated the clearing of the track for the 16th as many other amendments as may be deemed necessary. That May, Woodhull and her sister, Tennessee Claflin, started their own newspaper, Woodhull and Claflin's Weekly, with the motto, Upward and Onward, and a regular column called 16th Amendment. But in the fall of 1870, when she moved from New York to Washington to advance her presidential campaign, she changed her mind about the 16th Amendment, which was still stalled in the House Judiciary Committee. On November 19th, she wrote in Woodhull and Claflin's Weekly that it was a dead letter. I do now proclaim to the women of the United States that they are enfranchised. She began planning a political strategy, fixing the Constitution without amending it and without asking for the aid of the Supreme Court. A Republican form of government. The woman suffrage campaign met with striking rejection, time after time. Woodhull stepped into the movement and anointed herself its vanguard, just at the moment when the federal government had assumed broad new powers relative to the states. Woodhull could not have foreseen in 1870 that no further amendment to the federal Constitution would pass for 43 years. Not until 1913 would Congress pass the 16th Amendment, and it would have nothing to do with women's rights. As had been true during the last amendment drought in the 61-year stretch between the 12th Amendment in 1804 and the 13th in 1865, the years between the 15th in 1870 and the 16th in 1913 would be marked by an extraordinarily activist and conservative Supreme Court. Constitutional change came in these years, but it came from the bench, on which 9 men sat, resolute. Yet, as had also been true in that earlier interregnum, constitutional change happened in these years in the states, where what did or did not belong in a constitution and how far one could be amended was the subject of heated and sustained debate. Much of it involved continued and even widening resentment of the federal government, not just from the former states of the Confederacy, but from the newer states of the West. In the first place, Congress required the rebel states to rewrite their constitutions, and as it did for new states entering the Union, it very often demanded certain provisions and revisions. Between 1864 and 1866, all 11 states of the Confederacy held all-white constitutional conventions. Congress rejected 10 of their proposed constitutions. A delegate at Mississippi's 1865 convention complained about what he considered constitutional coercion. This is no convention and does not represent the people, but rather the President of the United States or the federal government, he fumed, damning the idea of amendment by force and bayonets that would produce only a bastard convention. Congress made demands and, within its powers, enforced them. In 1866, the Joint Committee on Reconstruction proclaimed that no portion of the people of this country, whether in state or territory, have the right, while remaining on its soil, to withdraw from or reject the authority of the United States. Jefferson Davis had hoped to argue against this proposition at his trial, but never had the chance. It required that any new state constitution acknowledge that there existed no right to secede. Congress also required that states entering or re-entering the Union adopt constitutions that guaranteed a Republican form of government. The 14th Amendment's apportionment clause punished states that denied the right to vote to any male inhabitants, which was illegal under the 15th Amendment after 1870, by reducing their representation in Congress. In 1866, Congress rejected Nebraska's proposed constitution, which limited the franchise to white citizens and white persons of foreign birth who shall have declared their intention to become citizens. In 1868, when Arkansas sought to re-enter the Union, Congress required that its new constitution shall never be so amended or changed as to deprive any citizen or class of citizens of the United States of the right to vote who are entitled to vote by the Constitution herein recognized. It imposed these same conditions on other states of the former Confederacy. Under the 1867 Military Reconstruction Act, Congress also decreed that rebel states seeking to re-enter the Union had to ratify the 14th Amendment and proclaim the supremacy of the federal government. South Carolina's 1868 Constitution, for instance, provided that every citizen of this state owes paramount allegiance to the Constitution and government of the United States, and no law or ordinance of this state, in contravention or subversion thereof, can have any binding force. In a speech at the convention's conclusion, the president of the convention proclaimed that we have obliterated from our political system that most pernicious heresy of state sovereignty, a heresy which, for nearly half a century, taught by our leaders, had, like Ignis Fatuus, led the people of South Carolina on more than one occasion to the brink of rebellion. Delegates to Mississippi's 1868 convention resolved that the state's ordinance of secession was based upon an unfounded assumption of state sovereignty and a perverted theory of state rights, and brought about in the interest of slavery, and they denounced the doctrines of state rights and state sovereignty, interpreted as they have been into a justification of secession, as utterly subversive of our form of government and tending to confusion, anarchy, and national destruction. All the new states entering the Union after 1870 were required to include a federal supremacy clause as well. On the ground, federal supremacy was purely notional, in the face of the vigilantism of the Southern white supremacist organizations, including the newly formed Ku Klux Klan, whose members attacked black schools, black churches, black businesses, black newspaper offices, black women and children, and above all, black men who tried to vote. In Pulaski, Tennessee, in 1868, more than 2,000 black men were registered to vote, but fewer than 700 managed to cast a ballot. So great and so widespread was the violence that in 1870 the Grant administration established the Department of Justice, whose initial remit was to investigate and prosecute the Klan. The most remarkable change of all was a fleeting one. For the first time, black men served as delegates to state constitutional conventions. And here what they undertook to do is exceedingly interesting. They often sought to diminish the state's power of amendment. All white state constitutional conventions held between 1820 and 1860, the very conventions that had introduced the word white into state constitutions, had generally made both making amendments and holding future conventions easier. The Reconstruction-era so-called black state conventions, which removed the word white from state constitutions, made both amending and convening more difficult. Most new state constitutions qualified the people's right to alter or abolish them, changing it to a much softer and not to be seen as endorsing secession right to alter or reform. 4 states, Georgia, Texas, Louisiana, and Mississippi, eliminated the right entirely. Other states made it harder to call a state constitutional convention, and Louisiana and Florida made no provision at all for future conventions. Adding these obstacles to constitutional revision was accomplished in sizable measure by black men. Having watched state constitutional conventions chisel away at their rights for decades, black men serving as delegates at state conventions sought not only to codify their rights, but, before adjourning, to make those rights provisions unalterable. "We have been cheated out of our rights for 2 centuries, said black delegate Francis Cardozo at South Carolina's 1868 convention. "And now that we have the opportunity, I want to fix them in the Constitution in such a way that no lawyer, however cunning or astute, can possibly misinterpret the meaning." By the beginning of 1869, black men were guaranteed the right to vote in 17 states, where the word white was deleted, but barred from voting in 17 others, where voting requirements still included the word white. The purpose of the 15th Amendment had been to overturn these restrictions and to bar any future restrictions as violations of the Constitution. That the black community in Baltimore celebrated its ratification with a fabulous parade in a state that had rejected the amendment did not augur well for its enforcement. In the Supreme Court, the Constitution would remain white. The word male. The 15th Amendment is what legal scholars call doctrinally undeveloped, though this is something of an understatement. Like the 14th Amendment, the 15th Amendment was barely enforced. Efforts were made to repeal it, but by the 1880s, this was hardly necessary, since white Southerners had found ways, far short of repeal, to nullify it. It became in many parts of the country a dead letter. Neither Congress nor the court explored its implications or derived a doctrine from its underlying principles to use for broader application. Woodhull attempted to develop a 15th Amendment doctrine. Her argument began with the logic of the amendment itself. Where suffragists had despaired at the inclusion of the word male in the 14th Amendment and the absence of the word sex in the 15th, Woodhull declared that none of this mattered. With the right to vote, sex has nothing to do, she liked to say. The Constitution makes no distinction of sex. The 15th Amendment, she reminded Congress, says that the right of citizens of the United States to vote shall not be abridged on account of race, color, or previous condition of servitude. Here she made 2 claims. First, a race of people comprises all the people, male and female, and therefore all people included in the term race have the right to vote. And second, women, white and black, were covered under the language of previous condition of servitude, since they had, from time immemorial, groaned under the burdens of their enforced service to men. As she asked in another speech, if freedom consists in having an actual share in appointing those who frame the laws, are not the women of this country in absolute bondage, and can government, in the face of the 15th Amendment, assume to deny them the right to vote, being in this condition of servitude? Woodhull introduced these arguments in a memorial she published in December 1870. She repeated them in her testimony before the House Judiciary Committee on January 11, 1871, at a meeting timed to coincide with a suffrage convention to be held in Washington the next day. She appeared in the Capitol at 10 in the morning. At 3 that afternoon, she spoke at Lincoln Hall to an audience of suffragists in town for their convention. Then she went to meet with President Grant. Even the vehemently anti-suffrage New York Tribune conceded, all the past efforts of Miss Anthony and Mrs. Stanton sink to insignificance beside the ingenious lobbying of the new leader and her daring declaration. At the end of the month, the Judiciary Committee released a report. John Bingham, writing for the majority, conceded much of Woodhull's argument, but insisted that Congress lacked the authority to issue the declaratory act urged by Woodhull, and tabled the petition. The minority report was written by William Logridge and Benjamin Butler. Logridge and Butler argued for accepting Woodhull's contention and issuing the requested declaration, in the spirit of the age, a spirit of innovation and progress. The 14th Amendment had for the first time defined a citizen, and its birthright citizenship clause declared everyone born in the United States to be a citizen. Logridge and Butler, drawing on decades of black abolitionist agitation, argued that from the very nature of our government, the right of suffrage is a fundamental right of citizenship. Woodhull had not expected to prevail immediately, and her argument had gotten exactly the serious hearing that she'd sought. She continued the campaign, delivering a lecture on constitutional equality to a sold-out Lincoln Hall 2 weeks later. Women did not join in the act of constructing the Constitution, Woodhull began. I and others of my sex find ourselves controlled by a form of government in the inauguration of which we had no voice, and in whose administration we are denied the right to participate. Under what logic were women expected to abide by the Constitution if they were to remain disenfranchised and ineligible for office? She called in her audience to rally for change by seizing it. The government is an embodiment of the people, and as they change, so also must it change. In this significant fact lie all the true beauty and wisdom of our form of polity. It can be changed without actual revolution, and consequently possesses the inherent qualities of permanency. The 14th and 15th Amendments were sufficient, no more amendment was needed, but Congress did need to act with enabling legislation. She'd had it with petitions and pleadings and moral persuasion. If Congress refused to listen and grant what women ask, there is but one course left them to pursue. Were a year to pass without congressional action, she warned, women would hold their own constitutional convention to frame a new constitution and to erect a new government, complete in all its parts, and to take measures to maintain it as effectually as men do theirs. Was she serious? Yes, she insisted. We mean treason. We mean secession, and on 1,000 times grander scale than was that of the South. We are plotting revolution. We will overslough this bogus republic and plant a government of righteousness in its stead, which shall not only profess to derive its power from the consent of the governed, but shall do so in reality. And then began her downfall. Where the Liberal League advocated for separation of church and state, free speech, a free press, and freedom of thought, and often called themselves free thinkers, most stopped short of advocating for free love. Woodhull, though, not least by way of the Victoria League that she founded, did advocate for free love, by which she meant that she approved of divorce and of sex before marriage. Yes, I am a free lover, she said, answering a heckler. I have an inalienable, constitutional, and natural right to love whom I may. Other suffragists used the language of self-sovereignty to describe what would later come to be called reproductive rights. Wrote Stanton in 1871, "Woman must at all times be the sovereign of her own person." At the time she was running for president, Woodhull was also caring for her ex-husband, who was dying. He lived in the same house as she and her husband. Moralists attacked her as a libertine and a prostitute. She tried to defend herself by pointing out that their attacks on her domestic arrangements were evidence of her opponent's desperation. Women's suffrage and women's rights being the issue and there being no defense, she wrote in 1871, I am taken as the representative woman, and my personal character being maligned and deprecated, the cause suffers. On November 7, 1871, Election Day, Woodhull and 11 other women from New York tried to vote at the polls at 682 6th Avenue. When poll workers refused to accept their ballots, Woodhull took a copy of the Constitution out of her pocket and delivered an impromptu lecture. Given the ongoing attacks on her character, she failed to win any meaningful support for her presidential bid, which had always been as much a stunt as a campaign. Even her support among suffragists began to flag. Stanton still supported her, but Anthony abandoned her. In May 1872, at the annual suffrage convention held in New York, Stanton, in a keynote address, urged women to follow Woodhull's lead and attempt to vote in November. She also supported Woodhull's call for a new political party, the Equal Rights Party, under whose banner Woodhull sought the presidency. Anthony, who had contrived to get herself elected president of the convention, offered no such endorsement. When Woodhull got up to address the convention, she called for the meeting to adjourn to another hall where it would convene as a nomination convention. The motion was not out of order, but Anthony refused to allow a vote on it. Woodhull persisted. She simply called for a vote herself. Anthony then declared the vote out of order, an announcement that was met with mayhem. When Woodhull seized the podium, Anthony found a custodian and got him to turn off the lights. The Equal Rights Party did hold its presidential nominating convention the next day with 668 delegates. They nominated Woodhull for president, chanting, "Victoria, Victoria," and in absentia, and without his knowledge, Frederick Douglass as vice president. Douglass kept well out of the dispute among suffragists. Abandoned by suffragists and wounded at being maligned as lascivious, devious, and worse, one newspaper dubbed her Mrs. Satan, Woodhull decided to exact vengeance on the moralists. In the November 2, 1872 issue of Woodhull and Claflin's Weekly, on newsstands on October 28th, Woodhull published a blistering attack on Henry Ward Beecher, who, as was widely known in certain circles, had been carrying on an adulterous affair with a married woman for years. Within hours, Woodhull was arrested for obscenity under the terms of a state law, an early instance of a series of draconian moral codes that would soon be passed by Congress and championed by anti-vice zealot and newly installed U.S. Postal Inspector Anthony Comstock. Comstock himself had arranged for Woodhull's arrest. Using an alias, he had requested a copy of the issue by mail so that he could report the violation. She spent Election Day in Ludlow Jail. 5 years later, she left the country. The Amendmentists. The radicalism of Woodhull's approach to constitutional change can truly be seen only by comparing her declaration that the Constitution did not need amending with pleas for amendments in the 1870s and 80s, when the 3 amendments ratified between 1865 and 1870 elicited a flurry of calls for more. This has been true with every surge of successful amendments. Each produced a sense that the Constitution was ripe for still more change, driving public interest in the possibility of constitutional revision. Before Woodhull announced that a constitutional amendment wasn't necessary for women to gain the right to vote, suffragists pushed for a 16th Amendment, but so did many other Americans, especially moral crusaders. Their preferred 16th Amendments would introduce God into the Constitution, prohibit the sale of alcohol, and ban polygamy. Proposals to express devotion to God or to Christ had been among the first amendments ever urged. In 1789, Benjamin Rush had written to John Adams, suggesting that this omission might be repaired. Perhaps acknowledgment might be made of his goodness or of his providence in the proposed amendments. None had ever earned either substantial national support or consideration. To the contrary, much deeper support existed for the religious toleration and opposition to the state establishment of religion that were adopted in 1789 as part of the First Amendment. In the 1870s, such proposals came back into view, as they would periodically over the next century and a half, but they were generally expressions of religious schisms as much as anything else. Derided as the amendmentists, religious leaders very often proposed amendments that were at odds with one another, especially as they took up positions on either side of charged questions about the relationship between church and state. Evangelical, conservative Protestants advocated the recognition of God in the Constitution. Liberal and more secular Protestants both opposed such a recognition and advocated the end of Bible instruction in public schools. A synod of Protestants, meeting in 1861, launched a petition campaign to introduce God into the Constitution. They believed that because the nation had not been founded as a Christian nation, the Civil War had been God's punishment. They regretted that the name of God is not found in our national constitution, nor does it contain a distinct recognition of his authority or existence. For this omission, the nation had been punished. As Felix R. Bruneau, who served as head of Grant's Board of Indian Commissioners, noted, the Confederate Constitution did thank God. Its preamble invoked the favor and guidance of Almighty God, which he believed had stood its army well in battles. The Union movement to call for a constitutional amendment to recognize the Christian religion began at a convention in Xenia, Ohio, in February 1863, just weeks after the Emancipation Proclamation. As one evangelical reported, the Civil War in which the nation was then engaged was almost universally felt to be an expression of the divine displeasure against the nation. Reformers cited slavery and the lack of an acknowledgement of divine providence as the two defects in our otherwise inimitable Constitution. The Emancipation Proclamation remedied the first, but the second, the crowning original sin of the nation, the failure to acknowledge God, required an amendment. In 1864, reformers founded the National Association to secure the religious amendment to the Constitution of the United States. With the backing of the inimitable Massachusetts Senator Charles Sumner, leaders of the association met twice with Lincoln and claimed that he said, "You got one of the things you asked for in my first administration, the emancipation of the slaves, and I hope you'll get the second in my second administration." That second thing was an insertion into the preamble to read, "We, the people of the United States, recognizing the being and attributes of Almighty God, the divine authority of the Holy Scriptures, the law of God as the paramount rule, and Jesus, the Messiah, the Savior, and Lord of all, in order to form a more perfect union." Sumner withdrew his support for the movement after meeting with Meyer S. Isaacs, secretary of a Jewish civil rights organization called the Board of Delegates of American Israelites. Isaacs called the amendment the work of zealots and fanatics, and warned Sumner that he appeared to be backing the establishment of Christianity as a national religion. Sumner assured Isaacs that the amendment had no chance of passing, and in any case he didn't actually support it. "I have said that I should not object to a recognition of God by formal words in the Constitution," Sumner protested. "That is all. I take it no Hebrew would differ with me on that point." The National Association to secure the religious amendment to the Constitution met in conventions and organized petition drives. Beginning in 1868, the offices of the Christian Statesman offered petition forms to be filled out by readers and mailed to Washington. "Stacks of petitions, almost a mountain high, must be in the rooms of that committee," said one senator in 1871 about the Judiciary Committee. Between 1864 and 1900, religious reformers submitted nearly 800 petitions to Congress requesting such an acknowledgement in one form or another. Most were signed by hundreds of people, and some by thousands. The overwhelming majority came from the Midwest and upstate New York, the parts of the country that had been most affected by the Second Great Awakening. "Our nation is Christian. The Constitution is unchristian," lamented Bruneau in 1874. But if the national sin of neglecting to mention divine providence in the Constitution was the reformers' stated motive, the movement was animated by other causes of concern, too, including Darwinism and the rising number of immigrants who were not Protestants, especially Catholics and Jews. Evangelicals of the Second Great Awakening despaired at the growth of secularism over the course of the 19th century. And, after the 14th Amendment's incorporation of the Bill of Rights to the states, at the disestablishment of religion guaranteed by the First Amendment. Sunday laws and blasphemy laws had been overturned, and Bible instruction in schools had been banned. Petitions calling for a new constitutional amendment grew, ranging from an amendment to more fully recognize the obligations of the Christian religion, 1864, to one recognizing Jesus Christ as the supreme ruler of nations, 1867. None earned significant support in Congress. After the war, the reformers' attention moved to religious instruction. In 1869, in an attempt to lure Catholic families away from parochial schools, the Cincinnati School Board banned Bible reading and all forms of religious instruction in the city's public schools. Among the school board members was Max Lilienthal, a German-born educator who had emigrated to the United States in 1845 and settled in Cincinnati. By 1855, he became rabbi at Cincinnati's Congregation Ben Israel. Lilienthal was the leader of a movement to establish Reform Judaism in the United States. His lectures were announced in the Index, the organ of the Free Religious Association, and he regularly defended the school board's decision, including in the Jewish Times. An abolitionist committed to the idea of moral progress, Lilienthal argued that progressive civilization is neither Jewish nor Christian, but something greater, something broader than all these sectarian terms. Nationally, liberal Protestants supported the school board's decision. Most notably, the preacher Henry Ward Beecher, brother of Harriet Beecher Stowe, wrote in 1869 that the state has no business to teach religion or to show partiality to one or another sect in religion. In 1870, in Board of Education of the City of Cincinnati v. Minor, the Ohio Supreme Court ruled that the school board's decision violated the state's constitution. Lilienthal referred to the legal battle as a regular tournament between modern philosophy and obsolete theology. In a notable dissent from the Supreme Court decision, Alphonso Taft, father of the future president and Supreme Court Chief Justice William Howard Taft, declared his view that the First Amendment required neutrality toward all sects, and that Bible reading is Protestant worship, and its use is a symbol of Protestant supremacy in the schools, and as such, offensive to Catholics and to Jews. 3 years later, the Ohio Supreme Court unanimously agreed, reversing the lower court and thereby upholding the constitutionality of the school board's decision, arguing that a Republican form of government necessitated a free conflict of opinions as to things divine. And in a direct rebuke to the Christian Amendment movement, the court stated that religion is not, much less Christianity or any other particular system of religion, named in the preamble to the Constitution of the United States as one of the declared objects of government. Leaders of the Christian Amendment movement saw the banning of Bible reading in public schools as the inevitable tragic consequence of the omission of Christianity from the Constitution. Instead of expelling the Bible from our common schools to make them conform to the fundamental law, which acknowledges neither God nor the Bible, we shall insert the acknowledgement of God and His law in the Constitution and make it conform to our common schools. Soon, the National Association to Secure the Religious Amendment to the Constitution changed its name to the National Reform Association, now describing its mission as not only securing a Christian amendment, but also maintaining existing Christian features in the American government. They were attempting to halt an avalanche of secularism. The expulsion of the Bible is only the starting point, warned one Protestant leader. It means, ultimately, the elimination from public instruction of all that tends to the promulgation of the doctrines of true religion or morality, and of the rights of free human worship. Opposition to the Christian Amendment grew, especially among free thinkers and religious skeptics, led by Octavius B. Frothingham, who had founded the Free Religious Association in 1867. The Index warned that a Christian amendment would lead to the overthrow of the free republic and the erection of a Christian theocracy in its stead, along with the end of a free press and free speech. They formed liberal leagues dedicated to the defeat of the Christian Amendment. And in 1872, they'd organized a massive year-long petition campaign to counter the flood of Christian Amendment petitions. Their petition read, "We protest against such proposed amendments as an attempt to revolutionize the government of the United States and to overthrow the great principles of complete religious liberty and the complete separation of church and state on which it was established by its founders." On the floor of the Senate, Sumner, having switched sides, introduced one petition signed by 1,600 Bostonians in May 1873. A year later, he presented a similar petition, this time signed by more than 35,000 people and nearly 1,000 feet long. It is seldom that 35,000 people can be found to sign an appeal against a wise measure, the Boston Globe reported, and the 953 feet of the petition certainly go a great way in demonstrating the absurdity of the proposed constitutional plan of salvation. In response, Benjamin Butler of the House Judiciary Committee issued a report the next month that concluded that the framers of the Constitution had carefully weighed this question in 1787 and had decided that it was inexpedient to put anything into the Constitution or frame of government which might be construed to be a reference to any religious creed or doctrine. Moreover, none of the amendments proposed during the ratification debates had seen fit to correct this omission. Because even that did not defeat the Christian Amendment movement, its opponents crafted an alternative amendment that they published on the front page of every issue of the Index. They called it the Religious Freedom Amendment, but the Christian Amendmentists called it the Irreligious Amendment. Instead of an insertion into the preamble, they sought to enlarge the First Amendment by adding a clause to Section 1, barring Congress from making any law favoring any particular form of religion, and adding a Section 2 that applied the same restrictions to the states and that further provided that no religious test shall ever be required as a condition of suffrage or as a qualification to any office or public trust in any state, and no person shall ever in any state be deprived of any of his or her rights, privileges, or capacities, or disqualified from the performance of any public or private duty, or rendered incompetent to give evidence in any court of law or equity in any consequence of any opinions he or she may hold on the subject of religion. And then they organized another petition drive, which failed. The drafting and ratification of the 13th, 14th, and 15th Amendments in just 5 years gave reformers false hope. Those amendments had been, all of them, wartime measures, even after the war had ended. The 13th and 14th Amendments had been passed by a Congress that did not include the Southern states. Ratification of the 14th Amendment, as Southerners liked to point out, had been forced upon them, and so effectively had the 15th. In peacetime, after the nation was reunited, getting an amendment through a partisan Congress was nearly impossible. Between 1870 and 1909, not a single amendment passed both houses of Congress. Petitions came and were read and filed away. On the floor of Congress, amendments were introduced as bills and sent to committee to die. But in 1875, one entirely unlikely amendment did get out of committee and went to a vote. It even passed the House. It sought to broker a peace between the Christian Amendmentists and the Religious Freedom Amendmentists. Before 1876, the only party platform to endorse a constitutional amendment had been the Republican Party platform of 1864, which included a pledge to abolish slavery by amendment. After 1876, amendment planks became commonplace. Grant's administration was plagued with corruption, and there seemed a real chance that Republicans would lose the White House in the election of 1876. By the end of 1875, Grant was keen for a political win for his party. With city and state funding still going to parochial schools, the overwhelming majority of which were Catholic, Grant decided to tap into a growing opposition to religious education animated by anti-Catholicism, and equally into a growing demand for universal, free public education. In a speech in Des Moines in September 1875, he called on cities and states to encourage free schools and resolved that not $1 appropriated for their support shall be appropriated to the support of any sectarian schools. and to keep the church and the state forever separate. That December, in his annual message to Congress, Grant called for a constitutional amendment forbidding public schools from teaching religious, atheistic, or pagan tenets and banning the use of public funds for schools of any religious sect or denomination. Grant aimed to resolve the dispute by asking for concessions from both sides. Protestants would give up Bible reading in schools. Catholics would give up public funding for parochial education. Maine Republican, former Speaker of the House and presidential aspirant James G. Blaine proposed a narrower amendment in December. No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof, and no money raised by taxation in any state for the support of public schools or derived from any public fund therefore, nor any public lands devoted thereto, shall ever be under the control of any religious sect, nor shall any money so raised or lands so devoted be divided between religious sects of denominations. All that Mr. Blaine means to do, or can do, with his amendment is not to pass it, but to use it in the campaign to catch anti-Catholic votes, warned The Nation magazine. In 1876, the Blaine Amendment passed the House, 180-7. It was significantly revised in the Senate. Lobbying from the Christian amendmentists led to the addition of a clause that read, "This article shall not be construed to prohibit the reading of the Bible in any school or institution." That insertion likely doomed the amendment. The Senate voted 28-16 in favor of the revised amendment, but that tally fell 4 votes short of the required 2/3 majority. 27 senators, including Blaine, simply failed to show up to vote. The Blaine Amendment became one of a handful of amendments to pass one chamber, only to fail in the other. Republicans included a version of the amendment on their party platform in 1876, but it never rose from the ashes of its Senate defeat. Supporters and opponents of the Christian Amendment clashed again in the 1890s. In 1892, in an opinion in Church of the Holy Trinity v. United States, a Supreme Court justice observed, almost in passing, that we are a Christian people and the morality of the country is deeply engrafted upon Christianity. The language gave new hope to the Christian amendmentists, who once again pursued their objective, leading their opponents to renew their efforts to get Congress to pass a religious freedom amendment. As a Washington correspondent for the Los Angeles Times wearily reported in 1896, there are always people who want to insert the word God in the Constitution, as is done in some of the state constitutions, and people who make it their business to see that this is not done. They watch each other like hawks, and all they accomplish is to create such a warfare that Congress will not consider it seriously. The Rum Curse. In the course of American history, constitutional amendment as Christian salvation has generally been a dead end. Abolition began as a religious crusade, but it succeeded only by operating within electoral politics. And it took the secession of the South to accomplish the 13th Amendment. Victoria Woodhull appears to have taken the failure of so many crusading amendments as a warning that a different approach was necessary. But not every suffragist learned that lesson, nor did other types of constitutional crusaders. The tornado of religious enthusiasm that swept much of the Midwest, where support for the Christian Amendment was strongest, was only one front of a much larger storm of religious passion. Temperance reformers wanted to purify the Constitution, too. They wanted to purify the whole country and even the world. By the 1870s, they wanted a federal constitutional amendment. Organized into brigades in the states and aided by a national organization that printed useful materials like a constitutional amendment manual, theirs would be one of the few such moral crusades to succeed, with the ratification of the 18th Amendment in 1919. And then their amendment would be the only one in American history to be repealed under the terms of the 21st Amendment in 1933. Urged on by temperance reformers during the Second Great Awakening, a handful of states had banned the sale of liquor, starting in 1851, but most of those laws had been deemed unconstitutional. Temperance was a woman's crusade, and for good reason. Some men who drank to excess beat women and failed to support their wives and children. In 1862, Congress had imposed a liquor tax to help fund the war. War led to drinking, and so did the aftermath of war. The number of saloons doubled in a single decade. Between 1840 and 1910, the consumption of beer rose by 1,000%. By the 1870s, taxes on liquor, beer, wine, and tobacco were providing 90% of the federal government's revenue. In an era of comstockery, temperance found new followers. Beginning in the early 1870s, crusaders held revival meetings, closed saloons, convinced drinkers to sign abstinence pledges, petitioned state constitutional conventions, and campaigned for a federal constitutional amendment. Much animus was directed against German brewers. German-language newspapers referred to the Crusaders as the prayer pest. In the Midwest, Crusaders forced the closure of 1,000 saloons. Drinking, once considered a vice requiring personal restraint, was edged out in favor of the notion that the sale of liquor ought to be a crime, requiring constitutional amendment. Organized drives petitioning Congress for an amendment to ban the manufacture and sale of intoxicating liquors throughout the United States began in early 1871, weeks after Woodhull appeared before the House Judiciary Committee. By 1872, prohibitionists were seeking a constitutional amendment that would render all persons addicted to the use of intoxicating liquors ineligible to office, or, still more broadly, disqualifying from office anyone who uses intoxicating liquors as a beverage. In 1873, after a call for a congressional investigation of the liquor trade was defeated, calls for a constitutional amendment grew louder. In 1874, the movement coalesced around a new national organization, the Women's Christian Temperance Union, WCTU, formed in Cleveland, Ohio. Its standard petition called for an amendment banning the making, selling, importation, and exportation of intoxicating liquors. In 1875, the WCTU announced its formal turn to the amendment solution, calling drinking a crime against God whose end required a constitutional amendment. WCTU petitions began flying to Capitol Hill. In 1876, the first bill calling for a prohibition amendment was introduced in the House. The relationship between temperance and suffrage was uneasy. Within the rhetoric of the movement, drinking was a vice indulged in by men at the expense of women and children. In 1875, Frances Willard convinced the Illinois chapter of the WCTU to pass a resolution that since woman is the greatest sufferer from the rum curse, she ought to have power to close the dram shop door over against her home. But when Willard, then corresponding secretary of the national organization, sought the presidency, she was defeated. She resigned and inaugurated the Home Protection Petition campaign, seeking for women the right to vote on temperance issues. In 1879, she finally prevailed against the anti-suffrage faction and was elected president of the WCTU, a position she held for nearly 20 years. Neither the Christian Amendment nor the Religious Freedom Amendment ever succeeded, not even in getting out of a congressional committee. With far better local support, national organizational infrastructure, and movement endurance, the Prohibition and women's suffrage amendments did succeed, ratified as the 18th and 19th Amendments in 1919 and 1920, but only after a half-century of struggle. Victoria Woodhull had proposed an entirely different and immediate procedure, involving no special pleading, only a citizen's declaration of constitutional meaning. That hadn't worked either. Suffragists went back to the quieter, humbler, more mannered pleading of petitioning. Madam, you are not a citizen. Victoria Woodhull liked to tell a story about how, when she presented her argument to the House Judiciary Committee in 1871, John Bingham had said to her, "Madam, you are not a citizen," and that she'd had to remind him of the text of the 14th Amendment, which he had mostly written. This story seems almost certainly apocryphal, but the question of who was and was not a citizen or a person under the 14th Amendment would occupy the courts for decades, were Indian citizens, were Chinese American citizens, were corporations persons. On November 5, 1872, Election Day, Woodhull was unable to attempt to exercise her 15th Amendment right to vote. She was locked up in Ludlow jail. But other suffragists went out and gave it a try. Sojourner Truth tried to vote in Michigan, Susan B. Anthony and 14 other women attempted to cast their ballots in Rochester, New York, and were arrested. When registering to vote, Anthony had asked the registrar whether he had read Benjamin Butler's report, the Minority Report, agreeing with Woodhull's claim that the 14th and 15th Amendments guaranteed women the right to vote. The registrar had not read it. At her trial in June 1873, indicted on the charge of having knowingly voted without having a lawful right to vote, Anthony was asked, "Did you have any doubt yourself of your right to vote?" She answered, "Not a particle." She was found guilty. In Washington, Mary Shadd Cary and more than 60 other women had tried to register to vote in 1871 without success. "We do not know of her equal among the colored ladies of the United States," Frederick Douglass once wrote about her. Born in Wilmington, Delaware in 1823, Shadd was the oldest of 13 children. Her father, an anti-slavery activist, had regularly attended black conventions and had been the president of a black convention in 1833. Beginning at the age of 16, Shadd had taught in black schools. By 1851, after the passage of the Fugitive Slave Act, she had left the United States and urged fellow free blacks to follow her. She settled in Windsor, Ontario, just across the water from Detroit, where she published A Plea for Emigration, or Notes of Canada West, in its moral, social, and political aspect, and helped found a newspaper, the Provincial Freeman. Described as the first colored woman on the American continent to establish and edit a weekly newspaper, she also became a compelling orator. In 1855, she addressed an audience of black men at the 11th Colored National Convention in Philadelphia. While in the city, she argued the proposition and won in a debate on "Shall the free colored people of the United States emigrate to Canada?" The next year, she married a barber named Thomas F. Carey. In 1863, she recruited black men for the Union Army. After her husband's death in 1860, she and her 2 children moved to Washington in 1869, where Shadd Cary studied law at the newly founded Howard University. Shadd Cary agreed with Frances Harper, who argued that much as white women need the ballot, colored women need it more. In January 1874, she joined 600 other women in signing a petition seeking the right to vote in the District of Columbia. It was always hard to get attention on the Capitol at the start of a congressional session. Consider the first day of this session, when, promptly at noon on January 7th, the 43rd Congress opened. In the Senate, the chaplain said a prayer, minutes were read, and the floor was opened for the presentation of petitions. Sumner introduced a protest of the proposed theological amendment to the Constitution that was signed by more than 35,000 people and, if unfurled, measured nearly 1,000 feet long. He promised that the petition itself was brief. "We protest against such a proposed amendment as an attempt to revolutionize the government of the United States and to overthrow the great principles of complete religious liberty and the complete separation of church and state on which it was established by its original founders." He apologized that he'd failed to introduce it when it first came into his hands the previous spring, but he'd been too ill to attend the Senate. Reading this petition was one of Sumner's last acts. He would die of a sudden heart attack at home weeks later on March 11th. There followed some discussion of whether to refer the petition to the Judiciary Committee or to the Privileges and Elections Committee, of which Oliver Morton of Indiana was chair, or to another committee. Morton, hearing his name, stirred. "I was not listening this morning," he confessed. Wearily, Sumner began all over again, explaining the giant scroll. "This is a petition most numerously signed and largely from the West against what is known as the proposed theological amendment to the Constitution of the United States by the insertion of new words in the preamble." The petition was referred to the Judiciary Committee, but there were more petitions to read into the record that day, including one from the California Women's Suffrage Association asking for a constitutional amendment declaring that the right of citizens of the United States to vote and hold office shall not be denied or abridged on account of sex. A week later, that session's prohibition amendments began arriving, with 2 from Wisconsin. And so it went. Another day, another stack of petitions. Did anyone listen? Not often. Petition after petition after petition died in committee. On January 21st, that suffrage petition, signed by 600 women from the District of Columbia, was sent on to the House Judiciary Committee. Shad Carey then addressed that committee, speaking, she said, as a colored woman, a resident of this district, a taxpayer of the same, and one of a club equal in point of numbers to the male colored voters herein, claiming affiliation with 2.5 million of the same sex in the country at large. While denouncing the word male and asking that it may be stricken out by you without delay, she argued that by the provisions of the 14th and 15th Amendments, millions of colored women today share with colored men the responsibilities of freedom, including suffrage. If black men had earned the right to vote by their service in the Union Army, so had black women by their many, many sacrifices. And that war would have been for nothing until its victory could be made permanent, she warned, and unless the government were to be based upon the consent of the governed by granting constitutional rights equally to both sexes. If Congress would act, she closed, black women would at last be governed by their own consent. Mary Shad Carey had no more success in 1874 in persuading the House Judiciary Committee than Victoria Woodhull had had in 1871. She had less success and also was less noticed. Within a year, the Supreme Court had ruled on the Woodhull-Carey strategy, known in suffrage circles as the New Departure. In Missouri, the suffragist Virginia Minor had attempted to register to vote in 1872, too. Rejected, she'd filed suit against the registrar, Reese Happersett, arguing that because Minor was a citizen under the terms of the 14th Amendment, she could not be denied the right to vote. When the state Supreme Court ruled against her, Minor appealed to the U.S. Supreme Court. In a unanimous decision, the justices ruled that the right to vote is not among the privileges and immunities of citizenship, and that if it had been intended to make all citizens of the United States voters, the framers of the Constitution would not have left it to implication. Nor had the 14th or 15th Amendments established that right. Minor v. Happersett put an end to the argument that the Constitution didn't need amending. Women were granted the right to vote in Wyoming in 1869, Utah in 1870, and Colorado and Idaho in 1893 and 1896. The political struggle for equal rights raged on. In 1880, Shad Carey founded the Colored Women's Progressive Freedom Franchise, whose first goal was to assert their demand of equal rights. In the election of 1896, women in 4 states, Wyoming, Colorado, Idaho, and Utah, were able to vote for president. Elizabeth Cady Stanton wrote to one candidate asking for his support and employing all the racist and nativist rhetoric that had animated her brand of suffrage since 1869. It would be a graceful tribute from a young man to the mothers of this republic to recommend Congress in his inaugural address to pass a 16th Amendment to the national Constitution forbidding disenfranchisement in the several states on the ground of sex, she argued, assuring him that this would place educated women at least on an even political platform with emancipated slaves and ignorant immigrants from the Old World. In England, Victoria Woodhull republished her original petition to Congress. The object of the Women's Suffrage Convention had been to obtain the franchise by amending the Constitution, Woodhull wrote in 1896, looking back. The whole gist of my contention, from the first, was and is that no amendment is necessary. She had been wrong. Women, it turned out, needed an amendment. The trouble was how to get one. The Understanding Clause. In 1876, James G. Blaine lost the Republican nomination to Rutherford B. Hayes, who then lost the popular vote to New York Democrat Samuel J. Tilden. Before the counting was completed, Tilden also appeared to have won the electoral vote, except for the many rumors that black men had been prevented from voting, or that their votes had been discarded. In the end, a hastily formed electoral commission granted the presidency to Hayes, apparently in exchange for a promise to end the military occupation of the South. Once Reconstruction was abandoned, the former Confederate states rewrote their constitutions once more. They are known as Redeemer Constitutions, since they were part of the white Southerners' attempt to redeem the former Confederacy from what they described as Negro supremacy. For these state conventions, voters chose delegates in elections that barred black voters, often through acts of terror and violence, and held conventions where, with rare exception, black men did not serve. The Redeemer Constitutions reversed many of the provisions of the Reconstruction Constitutions, weakening or abandoning federal supremacy clauses and restoring the right of citizens to alter or abolish their constitutions. After the federal government abandoned Reconstruction, it began the long, slow abandonment of the 15th Amendment. Tennessee, in 1870, adopted the first of these constitutions, instituting poll taxes to bar black men from voting. Post-Reconstruction state constitutions and Jim Crow laws would, by the end of the century, make it effectively impossible for black men in the South to vote. Meanwhile, the Supreme Court effectively dismantled the 14th Amendment in its 1873 Slaughterhouse Cases decision, ruling that the Privileges and Immunities Clause of the 14th Amendment was binding only on the federal government, not on the states. And in 1883, it declared the 1875 Civil Rights Act unconstitutional. Mississippi had held a constitutional convention in Jackson in 1890. All but one of its 136 delegates were white. The exception was Republican delegate Isaiah Montgomery, who had been born into slavery in 1847, the property of Joseph Davis, an older brother of Jefferson Davis. Joseph Davis had required the slaves on his plantation at Davis Bend, south of Vicksburg, to devise their own laws. Every Sunday, he, as judge, presided over trials where slaves presented claims before slave juries. Montgomery's father had been a mechanical engineer, and Isaiah became Joseph Davis's private secretary, serving Jefferson Davis in the same capacity whenever he visited Davis Bend. Montgomery would later write that he and Jefferson Davis became fast friends. After the war, Isaiah Montgomery's sisters studied at Oberlin, and the Montgomery family bought all 4,000 acres of the Davis plantations, becoming the richest black family in the South. Jefferson Davis sued for the property, and in the end, Isaiah Montgomery sold the plantations at auction. But through this and other ventures, he remained among the wealthiest black men and wealthiest men in the United States. He maintained a close relationship with Davis's widow, Verena. Delegates to Mississippi's convention explicitly argued against black suffrage and formally urged the repeal of the 15th Amendment, one stating that white people only are capable of conducting and maintaining the governments. As one delegate explained, it is the manifest intention of this convention to secure to the state of Mississippi white supremacy. Disenfranchising black voters without disenfranchising white voters required precision, and yet had somehow to be accomplished without violating the 14th and 15th Amendments. Montgomery served on the Franchise Committee and supported its solution, which was not only to mandate poll taxes, but to restrict the franchise in a wholly new way by what became known as the Understanding Clause. It required prospective voters to pass a literacy test that required not only reading but also explaining any given portion of the state's constitution. Montgomery delivered an address at the convention supporting the franchise requirements, including the Understanding Clause. He hoped that it would be fairly enforced and bridge a chasm between the races and instead divide Mississippi voters not by race, but by education. But the Understanding Clause was vastly unpopular with the broader public since it so obviously seemed ripe for corruption. One newspaper called upon the members of the Constitutional Convention to wipe out, strike out, blot out, kick out that outrageous, unjust, iniquitous, miserable, and disgraceful clause in the franchise law known as the Understanding Clause. Everybody knows that it was put there for the purpose of swindling men out of their votes under the cover of law, and that it is a disgrace to the state. In the end, the state legislature simply adopted the Constitution rather than submitting it to the people for ratification, where it would likely have failed. The Understanding Clause, selectively applied, effectively disenfranchised the entire black electorate. White voters were not generally asked to take the test. I have stood by, consenting and assisting in striking down the rights and liberties of 123,000 freemen, Montgomery admitted. He has made peace with the lion by allowing himself to be swallowed, was the verdict of Frederick Douglass. Elements of the Mississippi system and other mechanisms of disenfranchisement were soon adopted throughout the South. The word white had been written into state constitutions before the Civil War, deleted afterward, and overruled by the 14th Amendment in 1868. The Supreme Court had been chipping away at the protections guaranteed by the Reconstruction Amendments beginning in 1873 with the slaughterhouse cases. In 1896, in Plessy v. Ferguson, the court ruled that racial segregation in public accommodations, like railway cars, did not violate the Equal Protection Clause of the 14th Amendment because of a doctrine the court created, allowing for segregation so long as accommodations were separate but equal. The Supreme Court all but nullified the 14th Amendment, while across the South, Jim Crow laws and Redeemer constitutions effectively nullified the 15th Amendment. By 1900, Southern members of Congress began routinely introducing proposals to repeal both the 15th Amendment and the Apportionment Clause of the 14th. This was purely symbolic. They'd already been violently voided. A century of constitutional interpretation. In 1887, many Americans found it difficult to celebrate the 100th anniversary of the Constitution. There seemed to be, as one organizer put it, an entire absence of any interest or general sentiment in favor of the proposed celebration on the part of the public at large. Most cities and towns ignored the anniversary. A national celebration was planned for Philadelphia, but to a man, the nation's most acclaimed orators declined the invitation to speak. No poet could be found. James Russell Lowell, Oliver Wendell Holmes Sr., John Greenleaf Whittier, all declined. Walt Whitman was not asked, the Centennial Committee having decided that such a choice would not be safe. The colored people's display was deemed a poor effort. Not until nearly the last minute did anyone notice that they had forgotten to arrange for fireworks. In the end, the organizers pulled it together, and some 500,000 people, including President Grover Cleveland and his wife, descended on the city for the military parade on September 17th. But compared to the hoopla that in 1876 had greeted the anniversary of the Declaration of Independence, the Constitutional Centennial was a disappointment. And as E.L. Godkin persuasively argued in The Nation magazine, Americans of the future would be more likely to celebrate the real founding of the country at the anniversary of 1865 with the ratification of the 13th Amendment than the anniversary of the drafting of the original Constitution in 1787. With the 100th anniversary of the Constitution, a century of attempts to amend it came to a close too. It appeared to plenty of people as though those efforts had more or less ended. The Constitution was intended to be and is practically beyond the reach of the people, according to an editorial titled "Not a Democracy" in the Washington Post in 1888. It is virtually unamendable. The writer believed this to be a good thing. Not everyone agreed. One historian used the occasion to quite carefully take stock. How many had been those attempts, and to what end? A great enthusiasm for counting had begun in the study of history, and in fact of everything. In a widely read and much admired account of American institutions published in 1888, The American Commonwealth, the British jurist and member of Parliament Lord James Bryce, the Tocqueville of American constitutionalism, reported that between 1884 and 1886, 47 amendments had been introduced on the floor of Congress, and not one had seen even the slightest success. He took this as a measure of both the excellence of the original instrument and the difficulties which surround the process of change. Bryce blamed the Civil War for the difficulty of amendment. The struggle over the interpretation of a document which was found impossible to amend passed from the law courts to the battlefield. And he offered a theory for why it was so hard for Americans to clear the admittedly high bar set by Article 5. He put it down to party politics. A change in the Constitution, however useful its ultimate consequences, is likely to be, for the moment, deemed more advantageous to one party than to the other, and this is enough to make the other party oppose it. American scholars soon took up the subject. In 1889, the University of Pennsylvania's John Back McMaster published a long and exceptionally well-researched essay called A Century of Constitutional Interpretation in the popular illustrated magazine The Century. McMaster, who was only 36 but already one of the nation's leading historians, offered a detailed and spirited account of the ceaseless attempts to amend the Constitution beginning in 1787, when the Constitution was very far from being what the people wished. For McMaster, American constitutional history was, in fact, the story of Americans' attempts to close the distance between the Constitution they had and the Constitution they wanted. If the amending stopped at the 15th Amendment, McMaster wrote, the rage for amendment went on burning with tenfold fury. Constitutional history was at the time just emerging as an academic discipline, one with leanings toward social science and quantification. McMaster's work inspired a young disciple. Herman Vandenberg Ames graduated from Amherst College in 1888, briefly studied at Columbia, and began doctoral study in history at Harvard in 1889, where he likely read McMaster's essay and also McMaster's books, including his 1889 Outline of the Lectures of the Constitutional History of the United States. He might even have gone to Philadelphia to attend McMaster's lectures, in which McMaster gave nearly equal attention to defects in the Constitution and efforts to amend it as to constitutional interpretation. At Harvard, Ames overlapped with W.E.B. Du Bois, who earned his B.A. in 1890 and his Ph.D. in 1895. They also shared an advisor in the historian Albert Bushnell Hart. For Ames's dissertation, which he completed in 1891, he undertook an extraordinarily ambitious archival project, the compilation and analysis of proposed amendments to the Constitution of the United States during the first century of its history. Reading through the records from Philadelphia in 1787, Ames had come to think something had gone terribly wrong. It is difficult to avoid the conclusion that it was the expectation of the members of the Federal Convention that a frequent use of the amending power would be made, he wrote. And he'd been surprised to discover that although many scholars had written about the 15 amendments that up till then had been ratified, no attention has been paid, with rare exception, to the amendments which have failed. Ames cited and thanked McMaster, and noted that 2 excellent brief articles by McMaster were nearly the only pieces ever written on the subject. So he'd gone to Washington and tried to find the records of those failures in the Congressional Globe and the Congressional Record, and especially in the Senate document room in the Capitol. Paging through old papers, he found upward of 1,300 distinct resolutions containing over 1,800 propositions to amend the Constitution. Ames believed that the Constitution was too difficult to amend. The expectation of the framers had not been fulfilled, he wrote in 1891, and the facts plainly show that the method is not sufficiently facile to meet our wants. 5 years later, he published his monograph to much-deserved acclaim. The next year, he joined McMaster on the history faculty of the University of Pennsylvania. The 2 men later wrote a book together. Ames's compilation as the single reference work on the subject provided the most important record of constitutional amendment efforts to date. He called attention to the difficulty of amending the Constitution, 1,800 proposals and only 15 ratified amendments over the course of a century, and warned of the fateful consequences of unamendability. Ames's figures, though, are not altogether reliable. On the one hand, he inadvertently exaggerated the scale of constitutional discontent by counting proposals that were duplicative or mere refinements upon one another, or simply different sections of a single amendment, as if they were separate amendments. On the other hand, he left much out. As he noted in a footnote, no notice has been taken of petitions. He overstated the number of proposals introduced on the floor of Congress, and he left out entirely the voices of people who offered support for or opposition to existing proposals, or who introduced their own proposals by way of petition. Quantitative evidence of the Constitution's unamendability arrived at a time when the nation confronted radical social and economic changes. By the 1890s, the United States stretched across the continent, crisscrossed by railroad tracks and telegraph wires, and in the West, scissored with barbed wire. The U.S. population had grown from under 4 million in 1790 to more than 60 million a century later. Immigrants as a percentage of the U.S. population had risen from 10% in 1850 to 15% in 1890, when new waves of immigrants from Eastern Europe, especially Jews, Hungarians, and Italians, fled poverty in the Old World to seek their fortunes in the New. The rise of the corporation and the growth of railroads, along with American expansion, including the acquisition, conquest, and annexation of the Philippines, Cuba, Guam, Puerto Rico, and Hawaii, contributed to dire economic inequality in what came to be known as the Gilded Age, characterized by an extraordinary accumulation of wealth among the very few and miserably meager conditions for the very many. Less than 1% of the population controlled more than half the nation's wealth. Yet an increasingly activist and conservative Supreme Court sided again and again with business interests. Before 1890, it had hardly ever used its most powerful weapon, its asserted power to declare government actions unconstitutional, but after 1890, it used that tool repeatedly, relying too on its finding in the 1886 case, Santa Clara County v. Southern Pacific Railroad, that corporations are persons entitled to 14th Amendment rights. In 1898, a very young historian named Charles Beard lamented that this crowned Constitution with its halo has been the bulwark of every great national sin, from slavery to monopoly. Only amendment, it seemed, had ended the former, and only amendment could end the latter. Amendments were necessary, but what if they were impossible? Frederick Upham Adams, who invented the electric light post and edited a magazine called The New Time, believed that the great issue of 1900 will be, shall the Constitution of the United States be so amended or revised that the rights of the majority shall be preserved? In 1897, he explored the consequences of an undemocratic and unamendable Constitution in a novel called President John Smith. While robber barons count their millions and starving workers march by the hundreds of thousands in endless strikes, the Supreme Court strikes down as unconstitutional all laws designed for their relief, unwilling to admit that the Constitution of 1787, an antiquity, the cherished heirloom of a vanished age, was absolutely unfitted for the world of 1887. Our hero is a lawyer named Smith. John Smith had no patience with certain of his friends who would hold up their hands in horror that the Constitution of the United States was full of errors. "Have you no veneration?" exclaimed Jones one day. "Not a bit," responded Smith. "Veneration is a half-witted, obsequious brother to superstition, and I care for the companionship of neither." Smith becomes a judge, but resigns from his judgeship because he refuses to take an oath to the Constitution. After giving a stirring speech at a nominating convention in which he argues for the repeal of the entire Constitution, he's nominated for president. Although he wins both the popular and the electoral vote, his enemies plan to steal his victory from him, whereupon, as the vice president is overseeing the Electoral College count at the Capitol, Smith's followers break in and riot. Insurrection is what happens when you can't amend the Constitution. With Smith's defeat by way of a stolen election, the country descends into chaos. At a meeting in Omaha, Smith calls for a constitutional convention to draft a new constitution in which the people shall make and unmake laws, in which the people shall elect and depose officials, in which the will of the people is supreme. Its Article 8 provides for repeal, revision, or amendment by a majority vote of the people of the United States. The Constitution is ratified overwhelmingly, and Smith becomes the next president. In 1898, North Carolina Supreme Court Justice Walter Clark, a contributor to Frederick Upham Adams' magazine, The New Time, describing the 1787 Constitution as a misfit, called for a wholesale revision. "The Constitution is not a fetish to be worshipped, nor did it come down from heaven a perfect work," Clark wrote. "Its defects nearly brought us catastrophe. It did not foresee the steamboat, the railroad, the factory, the bank, the corporation. It was not democratic. He lamented the indirect election of the Senate. He lamented the Electoral College. He lamented the presidential nomination of Supreme Court justices, as well as their life tenure. The Constitution," Clark pointed out, "was devised for a population of 3 million living along the Atlantic, but we are now trying to make it do duty for 80 million settled from ocean to ocean and from the Great Lakes to the Gulf," he complained. "The expected admission of Hawaii, which indicates a colonial policy, are features unprovided for by a constitution which contemplated merely a union of co-equal states and not permanent territories or colonies." Clark believed that in an age of American empire, the very survival of the Republic was at stake. "The revision is needed," he concluded. "It will and must come." And it did come, but not then, and not there. Meanwhile, as Clark saw, a crucial chapter in American constitutional history had been unfolding nearly 5,000 miles away from the nation's capital, on a tropical island in a volcanic archipelago in the bluest Pacific. Chapter 7. We began this quilt. The name of this republic is hereby changed from the United States of America to the United States of Earth. Failed amendment to the U.S. Constitution, introduced into the House, 1893. The Queen was locked in an upstairs bedroom in the royal palace, as if she were Rapunzel. Anything she might read had been taken away from her, though as a kindness she was allowed pencils and paper. "I was thereby able to write music after drawing for myself the lines of the staff," she explained. She'd been provided with 2 cages of canaries. She adored their singing. She sang herself. Her songs were more than songs. She used them to send messages. Friends were permitted to bring her flowers from the royal garden. "Such lovely flowers are sent in pots, all in bloom, and my room is a perfect bower of ferns and flowers," she wrote to her niece. The flowers were more than flowers. They'd been cunningly wrapped in bits of newspaper, the Queen's only supply of news. She spent much of the day with her female attendants. "We are occupied in sewing," she told her niece. "They were darning stockings or mending some rent in our garments. But they were also stitching a kapa apana, a crazy quilt. The quilt was more than a quilt. It was a kind of kumu kanavai, or constitution, a repair to a tear in the fabric of her kingdom, a rent mended." Hawaii's constitutional past, like that of other insular U.S. territories, Puerto Rico, Guam, American Samoa, as well as that of North American native nations, has been mainly left out of the larger history of American constitutionalism. These histories follow different plot lines and timelines. They involve different actors, languages, politics, laws, and, as Francis Lieber would have termed it, different constitutional hermeneutics. They can be hard to fold into a national story centered on the U.S. Constitution and the workings of the federal government in Washington, D.C. And there are arguments, too, against doing that kind of folding, on the theory that this, too, is another kind of forced assimilation. But leaving these parts of American history out of its constitutional past renders American imperialism invisible and obscures the influence of U.S. constitutional ideas and practices on insular territories and native nations as well as influence that runs in the other direction. The constitutional and political contest over the annexation of Hawaii in 1898, more than 20 years after the end of Reconstruction, reveals the persistence of race-based ideas about republicanism, constitutionalism, and the powers of interpretation and amendment. Folding this story into a larger narrative of American constitutional history also reveals the role played in that annexation by U.S. corporations like the infamous Sugar Trust, and establishes the centrality of the conflicts between business and labor that would inform efforts to amend and reinterpret the Constitution for decades. With constitutionalism, as with the Queen's quilt, Hawaiians had their own fabrics and patterns, textures and weaves, but they also imported fabrics, silks, and patterns from China, Japan, Europe, and America, then stitched them together, making of the art of quilting, too, a metaphor for constitutional construction. The Queen's 9-block quilt measured 97.5 by 95.5 inches, the size that would cover a proverbial queen-size bed. It was made out of rich, bright silks cut from the Queen's clothing and stitched with many colored satin threads in a then-popular needlework style usually called crazy quilting, but sometimes known as Japanese patch, since it was influenced both by the English embroideries of William Morris and by Japanese or Oriental mosaics. The center block is itself divided into 4 quarters, each containing embroidered words, a chapter in the life of the Queen. The story begins on a blue brocade, stitched with threads of gold and red. Lydia Kamakaeha Liliuokalani, born September 2nd, 1838. Liliuokalani had been born into the house of Kamehameha. American missionaries had arrived in Hawaii in 1820, just after the death of King Kamehameha, a time of deep political and religious disruption. The diseases that the Americans brought led to devastating population decline and all the dislocation and desperation that comes with it. By the time Liliuokalani was born in 1838, nearly half the native population, the Kanaka Maoli, had died. A missionary baptized her and named her Lydia. The missionaries told the ali'i, or nobles, that the worship of their god, Jehovah, required adopting the palapala, the written word, and that it could both save their people and strengthen their own power. For Hawaiians, this technology was merely another form of the medium of speech, the powerful tradition of oral performance, and the keeping of history, especially through chants, prayers, proverbs, and songs. Yet the missionaries required different acts of speaking and writing. Lydia was sent to a missionary school. She spoke Hawaiian and English and some French, German, and Latin. Alongside Christianity, American missionaries spread American constitutionalism around the world, and with the same missionary zeal. In 1839, King Kamehameha III agreed to a Declaration of Rights, and the next year to Hawaii's first written constitution. Article 46 provided for amendment, and still Native Hawaiians died. By 1860, the population had once again been cut in half. In 1862, when Liliuokalani was 24, she married an American, or haole, a foreigner, then studied for a time at Oahu College. In 1878, she composed her most famous mele, or song, Aloha Oe, Farewell to Thee. There were so many goodbyes. In little more than a century, Hawaii's native population had fallen from nearly 900,000 to less than 40,000. Year by year, the Kanaka Maoli became a smaller and smaller percentage of the population, and the number of haole grew. Constitutionalism in Hawaii involved a ceaseless battle for power between the monarchy and the coalition of American and European missionaries and sugar plantation owners, sometimes known as the Missionary Party, who sought to dispossess and rule over Native Hawaiians and disenfranchise Portuguese, Chinese, and Japanese laborers. Liliuokalani called Americans and Europeans pseudo-Hawaiians. By the 1880s, the Kanaka Maoli had become a minority in their own land. In 1887, the missionary party imposed a new constitution, taking power away from the monarch, King David Kalakaua, Liliuokalani's brother. A growing resistance formed the Hui Kalai'aina, a political association, to fight for voting rights for the Kanaka Maoli under the slogan, Hawaii for the Hawaiians. Liliuokalani became Mohi Wahine, Queen, in 1891 at 52. On her quilt she stitched, proclaimed heir apparent April 10, 1877, ascended the throne January 29, 1891. She was determined to revise her kingdom's constitution. It was for this that she would be imprisoned in the royal palace, shut up with singing birds and blooming flowers and silken threads and needles, mending and stitching. Her crime, the last act of the last Hawaiian sovereign, was her attempt to amend the Hawaiian Kumukana Vai. Bastard Constitutions. Article 4 of the U.S. Constitution guarantees to every state in this union a republican form of government. No such guarantee was ever made to every territory. From the start, the U.S. Constitution had been as much a colonial constitution as an anti-colonial one. Even as Americans cast off their status as colonial subjects of the British Empire and embraced both independence and republicanism, they were establishing an American empire. Jefferson had famously declared in 1805 that by enlarging the empire of liberty, we provide new sources of renovation should its principles in any time degenerate in those portions of our country which gave them birth. But the growth of the Republic meant the violation of the sovereignty of native nations and the denial of both statehood and equal citizenship to people who lived in places the United States decided to acquire. Between 1776 and 1871, the federal government made treaty after treaty with native nations, an act that by its nature acknowledged their sovereignty, and after 1831, under the formal term of domestic dependent nations. But it broke treaty after treaty, an act that by its nature made a mockery of sovereignty. The 1787 Constitution placed Indians not taxed beyond the pale of the political community, excluding them from the calculation of representation. Instead, in the 1780s, the federal government promised Indians their own representation in Congress. This never came to pass, even though the promise was regularly renewed. In the 1830s, Andrew Jackson had proposed that Eastern Indians removed to Indian Territory would have representation in Congress when a portion of that land, known as the Western Territory, entered the Union as a state. Indian Territory at the time stretched from the top of Texas to the bottom of Canada and from the Great Lakes to the Rocky Mountains. Members of Congress had objected to the prospect of adding to our Union men of blood and color alien to the people of the United States, and the proposal for Western Territory had been rejected. A decade later, the same reservations had been raised to admission to the Union of portions of Mexico. At the annexation of Texas in 1845 and of more than half of Mexico in 1848 with the Treaty of Guadalupe Hidalgo, members of Congress had objected both to establishing these territories as colonies and to admitting them as states on racial grounds. John C. Calhoun argued that Americans had never incorporated into the Union any but the Caucasian race, and that to incorporate Mexico would be the first departure of the kind, for more than half the population are pure Indians, and by far the larger portion of the residue, mixed blood. The bigger the nation grew, the wider its inequalities. State constitutions ratified in the mid-19th century sought to restrict suffrage to white men, at a time when the free black population was rising, as was the population of Americans of Mexican, Chinese, and Japanese descent. After the United States expanded to the Pacific, with the establishment of the Oregon Territory in 1848 and the entry of California into the Union in 1850, some new state constitutions not only disenfranchised Chinese and Japanese immigrants and their descendants, but also barred them from citizenship. Oregon's 1857 Constitution prohibited blacks from entering the state, owning real estate, making contracts, or in any way using the legal system. Before 1850, Indian Territory had stood at the remote western edge of the United States. After 1850, it divided the eastern United States from the western. From the federal government's vantage point, Indian Territory now stood in the way of settlement, transportation, and especially commerce. In a speech advocating the Transcontinental Railroad, Illinois Senator Stephen Douglas insisted that the Indian barrier must be removed. In 1854, the federal government established the Kansas and Nebraska territories, which entered the Union as states in the 1860s. In 1861, when the South seceded from the Union, many tribes formed alliances with the Confederacy, which promised them both representation and statehood. When the Union won, the tribes lost too. In any event, the Confederacy would have been no likelier than the Union to keep its promises. The American Board of Commissioners for Foreign Missions, the Christian missionary society that had undertaken missions to the Cherokee and fought against Jackson's Indian removal policy, had organized the first missions to Hawaii. But by the 1840s, many of the sons of those missionaries had themselves become the wealthy owners of large sugar plantations. They proselytized Christianity, constitutionalism, and capitalism in that order. Hawaii's 1840 constitution established a constitutional monarchy, but much of the new government's power lay in the hands of American missionaries and businessmen. American-style legal codes, including a revised constitution drafted by an American attorney and adopted in 1852, introduced wage labor and private land ownership, promoted foreign investment, the importation of Chinese and Japanese laborers, and the settlement of businessmen from the United States, impoverished the people, Maka Ainana, and alienated them from the land, and took away the political power of women who were denied the right to vote. During the American Civil War, Hawaiian sugar planters profited from the disruption of trade in the Atlantic and grew wealthier still. But at their power, the monarchy balked. When Kamehameha V ascended to the throne at the end of 1863, he refused to swear an oath to the 1852 Constitution. Among other things, he objected to its liberal suffrage provisions and wished to introduce property and literacy qualifications. Its tortured amendment provision, Article 105, made amendment exceedingly difficult, and in any case the king believed that he himself held the power of amendment. In May 1864, he called for a constitutional convention. In an address to its delegates, he conceded that under a constitutional government, the people must be consulted, but asked, "Who are the people? Is it the dregs of society, the ignorant and improvident, or is it the intelligent element?" To a proposed amendment to add the words "and equal" to Article 1, God hath created all men free and equal, and endowed them with certain inalienable rights, the king objected, citing the Hawaiian division between nobles, alii, and commoners. The history of these islands informs us that there have always been here races of chiefs and common people. But when its delegates refused to do his bidding, he dissolved the convention. In a final speech to the convention, he said that universal suffrage cannot coexist with a monarchic form of government, and promulgated a new constitution that extended his own political power at the expense of that of the American missionaries and businessmen. Liliuokalani composed a mele or song that endorsed this new constitution. "Do not abandon this good work. Steadfast, stand firm for our Constitution." On the mainland, the post-Civil War federal government exerted its power to promote expansion to the Pacific, taking unceded Indian lands along the way. Under Reconstruction-era treaties with Indian tribes in 1866, the federal government required the 5 tribes, Cherokee, Chickasaw, Choctaw, Creek, and Seminole, to emancipate their slaves and grant them citizenship, a demand the tribes resisted, and to cede much of what remained of Indian territory to railroads. Indian territory was reduced to what is now the state of Oklahoma, a Choctaw word meaning home for the red man. The federal government then ceased its policy of making treaties with native nations and instead pursued the twin policies of forced assimilation and devastatingly brutal warfare among Plains Indians, the Cheyenne, Arapaho, Comanche, Kiowa, and Apache, forcing them onto reservations on smaller and smaller stretches of land. Within Indian Territory, native nations established new forms of government, but most were uninterested in seeking statehood. In 1870, an intertribal council adopted Indian Territory's first constitution, the Okmulgee Constitution, establishing a confederacy republican in form with due regard for the rights of each tribe under existing treaties. Though the council met until 1876, the Constitution was never ratified. The Chickasaw objected due to lack of equal representation in the legislature. The ratification of the 14th Amendment had raised questions about Indian citizenship. The Birthright Citizenship Clause granted citizenship to all persons born in the United States or under its jurisdiction. What about Indians born on sovereign Indian lands? In 1879, Standing Bear, a Ponca chief, was imprisoned in Nebraska for leaving Indian Territory to bury his son, who died during a forced removal. He filed a habeas corpus petition seeking his release. In Standing Bear v. Crook, he argued that he was both a citizen and a person under the terms of the 14th Amendment. The U.S. government argued that he was neither. The judge ruled in favor of Standing Bear. Webster describes a person as a living soul, a self-conscious being, a moral agent, especially a living human being, a man, woman, or child, an individual of the human race, the district judge wrote. This is comprehensive enough, it would seem, to include even an Indian. 5 years later, in Elk v. Wilkins, the Supreme Court took up the question. In 1880, John Elk, a former Winnebago, Ho-Chunk tribal citizen, who had left his homelands and settled in Omaha, Nebraska, tried to register to vote. He was denied on the ground that as an Indian, he was not a citizen. Elk argued that he was indeed a citizen under the terms of the 14th Amendment, but in a 7-2 decision, the Supreme Court ruled that he was not a citizen, because although born within the territorial limits of the United States, he had not been subject to its jurisdiction because he had been a citizen of a tribe. The two-man dissent argued that because Elk had severed all relations with his tribe, he had automatically become a citizen of the United States. Prejudice against Chinese immigrants had been a feature of state law and constitutional discourse since the 1850s. In 1854, the California Supreme Court ruled that no person of Chinese, African, or Native American descent could testify in court against a white person. The court specified that Chinese immigrants had been marked as inferior by nature. Oregon's 1859 Constitution forbade immigrants from China from owning real estate. Francis Lieber, a man who had written that the white man has shown little sympathy with other races and sympathy is the first basis of all idea of justice, also complained that Chinese immigrants invade our country similar to the Norway rat. And in 1870, he proposed a constitutional amendment prohibiting the immigration of any but white people. California's 1879 Constitution banned Chinese immigrants from government employment. In waves of violence, Chinese immigrants who settled in the American West were threatened, harassed, arrested, and lynched. In 1882, with the Chinese Exclusion Act, Congress inaugurated a race-based immigration and citizenship policy, restricting immigration from China for 10 years and barring all Chinese immigrants from becoming U.S. citizens. It was renewed again in 1892 and 1904 and granted permanency 2 years later. Prejudice against Chinese felt in the United States, where they were represented in the press as filthy and diseased, was carried to Hawaii by white settlers and missionaries, including, for instance, the early editors of the Pacific Commercial Advertiser, an English-language Honolulu newspaper that advocated restricting Chinese immigration to Hawaii. As for the 14th Amendment's definition of personhood, the court most notably intervened in a case in 1886, Santa Clara County v. Southern Pacific Railroad, when it ruled that corporations are, under the 14th Amendment, persons. The implications of that ruling in the struggle between capital and labor that would animate much political disputation would become the focus of amendment agitation in the Progressive era. In the shorter term, it advanced the interests of railroad corporations in opening Western lands to white settlement. In 1887, with the Dawes Act, Congress opened up to white settlers land that had been previously closed to them by mandating the division of tribal lands, exempting only the 5 tribes in Indian Territory. Indians who agreed to live and dress as white would be allotted grants of land for farming, though, as it turned out, the lands made available to them were often barren. Liliuokalani was the head of a sovereign nation that was neither part of nor even adjacent to the United States. She was Polynesian, not Asian or African or European or American. Yet each of these events, American expansion to the Pacific, the denial of native sovereignty, the assertion of federal supremacy, the overturning of constitutions, the hardening of racial lines, was another link in the chain of events that would lead to her imprisonment in Hawaii in 1891. The Constitutional Sovereign. Congress passed the Dawes Act in February 1887. That spring, American missionaries and businessmen in Hawaii began plotting against the king, David Kalakaua, who since 1882 had opposed closer ties with the United States. At his coronation, Kalakaua had also reintroduced and celebrated the ancient practice of hula, banned and much despised by Victorian-era missionaries as obscene. Americans opposed to Kalakaua, led by Lauren Thurston and Sanford B. Dole, both children of missionaries, formed the Hawaiian League, a clandestine society whose members included the owners of the kingdom's wealthiest sugar plantations. They wanted to overthrow the monarchy and establish a republican government by all necessary means. Some wanted to secure annexation to the United States and apply for statehood. Native Hawaiians did not support any of these objectives. In secret, the Hawaiian League enlisted the support of an all-white paramilitary organization, the Honolulu Rifles, and drafted a new constitution. Kamehameha V's 1864 constitution had proclaimed that the king is sovereign of all the chiefs and of all the people, the kingdom is his. Thurston and Dole's 1887 version deleted those last 4 words. The king's power as an executive was given instead to his cabinet, which retained control over legislation. Nor could the king remove any members of the cabinet without the approval of the legislature, which in turn was elected only by men of considerable property. Dole appointed himself to a new Supreme Court with lifetime tenure. The legislature, under the 1887 Constitution, controlled the military, where earlier the king had. The Thurston and Dole Constitution denied nearly all Native Hawaiians of the right to vote by setting a property requirement for voting at $3,000, about $100,000 in 2025 money, and imposed racial restrictions that excluded 18,000 naturalized Chinese Hawaiians from the electorate. White Southerners complained that the 14th and 15th Amendments and Reconstruction-era state constitutions were bastard constitutions that had been imposed on them by force and bayonets. Hawaiians called the constitution that Dole and Thurston imposed on them in 1887 the Bayonet Constitution. Faced with the Honolulu Riflemen and under the threat of assassination, Kalakaua signed the Constitution. When a delegation of Kanaka begged him to abrogate the Constitution, he issued a statement of particular ambiguity. It has been read as endorsing the new Constitution, admitting his powerlessness to change it, and warning Hawaiians to view it as fundamentally foreign. Under the old Constitution, the people went barefoot or wrapped their feet in tea leaves. Under the new Constitution, they wore shoes. Under the old Constitution, they wore the maulo. Now they wear clothes like other civilized people. Under the old Constitution, they sheltered their heads under palm leaves. Now they wear hats, and moreover, this was his Constitution. Were hats and shoes good, bad, or simply inevitable? At the time, Liliuokalani was away on a 4-month voyage. In England, she met with Queen Victoria, who kissed her on the forehead. When she left, her brother's 4-member cabinet included 3 Native Hawaiians. When she arrived home, days after her brother signed the Bayonet Constitution, his cabinet consisted entirely of white men who were members of the Hawaiian League. Among them, only Lauren Thurston had been born in Hawaii. She later wrote that the Haole conspirators had forced the king, without any appeal to the suffrages of the people, to sign a constitution of their own preparation, a document which deprived the sovereign of all power, made him a mere tool in their hands, and practically took away the franchise from the Hawaiian race. As heir apparent, she began considering what she might do by way of amendment. Could she alter? Could she abolish? Kalakaua died in 1891, and Liliuokalani ascended to the throne, inheriting the Bayonet Constitution. She moved into Iolani Palace, the opulent residence built by her brother. The palace had electric lights installed in 1887, 4 years before the White House. Early in 1892, a debate emerged in the legislature, where the Liberal Party called for a new constitution to replace the Bayonet Constitution, this time to be sent to the voters for ratification. The Reform Party, which was responsible for the 1887 Constitution, was opposed to calling a convention. "I do not wish to be governed by dolls," said one Liberal Party leader. There was much intrigue, including an attempted rebellion by Liberals who had earlier attempted to overthrow Kalakaua and replace him with his sister. Hawaii for the Hawaiians wanted a new constitution too, one that would restore the political power of Native Hawaiians and weaken the government's ties to the United States and its control by an American oligarchy. They wrote and signed petitions, palapala hohopi'i, papers of protest, and submitted them to the Queen. Petitions poured in from every part of the islands for a new constitution, Liliuokalani later wrote. It was estimated that out of a possible 9,500 registered voters, 6,500, or two-thirds, had signed these petitions. The 34 palapala hohopi'i that survive in the archives from the islands of Hawaii, Oahu, and Maui contain some 2,000 names. The petitions from other islands appear to have been lost. In the fall of 1892, Liliuokalani and native legislators drafted a constitution that gave the Queen, rather than the legislature, the power to appoint the cabinet, established term limits for Supreme Court judges, and extended suffrage to natives and to Chinese laborers, but disenfranchised the haole. It closely resembled the 1864 Constitution. In December, by a vote of 24 to 17, the legislature had rejected her call for a constitutional convention. She decided to proclaim the Constitution by fiat. On the morning of Saturday, January 14, 1893, she rode in an open carriage from Iolani Palace to the Legislative Building, where she presided over the scheduled closing of the legislative session. She then rode back to the palace, followed by dozens of members of the Hawaii for Hawaiians, marching 2 by 2 and carrying in a ribboned box a copy of the new Constitution. In the palace's blue room, she presented the document to her cabinet. "I was requested by my people to promulgate a new constitution," she said. "I want you gentlemen to sign it or to consent to it." She likely expected them to accede, as Kamehameha V's cabinet had acceded in 1864. They did not, advising her that this method of amending the Constitution was unlawful. Instead, the U.S. Minister to Hawaii, John Stevens, communicated with a U.S. naval ship, the USS Boston, in the Honolulu harbor. Stevens argued that American and Christian Caucasian people needed to take over Hawaii in order that it not be submerged and overrun by Asiatics. At his request, American forces, 164 sailors and Marines, each armed with 80 rounds of ammunition, entered the city and marched to Iolani Palace carrying the American flag. Dole, who agreed to serve as president of a newly declared republic, announced the dissolution of the monarchy and the establishment of a provisional government to remain in power only until Hawaii became part of the United States, which they expected to happen swiftly. "The Hawaiian pear is now fully ripe, and this is the golden hour for the United States to pluck it," wrote Stevens in a letter back to Washington. Seeking to avoid bloodshed, the Queen yielded, but insisted that a legal review would support her claim that she remained the constitutional sovereign of the Hawaiian Islands. She stitched this turn of events, too, into the center of her quilt. Dethroned, January 17, 1893. Hoping to return to power, Liliuokalani sought the support of both the American president, Grover Cleveland, and the U.S. Congress. In the American press, she faced caricatures that brought together tropes used to demean both indigenous Americans and people of African descent. A New York newspaper described her as the debauched queen of a heathenist monarchy, where those who wished to make Honolulu a center for the manufacture and distribution of opium lie together with the lewd and drunken majority of the native race, who live largely by the lucrative prostitution of their females to the wifeless Chinese and Japanese. The February 1894 cover of Judge magazine depicted her as a cannibal who sought the support of Cleveland, but had the real aim of beheading Dole. In Congress, Alabama Senator and chair of the Senate Foreign Relations Committee, John Tyler Morgan, recommended annexation. Morgan, who had been a brigadier general in the Confederate Army, urged Lorne Thurston to take 1,000 Confederate soldiers to Hawaii, and he would be sure of victory. In an 1,176-page Senate report, Morgan damned the Queen as having attempted to grasp absolute power and destroy the Constitution and rights of the white people. Nevertheless, Congress refused to approve of an annexation treaty, removed Stevens from his position, and instructed his replacement to restore Liliuokalani. The president disavowed the rebellion, calling it a substantial wrong. Kumu kanavai aka hapa uuku. Once it became clear that the United States would not immediately annex Hawaii, the leaders of the provisional government realized the need to form a permanent government, fearing that if they were removed from power, they would be charged with treason for having toppled the Queen. They began planning for a constitutional convention and preparing a constitution for a republican rather than a monarchical government. For a model, they looked to the states of the former Confederacy, where no redemption constitution was more influential than Mississippi's Jim Crow constitutionalism's founding document. I enclose extracts from the present Constitution of Mississippi, which is said to have the effect of disenfranchising a majority of the Negroes of that state, a member of the Hawaiian League wrote to Dole from Washington near the end of 1893. Lorne Thurston, too, now serving as Hawaii's minister to the United States, urged Dole to model the new Constitution on the Constitution adopted by Mississippi in 1891. Mississippi's Constitution had spread across the South. Now it crossed the Pacific. In preparing for its 1894 Constitutional Convention, Hawaii's provisional government decreed that the 19 members of its executive and advisory councils would automatically be included in the convention's 37 delegates, and that anyone hoping to vote for the remaining 18 spots would have to meet strict eligibility requirements and swear their fidelity to the provisional government and their opposition to the restoration of the monarchy. No Chinese or Japanese, groups that together made up more than half of Hawaii's population and who had been granted suffrage in the 1852 Constitution and denied it in 1887, would be able to vote for delegates. Then, too, the men who are clamoring for a government of the people proposed to bar out Hawaiians altogether, one missionary wrote home to Boston. No one was allowed to vote who would not swear to oppose the restoration of the monarchy. Having brooked no dissent, the results of the elections in May could have been predicted. Of the 37 delegates elected, 18 were U.S. citizens, and only 6 were Native Hawaiians. One purpose of establishing a new constitution was to meet a set of standards for annexation to the United States, which required a republican form of government. Mississippi's constitution provided a model because it theoretically met that standard while also imposing such elaborate new burdens on voters as to establish a white-only electorate. Dole, as president of the convention, said in his opening address that the point of rewriting the Constitution was to more fully introduce the principles of representation by the people. To that end, Chinese Hawaiians, led by merchant Gu Kwai and rice planter Wang Kwai, submitted a petition to the convention asking that they be regarded neither as a proscribed race nor in the same light as our fellow countrymen in the United States, and instead be granted the franchise. Female suffragists from the Hawaii chapter of the Women's Christian Temperance Union submitted a petition supporting restricting suffrage by property and education, but lifting a restriction introduced into the 1852 Constitution that restricted voting to men. While the convention was meeting, the territory's former Attorney General, William N. Armstrong, who had traveled around the world with King Kalakaua in 1881, published in a Honolulu newspaper an article called The Effect of the Alien, remarking on the nature of this constitutional moment. We have before us this grave and extraordinary proposition that we, about 1,000 Anglo-Saxons and Teutons, shall govern, and govern wisely if we can do so, about 80,000 aliens in blood. By aliens, Armstrong meant not Americans or Europeans, but Asiatics, Chinese and Japanese. The new Constitution simply could not be democratic because these aliens could not possibly participate in representative government. If we attempt to govern these aliens through a simple republican form of government, he warned, they will soon get the best of us. To guarantee white rule, he recommended 2 forms of government, one for ourselves and another by which the whites can rule natives, Chinese, Japanese, and Portuguese. This, he suggested, would have been the best way to handle the problem in the United States, too, instead of the flawed policy of Reconstruction. In dealing with the Negro, the government of the United States simply produced social anarchy in the South, Armstrong wrote. The model to adopt in Hawaii, he suggested, was not Reconstruction, but federal Indian policy, under which the U.S. government has the same absolute power over some thousands of Indians that we hold and intend to hold over the Asiatics. Notwithstanding Dole's stated commitment to the principle of representation, the delegates acted on neither the Chinese nor the female petitions, instead banning Chinese and Japanese men from voting by decreeing that no one from a country that did not have treaty relations with Hawaii could vote, and barring all women from voting by limiting the franchise to men. Then, to bar Native Hawaiian men from voting, the Constitution imported the methods deployed in the Jim Crow South, including the addition to the Constitution of an understanding clause. As in Mississippi, the possession of property was to be used as a proxy for mental qualifications, but more precise restrictions were deemed necessary as well. Anyone attempting to vote had to own property, be employed, and have renounced the monarchy. More, he had to be able understandingly to read, write, and speak the English language, and intelligently to explain, in his own words, in the English language, the general meaning and intent of any article or articles of this Constitution. The very language of the Constitution became a mechanism of disenfranchisement. The Constitution was not submitted to the people for ratification. No elections were held. There will be no election, Dole to be proclaimed president of Hawaii without a vote, a New York newspaper reported on July 1, 1894. The next day, the editors of the Hawaii Holomua, or Progress, published a solemn protest against the new Constitution and Mr. Dole's Republic. They denounced the Constitution as having been framed by aliens, meaning whites, declared the forced abdication of the Queen and the founding of the provisional government as the results of a most contemptible conspiracy, and described Dole as an oath-breaking ex-judge who now masquerades as a president of a republic. 2 days later, on the 4th of July, the provisional government announced the ratification of a new Republican Constitution and the formation of the Republic of Hawaii, Mississippi, in the Pacific. I proposed to make certain changes in the Constitution. What happened in Hawaii would influence American constitutional development throughout the Progressive era. Few corporations were bigger or drew more of the ire of progressive reformers than the Sugar Trust, that in the 1890s was built from wealth extracted from Hawaii, Native Hawaiians, and Chinese and Japanese immigrants. It was in an attempt to defeat conglomerates like the Sugar Trust that American progressives would seek change first in Congress, then in the Supreme Court, and finally by amending the U.S. Constitution. At the same time, what happened in Hawaii also drew from constitutional practices in the United States that had dispossessed Indians of their land and forced them to assimilate, stripped women of political power, deprived the poor of the right to vote, and denied the citizenship of, and failed to provide equal protection of the laws to, people of African and Asian descent. In Hawaii, these practices were stitched together like the pages of a book, from Georgia's treatment of the Cherokee in the 1820s and 1830s to Mississippi's treatment of African Americans in the 1880s and 90s, dismantling an indigenous government by requiring the adoption of a written constitution as a means for an assertion of sovereignty, and then ignoring that sovereignty and taking over the government anyway to erect a new government that was Republican in name only. But in Hawaii, there was an added dimension, the toppling of a monarchy, a queen who had been recognized by governments around the world and who had even had an audience with the Queen of England. No darker cloud can hang over a people than the prospect of being blotted out from the list of nations, wrote Liliuokalani. No grief can equal that of a sovereign forcibly deprived of her throne. On the night of January 2nd, 1895, a band of Liliuokalani's supporters received shipment of some 300 Winchester rifles from San Francisco and hid them in caves in Waikiki. They were preparing for the opening battle of a civil war with the aim of ousting the oligarchy. 3 nights later, the plot was discovered and defeated. Liliuokalani would stitch in her quilt, "Uprising." January 6, 1895. 123 men were arrested and detained as prisoners of war. The government declared martial law and proceeded to arrest another nearly 300 men and women, including all newspaper editors who had supported the Queen, and held them as political prisoners. 175 were charged with treason and faced execution. Most of the rest were charged with misprision or knowledge of and complicity with treason. Among these was Liliuokalani. Her Majesty Queen Liliuokalani, imprisoned at Iolani Palace, January 17, 1895. We began this quilt there. When troops searched her residence at Washington Place, they found a cache of weapons buried beneath the flower beds in her backyard, including 34 rifles, 11 pistols, 1,000 rounds of ammunition, and 21 homemade bombs. Inside, authorities opened her safe and removed all the documents it contained, including her diaries and the petitions demanding a new constitution. They also found a note in Liliuokalani's handwriting titled, "Course to Pursue on Hearing News of the Restoration." Appoint cabinet ministers, proclaim the new government and declare martial law, issue warrants of arrest for all dangerous people and such annexationists who are considered dangerous to the safety and peace of the community and the public in general. Issue notice for the return of all firearms, guns, and ammunition to the government. She was arrested. 170 of the 175 political prisoners were tried at a military tribunal. Most were sentenced to hard labor. 6 were sentenced to be hanged. Liliuokalani was told that their lives would be spared if she would abdicate the throne. She agreed. Her Majesty Queen Liliuokalani abdicated on 24th of January, 1895. At her 3-day trial in February, she disputed the government's right to try her and refused to enter a plea. "The only charge brought against me, really, was that of being a queen," she later wrote. In lieu of a defense, she wrote a statement in Hawaiian. In the year 1893, she read, "I propose to make certain changes in the constitution of the Hawaiian Kingdom, which were suggested to me as being for the advantage and benefit of the kingdom and subjects and residents thereof." Her cabinet then said they would not support those changes, whereupon a minority of the foreign population made my action the pretext for overthrowing the monarchy, and aided by the United States naval forces and representative, established a new government. Found guilty of misprision of treason on February 27th, she was sentenced to 5 years hard labor, a sentence, she wrote, whose sole present purpose was to terrorize the native people and to humiliate me. Instead of being sent to prison, she was confined in an upper room of what had been the royal palace, but had been dubbed by the Republic the Executive Building. She stitched her quilt. She wrote Malay. They were smuggled out of the palace and published in the newspaper. "This is your offense, Kalani. It is because of your love for your people." Her followers published Malay, too, in a kind of call and response. "We back Liliuokalani. She will be crowned again. Tell the story of the people who love their land." 8 months later, she was pardoned and released. She went to Washington in exile to plead for her restoration and to argue unsuccessfully against the annexation of Hawaii. For years, she lived in Boston. In 1897, President McKinley signed a treaty of annexation and sent it to the Senate. Nearly 30,000 people, more than half the native population of Hawaii, had signed a petition objecting to annexation. The United States initially voted down the annexation treaty, but after the Spanish-American War broke out early in 1898, it changed course and approved the treaty that July. The U.S. policy of Chinese exclusion now extended to Hawaii, and under the terms of the treaty, no Chinese in Hawaii were allowed to emigrate to the mainland. The treaty was never submitted for approval to the people of Hawaii. At Iolani Palace, the Hawaiian flag was lowered and the U.S. flag raised. Upon annexation, the U.S. government seized the so-called Crown lands, all the territory in Hawaii claimed by the Crown on behalf of the people. Liliuokalani wrote in her diary, "My love for my birthland and my beloved people, bones of my bones, blood of my blood, aloha, aloha, aloha." Under the terms of the treaty that ended the war with Spain, the United States gained the Philippines, Puerto Rico, and Guam, and Spain ceded its claim to Cuba. 2 years later, the United States acquired Eastern Samoa, and in 1903, the territory in Panama on which it would build a canal. In 1915, the United States would invade Haiti. Liliuokalani became the most eloquent opponent of the establishment of an American empire. Perhaps there is a kind of right, depending upon the precedents of all ages, and known as the right of conquest, under which robbers and marauders may establish themselves in possession of whatever they are strong enough to ravish from their fellows, she wrote bitterly. American imperialism in the Caribbean and the Pacific, spurred as much by business interests as by foreign policy, extended the nation's reach while compromising its commitment to a republican form of government. Congress had no interest in admitting Hawaii as a state, given that it would enter the Union with a majority non-white population. Other islands remained territories too. Asked Liliuokalani, the monarch to the democracy, is the American Republic of States to degenerate and become a colonizer and a land grabber? Would the Republic become an empire, or had it already become one? Millions of black and brown people. Liliuokalani was hardly alone in asking this question. In the 1890s, Americans, too, pointed out the incompatibility of republicanism with imperialism, and they asked other questions as well. What force might compel the United States to honor its constitutional guarantees of a republican form of government and equal protection and due process regardless of race? Not the Supreme Court. In 1898, in United States v. Wong Kim Ark, the court ruled that children born in the United States to Chinese immigrants are American citizens under the terms of the 14th Amendment's birthright citizenship clause. But more often, the court, Congress, and the states denied the full immunities and privileges of citizenship to people of color. Plessy v. Ferguson, the 1896 case in which the court established its separate but equal doctrine, would cast a shadow more than half a century long. What force, then, could counter the court? Constitutional amendment. But constitutional amendment is not available to minority populations whose rights are supposed to be protected by the court. W.E.B. Du Bois had an idea. He suspected that the addition of more people of color to the population of the United States, whether through immigration or naturalization or even through territorial annexation, would aid the cause of racial equality. Demography was on the side of justice, he believed. If people of color were to become a single political constituency, they could win rights. Black Americans must seek an alliance with the masses of dark men and women who inhabit the new lands acquired or conquered by the United States, Du Bois argued in 1899. We must remember that the 20th century will find nearly 20 millions of brown and black people under the protection of the American flag, a third of the nation, he said, and that on the success and efficiency of the 9 millions of our own number depends the ultimate destiny of Filipinos, Puerto Ricans, Indians, and Hawaiians, and that on us, too, depends in a large degree the attitude of Europe toward the teeming millions of Asia and Africa. This view, which would find expression at a conference of Asian and African peoples in Bandung, Indonesia in 1955, was not a view shared by the deposed Queen of Hawaii at the turn of the 20th century. Liliuokalani left for Honolulu in 1900. For years, she tried to regain control of the Crown lands. She wrote letters, she courted Congress, she sued the U.S. government. She saw little to be gained for the people of Hawaii in being classed with Filipinos or Puerto Ricans, and especially not with North American Indians. In pleading her case to Congress and the American public, she complained that the people of the islands have no voice in determining their future, but are virtually relegated to the condition of the Aborigines of the American continent. In assessing that situation, she was not wrong. The condition of indigenous peoples living within the continental United States was changing, but not for the better. Like Native Hawaiians, their sovereignty depended on the willingness of the United States to honor it, a willingness not to be relied on. Their treaties with the federal government were what James Madison would have called mere parchment barriers to American settlement and land acquisition. And their rights under the U.S. Constitution were very few and dwindling. They had no voice in drafting that constitution, and they had no means to amend it. Nevertheless, as the 20th century began, even as Liliuokalani continued to fight the federal government, Indians in what became the state of Oklahoma would produce one of the most influential constitutions in American history. Grand and great, the future state. At the turn of the century, Indian Territory remained a territory, if vastly diminished in size. At its establishment, it had comprised about a third of what is now the continental United States. In 1890, it was shrunk to the eastern half of what is now the state of Oklahoma. The western half became the Oklahoma Territory. The promise made at the establishment of Indian country as an unorganized territory in 1834 had always been that it would one day enter the Union as an American state. This promise had not been kept. The strategy of defending tribal sovereignty by adopting a written constitution, first tested by the Cherokee Nation in 1827, after the Cherokee sage Sequoyah had devised a written syllabary for the Cherokee language, had halted neither the federal government's seizure of Indians' lands, nor their forced removal, nor the waging of wars of conquest against them. But in 1898, under the Curtis Act, Congress placed the previously exempted 5 tribes under the land allotment provisions of the Dawes Act, an Indian territory under U.S. law, dissolving tribal courts, tribal governments, and tribal land claims. This change was scheduled to go into effect on March 4, 1906. Meanwhile, traditionalists fought to preserve tribal government, insisting that they already operated under fundamental law, their own fundamental law. The Creek leader Chito-Harcho, or Crazy Snake, renounced any authority of the federal government over the Creek Nation and set up an independent government in Hickory Ground with as many as 5,000 followers. In 1900, he declared the Creek chief Pleasant Porter deposed for his cooperation with the Dawes allotment scheme. The next year, Harjo and 252 of his followers, about 1 in 10 Creek men, were arrested and indicted for conspiracy, charged with the crime of having willfully and feloniously formed a certain government purporting to be the legal and lawful government of the Muscogee tribe of Indians. They pleaded guilty and in a statement insisted on having been, as citizens of the Creek Nation, opposed to the abolition of our courts by any act of Congress and to any change in our tribal form of government. All were eventually pardoned. They had been prosecuted, in effect, for constituting themselves by an act of consent into a government. In 1902, white leaders in Oklahoma Territory began planning to seek admission to the Union as a new state, Oklahoma, that would absorb Indian Territory. Indians would comprise a minority. The non-traditionalist chief, Porter, undertook to do what Harjo could not. Porter and 2 other chiefs, William C. Rogers, Cherokee, and Green McCurtain, Choctaw, held a conference to make plans to seek entry to the Union as a separate Indian state. They formally insisted on their right to form a government. As McCurtain wrote, "In the light of our history, it would be fitting and just to permit the Indian to have a voice in the affection of at least one state on a continent to which he once lay claim." While the white Oklahomans planned for their constitutional convention, Porter, McCurtain, and Rogers organized their own constitutional convention to be held in Muscogee on August 21, 1905. They suggested that if white Oklahomans wanted to be part of a single state, they were welcome to join the Indian one and submit to a constitution framed by Indian Territory representatives. The convention organized by Porter, McCurtain, and Rogers met for 60 days. The Chickasaw refused to participate, their chief stating, "In my judgment, the time has not arrived for the Indians to say they want statehood, and for this reason I will not officially or personally participate in the proposed convention." The Constitution its delegates devised in many ways resembled other state constitutions of the era. It included a Bill of Rights, proclaimed federal supremacy, and guaranteed the people the right to alter and abolish the Constitution. But it also included a number of distinctly new features, the very kinds of reforms that North Carolina Supreme Court Justice Walter Clark had called for in 1898 in urging a wholesale revision of the U.S. Constitution. All judges were to be elected. Corporations and banks were to be regulated. Workers were to be protected. Child labor was to be banned, and free public education was to be provided. At the close of the convention, the delegates approved it unanimously, Porter declaring it the belated fulfillment of a promise. From time immemorial, the Indians, as a heritage of the original inhabitants, have been promised a state, an empire of their own. There had been some debate about what to call this new state, this first Indian state. Contenders included Indianola or Tecumseh, but in the end, the decision was made to honor the inventor of the Cherokee syllabary. As a poem in the Cherokee Advocate put it, "Yes, grand and great, the future state should bear Sequoia's name." Ratification of the Constitution for the new state of Sequoia required the approval by referendum of the national councils and of the electorate. The national councils of Cherokee, Chickasaw, and Choctaw approved it, the Creeks and Seminoles did not. Submitted to the people for ratification, it won approval overwhelmingly, 56,279 to 9,073. And then Congress rejected it. Instead, in January 1906, Congress accepted Oklahoma's application for statehood as a state that would simply absorb Indian territory. Its proposed constitution was a barely changed version of the Sequoia Constitution, with all its progressive social and economic provisions. Most of the delegates from Indian Territory who served at Oklahoma's Constitutional Convention had served at the Sequoia Convention, too. Vice President William Howard Taft, who traveled to Oklahoma, urged Congress to reject it. "It is no constitution at all," he fumed, complaining of its length, its complexity, and its many provisions, which he described as flavored with socialism. The populist William Jennings Bryan called it the best constitution in the United States. In the first decades of the 20th century, the principles behind Oklahoma's constitution, which was essentially the Sequoia Constitution, absent statehood for Indians, would inspire the greatest burst of federal constitutional amendment since Reconstruction. Original rights. In 1907, the Senate sent a select committee to Indian Territory to ponder the implications of the battle between the competing constitutions of Sequoia and Oklahoma. Its members met with Chito Harjo, Crazy Snake, who spoke through an interpreter. Question: Whom do you represent? Answer: The 4 mother nations have sent me here to represent them. Question: What do you mean by that? Answer: The Creeks, Cherokees, Choctaws, and Chickasaws. Question: What are you? Answer: I am here representing the 4 mother people as to our original rights. Harjo told of how Americans had once pledged to the 5 tribes that this territory would be theirs forever. "I will never stop asking for this treaty, the old treaty that our fathers made with the government which gave us this land forever," he said. "For my old fathers and your old fathers made that treaty back there on the other side of the Mississippi, and they said that this land out here was to be ours as a nation forever. And that is the treaty I want, for we are to have it as long as the grass grows, water runs, and the sun rises. We should have this land." Fundamental law is meant to bind one generation to another over time. In this case, it did not. The water ran, the grass grew, and the sun rose, but the law by which the Creek constituted themselves did not last. Crazy Snake's speech is an origin story, a constitutional origin story. It is also a story about land and water, mountains and sky, humans and the natural world, ideas absent from the U.S. Constitution, but present everywhere in indigenous lawmaking, ideas that a century later would reemerge in an environmental legal movement that would seek to grant rights to nature. In 1893, when Liliuokalani was imprisoned, she had translated a Hawaiian origin story into English. At the time that turned the heat of the earth, at the time when the heavens turned and changed, at the time when the light of the sun was subdued to cause light to break forth, at the time of the night of the winter, then began the slime which established the earth, the source of deepest darkness. It was a tale of birth and rebirth. The seas spread, the land spread, the waters spread, the mountains spread. Ideas spread too, from a tropical island on a volcanic archipelago in the Pacific to the prairie grasses of Oklahoma, and even to the banks of the Potomac. In 1910, In Liliuokalani v. the United States, the deposed queen lost her suit over the crown lands. Her health declined, then plummeted. She began to suffer from dementia. For years, she scarcely knew where or who she was. In the summer of 1917, schools of red fish were seen in the harbors of Maui, an ancient portent of the death of an alii. A death watch began. In November, Lydia Kamakaea Liliuokalani, the last monarch of Hawaii, succumbed. The coming of death was almost imperceptible, a newspaper reported. So weak had been the queen for many hours, so slender the thread of life to which she still clung with amazing vitality. No one stitched with golden threads the last chapter of her reign. Liliuokalani died 11th of November, 1917. But on the day she died, the bells at a Honolulu cathedral tolled 79 times, one for each year of her life. 1 week later, a state funeral was held in the very room in the palace where, so many years before, she had once been held prisoner and had stitched a quilt. And as her casket was paraded through the streets, the people chanted and wailed and keened and sang, "Aloha Oe." The heavens turned, wars were won and lost, constitutions were written and rewritten. A republic became an empire, and once more a republic. The grass grew, the sun rose, the seas spread, and the waters ran red with blood. Part 3. The Pattern of Amendment, 1905 to 1959. We favor such amendment to the Constitution as may be necessary to provide for the election of all federal judges, without party designation, for fixed terms not exceeding 10 years, by direct vote of the people. Progressive Party Platform, 1924. At the unruly suffrage parade held in Washington on March 3, 1913, the day before Woodrow Wilson was to be inaugurated on the steps of the Capitol, the marchers wore white dresses. They carried banners, they waved placards, they rode white horses, they blew horns, they walked, they came alone, they came together, they numbered 5,000. They came with their state delegations, they came with their labor unions, they came with their classmates, in gowns and caps, marching behind their college banners. They marched as teams, librarians, lawyers, nurses, and teachers. There were more than 20 floats. Teams of horses pulled carriages carrying giant banners of yellow silk trimmed in white, with purple letters announcing the Great Demand. We demand an amendment to the Constitution of the United States enfranchising the women of this country. They were attacked, taunted, tripped, beaten, and spat on, chiefly by well-dressed men in suits who flooded out of office buildings. More than 100 injured women were carried to the hospital. The marchers locked arms and marched on. 28-year-old Alice Paul, who had recently completed a doctoral dissertation on the legal status of women, choreographed the procession with a single objective. "We are marching to start a nationwide movement for a constitutional amendment," she told the Washington Post. Most of the marchers were white, but black women marched too. A 25-woman delegation from Delta Sigma Theta sorority from Howard University marched. Ida B. Wells, leader of the anti-lynching movement, came from Chicago, where she'd founded a black women's suffrage club. Told by Paul to march with a segregated black section of the parade, Wells refused. She marched instead with the otherwise all-white delegation from Illinois. They marched down Pennsylvania Avenue and halted at the Treasury Building, where they posed in a tableau around a suffragist dressed as Liberty, as if she were Anne Willing Bingham, painted by Gilbert Stuart in 1797. Woodrow Wilson, who was born in Virginia and grew up in Georgia, was the first Southerner elected to the presidency since the Civil War. He was also a scholar of the Constitution and a proponent of a school of constitutional interpretation known as living constitutionalism. He did not support female suffrage, despite his commitment to constitutional change. He was also a segregationist. The NAACP's James Weldon Johnson would note grimly, that Wilson bears the discreditable distinction of being the first president of the United States since emancipation who openly condoned and vindicated prejudice against the Negro. Wilson completed his Ph.D. in 1886. Living constitutionalism had by then become canonical. Our real Constitution, an American civics textbook explained that year, is found in the interpretations which the courts have given to the written documents and the actual institutions which have been established under them. Wilson planned a great work, a history of government in all the civilized states in the world, to be called The Philosophy of Politics. The history of government, he argued, was the story of the adaptation of old means to accomplish new ends, a history of progress. He was an adopter of a political persuasion that came to be known as progressivism. Beginning in the 1890s, the progressive spirit straddled both the Republican and Democratic parties and animated surprisingly vital third parties, two: the People's Party, the Progressive Party, and the Socialist Party. The progressive agenda centered on expanding the power of the federal government to regulate the economy and relations between labor and capital, and to restrain the power of corporations. These goals required constitutional changes to which a great many people objected, including a deeply conservative Supreme Court. Progressivism can be understood as an attempt, as the editor Herbert Crawley explained, to overthrow the monarchy of the Constitution. The progressive era renewed the American philosophy of amendment. The Constitution had become amendable again. To progressives' eyes, not amendable enough, and to the eyes of conservatives, far more amendable than it was ever intended to be. In 1890, Wilson was named chair of jurisprudence and political economy at Princeton, where he wrote a 5-volume History of the American People. Beginning in the 1890s, while he toiled on his philosophy of politics, a conservative Supreme Court overturned laws passed by Congress that were designed to address the social and economic dislocations of the Gilded Age, the rise of the trusts, the ruthless exploitation of workers in factories and on the railroads, the failure of farms, the abject poverty of immigrants, the financial panics wrought by reckless speculators and bankers, the ceaseless strikes called by unions. Most infamously, in 1895, in Pollock v. Farmers Loan and Trust Company, the court struck down the 1894 Income Tax Act, which had taxed income, interest, corporate profits, and inheritance by reading the 1894 income tax against the records of 1787. We regard the conclusion reached as inevitable, the court wrote, when the circumstances which surrounded the convention and controlled its action and the views of those who framed and those who adopted the Constitution are considered. Wilson devised a theory of constitutional interpretation designed to counter that position. In 1908, Wilson published Constitutional Government in the United States, in which he argued that the founders' theory of checks and balances was outdated. The trouble with the theory is that government is not a machine but a living thing, he wrote. It falls not under the theory of the universe, but under the theory of organic life. It is accountable to Darwin, not to Newton. Regretting readings of the Constitution that followed a very mechanical theory of its meaning and intention, he believed that living political constitutions must be Darwinian in structure and in practice. 2 years later, he'd resigned from the presidency of Princeton to run for governor of New Jersey, and 2 years after that, he'd been elected president. With the exception of Donald Trump, no other American has ever gone from private life to the White House in so short a time. Suffragists thought the time had come at last for the amendment first proposed by Susan B. Anthony in 1878. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. The Constitution had not been amended since 1870, but in 1912, to reverse the court's decision in Pollock, Congress passed an amendment granting Congress the power to tax personal incomes, and in February 1913, it was ratified as the 16th Amendment. In his inaugural address on March 4, 1913, the day after the suffrage parade, Wilson declared that it was the obligation of the federal government to regulate the economy to protect ordinary Americans from the consequences of great industrial and social processes which they cannot alter, control, or singly cope with. A new era of American constitutionalism had begun. Amending state constitutions was becoming easier to do. By 1913, constitutional amendment could be enacted by a simple majority vote at the polls through the new direct democracy devices of the initiative and the referendum in 11 states: Arizona, Arkansas, California, Colorado, Michigan, Missouri, Nebraska, Nevada, Ohio, Oklahoma, and Oregon. In the spring of that year, the states ratified the 17th Amendment, mandating the popular election of senators, where before they'd been elected by state legislators. And even this was not the last amendment headline of 1913. In December, the Anti-Saloon League and the Women's Christian Temperance Union joined forces to hold a parade in Washington, an anti-rum army, urging Congress to pass, at last, a prohibition amendment. 1913 was conservatives' annus horribilis. On top of everything else, it was the year the historian Charles Beard published An Economic Interpretation of the Constitution, history written in the spirit of a muckraker, arguing that the framers had been interested above all in protecting their own wealth. Scavengers, hyena-like, desecrate the graves of the dead patriots we revere, read a story about Beard's book, published in an Ohio newspaper by the future president, Warren G. Harding. 4 federal constitutional amendments were ratified between 1913 and 1920, an unprecedented surge except for the adoption of the Bill of Rights. Wilson did not change his position on female suffrage until his campaign for re-election, after suffragists paraded with a donkey named Woodrow, carrying on its back a sign that read, "It means freedom for women to vote against the party this donkey represents." But women finally achieved the right to vote with the ratification of the amendment in 1920. The struggle, like so many struggles, had seemed interminable. To get the word male in effect out of the Constitution cost the women of the country 52 years of pauseless campaign, said Carrie Chapman Catt. That's also about how long it took to get the word white out of state constitutions. And then the Article 5 giant slept once more. In the 1920s, 2 more efforts failed. The Equal Rights Amendment, introduced in 1923, with hardly any prospect of success, and the Child Labor Amendment, sent to the states for ratification in 1924. By the end of the 1930s, after an extraordinary face-off between the executive and judicial branches of the federal government, New Dealers would turn decisively to the Supreme Court to effect constitutional change. So would the Civil Rights Movement. In the 1950s, with the Supreme Court's momentous 1954 decision in Brown v. Board of Education, this strategy would yield long overdue results, but would also unsettle the nation's constitutional balance. There would be still more marching on Washington. But Americans' divided assessment of the court and of its methods of constitutional interpretation would take on a new temper, and during the Cold War, a new theory of constitutional interpretation would begin to take form. A search for the framers' original intentions. Chapter 8. Mr. Constitution. Your memorialist most earnestly and respectfully asks that Congress pass an act calling for a convention. Failed call for a constitutional convention submitted to Congress by the Oregon Legislature, 1903. James Montgomery Beck, Mr. Constitution, was born, as only seems fitting, in Philadelphia. A lawyer, a writer, and briefly a member of Congress, he wore a pince-nez and a bow tie and a straw boater, as if he were a character out of a P.G. Wodehouse novel, an Edwardian dandy, Sir Raymond Bastable, or a partner in the firm of Bowles, Widgery, and Bowles. The Honorable J.M. Beck loved England, and, Pecksniffian in a barrister wig, was the first foreigner to argue a case before the Privy Council. He had a penchant for quoting Shakespeare. He appeared on the cover of Time magazine in its first year, 1923, when he was the U.S. Solicitor General. He could often be heard on the radio, denouncing the American people for wishing to amend the Constitution, as if this were an act of blasphemy, or aggravated battery. Beck is the grandfather of modern constitutional conservatism, which was founded on opposition to constitutional change of any kind, whether by judicial interpretation or by amendment. The position of latter-day originalists that amendment is the proper mode of constitutional change would have scandalized him. Beck's Constitution was perfect. Born in 1861 in the shadow of the Civil War, Beck began practicing law in 1884. It was an age of corporations and monopolies and trusts, giant conglomerations of companies and of wealth, steel, coal, oil, railroads, and sugar. It required a great deal of lawyering. In 1890, Congress passed the Sherman Antitrust Act, which banned combination in the form of trust or otherwise, or conspiracy that was in restraint of trade or commerce among the several states or with foreign nations. The age of trusts was also the age of trust busters. This required even more lawyering. Beck represented the trusts. He was pro-trust. He believed the Antitrust Act was unconstitutional. He championed industry and finance. He felt Wall Street was unfairly maligned for avarice. He despised muckrakers. He served as general counsel for the American Sugar Refining Company. He defended Standard Oil. If someone was trying to bust your trust, Beck was the man to call. Beck believed that most attempts to amend the Constitution were driven by foreign ideologies that had been brought to the United States by immigrants from Eastern Europe, statism and socialism, fiendish notions that betrayed the nation's founding ideals of individual rights and free markets. He often wondered when it had begun, the great fall, the great decay of constitutional fidelity. He had in mind one particular day, September 17th, 1887. He'd been 26 then, living in Philadelphia, when the city celebrated the Constitution's centennial with a military parade overseen by President Grover Cleveland. That day, Beck had been deeply stirred as the best of men made speeches that acclaimed the wisdom of the Constitution and showed a spirit of joyous optimism that its future was assured. But that glorious day had been America's last fine day because of the doubt, skepticism, unrest, and chaos that followed, and especially because of the strikes, railroad worker strikes and coal miner strikes and every other kind of strike. In Louisiana that year, black sugarcane workers went on strike. A sheriff's posse shot and killed 60 of them. Beck blamed labor for everything terrible that had happened to America since September 17th, 1887. It was then that the seeds of decay began their pernicious growth, he insisted. It was then that the American people began to have a conception of their government which was not that of the Constitution, but that of a unitary socialistic state. Not long afterward, Beck began to put his constitutional conservatism into practice by representing the trusts and defending American imperial expansion. In 1892, the American Sugar Refining Company acquired the E.C. Knight Company and 3 other smaller refining companies, leading it to control 98% of the American sugar processing industry, much to the consternation of progressive reformers. The government sued, arguing that these acquisitions granted the company nearly complete control of the manufacture of refined sugar in the United States, in violation of the Sherman Antitrust Act. In an 8-1 decision in 1895, the Supreme Court found in favor of the Sugar Trust, holding that refining is a local process and that federal control over interstate commerce was not intended by the framers of the Constitution. The decision greatly weakened the Antitrust Act. Later that spring, in an even greater blow to progressive reformers, the court handed down its 5-4 decision in Pollock v. Farmers Loan and Trust Company that struck down the federal income tax, again citing the intention of the framers. The American Sugar Refining Company, later Domino Sugar, processed sugar in the United States, especially at a sprawling complex along the East River in Brooklyn, New York. It imported sugarcane for processing from Hawaii, Cuba, and Puerto Rico. Its interest lay in the conquest, acquisition, and annexation of these territories. Sugar comprised 93% of Hawaii's export business. 22 of the 33 men who plotted the overthrow of Queen Liliuokalani in 1893 owned sugar stock, including Lauren Thurston, who led the plot. The Progressive-era historians Charles and Mary Beard James M. Beck's nemesis, argued that it had been mainly sugar that had precipitated the crisis that led to Liliuokalani's removal and the annexation of Hawaii in 1898. In 1901, the first civilian governor of Puerto Rico left his position, and having overseen the dismantling of the island's many crops in favor of the monoculture of sugar, the yield of sugar per acre is greater than in any other country in the world, returned to the United States, where he became first the treasurer and then president of the American Sugar Refining Company. None of these facts concerned James M. Beck, an avowed imperialist. In a speech in 1898, he invoked America's destined world supremacy. In 1900, as Assistant Attorney General, he argued that the United States had the power to rule Cuba. Neely v. Henkel was the forerunner of what became known as the Insular Cases, which limited the applicability of the Constitution in U.S. territories. Beck won. What did concern Beck was the federal government's opposition to conglomerations during the presidency of Theodore Roosevelt. In Beck's capacity in Roosevelt's Justice Department, he was compelled to become a trust buster, which he did not like, and so in 1903 he resigned. The next year, he represented Standard Oil when it was sued by the Bay State Gas Company. A muckraker denounced Beck, calling him counsel and chief orator for the Standard Oil Company and the system, after which Beck, in a speech to the New York State Bankers Association, accused progressives of money phobia. In 1905, in Lochner v. New York, the Supreme Court overturned a maximum hours law in New York that prevented bakers from working more than 10 hours a day or 60 hours a week. The court argued that the law violated the 14th Amendment's guarantee of due process. The right to purchase or to sell labor is part of the liberty protected by this amendment unless there are circumstances which exclude the right. Although not expressly mentioned in the text, the court argued that deducible from it is a liberty of contract. Beginning with Lochner, a conservative Supreme Court played a kind of constitutional dodgeball with progressives. In a line of cases involving the constitutionality of labor laws and what was sometimes called social legislation, the court knocked down progressive initiatives, thus driving progressives into the arms of Article 5. Beck celebrated the liberty of contract in a 1917 brief as one of the most sacred rights guaranteed by the Constitution, and upon it the amazing edifice of American industry has largely been built. In the 1900s, he wrote some 200 unsigned editorials for the New York Sun, whose parent company he represented, and denounced Theodore Roosevelt as a cross between a harebrained fanatic and a conscienceless demagogue. He appears to have begun investing in sugar by 1905. He became a general counsel for the American Sugar Refining Company in 1909, at a time when it was the subject of both another anti-monopoly suit and a fraud investigation. He represented the Sugar Trust for nearly 7 years. Twice he defended the company in cases before the Supreme Court. As Beck saw it, the assault on the Constitution had started with the labor movement. Then came socialism, the busting of trusts, the flood of immigrants, the Reds, and Bolshevism. All hell broke out during the New Deal. But for Beck, looking back at the end of his life, it seemed clear that the fatal turning point had come not in 1887, but in 1913, with the ratification of the 16th Amendment, which, nullifying Pollock v. Farmers Loan and Trust Company, granted Congress the power to tax incomes. Possibly it did more to destroy our form of government than any single cause except the impact of a mechanical civilization, Beck wrote. And yet Americans, he feared, had barely noticed. It was as if they were passengers on the good ship Constitution. The Titanic had sunk in 1912. Beck loved nothing better than a metaphor. The good ship Constitution was the Titanic, and the 16th Amendment, the iceberg. And yet, even as the ship crashed into that iceberg, the passengers took no notice. They continued to play cards and dance in complete ignorance that they were doomed, Beck wrote. The water began pouring into the hold. The great hull groaned. Deck chairs skittered across polished wooden planks. And alone, James Montgomery Beck bailed out the water, bucket by bucket. the House of Dollars. By the beginning of the 20th century, women suffragists, Christian amendmentists, and indefatigable prohibitionists had for decades been seeking federal constitutional amendments by way of moral crusades and congressional petitions. They had enjoyed very few successes. James Beck did not like these crusaders or their crusades, but he found them no threat. There seemed to be very little chance that any of them would ever succeed. What riled Beck was a new spirit of amendment, call it amendment pragmatism, that animated the progressive movement. Progressives applied to an agenda forged by a populist movement of farmers and factory workers the tools of modern bureaucracy and the influence of experts. They wanted to restrain monopolies, regulate the economy, protect workers, and advance direct democracy through mechanisms like the initiative and referendum and the election and recall of judges. They began their constitutional revolution in the states. Between 1889 and 1908, every state except Wyoming and Tennessee amended its constitution. Most implemented reforms along the lines of the measures proposed by the Sequoia Constitution in 1905 and adopted by Oklahoma in 1906. Attempts to deal with the problems of industrial society, often in painstaking detail. Oklahoma's 1906 Constitution established an 8-hour day for public employees. It banned child labor. It granted women the right to vote, at least in certain elections. It was also prodigiously long and contained a great deal that could scarcely be said to belong in a constitution. A subsection prohibiting railroads from providing free tickets to employees ran to nearly 400 words. Progressives wanted to make the process of amendment easier and to place it more directly in the hands of voters. Their work began with proposals for gateway amendments, amendments revising amendment procedures on the theory that if a genie offers to grant you 3 wishes, your first wish ought to be to ask for more wishes. State after state applied the mechanisms of initiative and referendum to the power of amendment in a process whereby, if something between 5 and 18% of voters initiated an amendment by petitioning the government, it went on the ballot as a referendum. The percentage of voters required for an initiative varied by state. Ratification was accomplished by a simple majority. Voters used this method of amendment to write not only the fundamental law, but also ordinary legislation, blurring the lines between and often confusing the two, putting into their constitutions, as Walter Lippmann complained, all kinds of rules and restrictions that, given any decent humility about the future, ought to be no more permanent than an ordinary statute. Amendments sprouted from constitutions like eyes from an old potato. In 1907, Louisiana ratified 27 amendments. In 1911, California ratified 23. In 1912, Ohio ratified 34. Progressives, like the dauntless Columbia University historian Charles Beard, approved of this spirit of amendment as a strong movement away from the Constitution. Conservatives, like James Beck, mourned it for the very same reason. Amendment pragmatism had a fusionist sensibility, bringing together the populism of the People's Party with the idea of progress written into progressivism. A constitution was the people's law, the love him or hate him populist William Jennings Bryan said in a speech before the Ohio Constitutional Convention of 1912, meeting in Columbus. Bryan, heralded as the great commoner, celebrated the initiative as the people's tool to remedy any of a constitution's defects, either of omission or commission. Theodore Roosevelt, speaking at the same event, began by paying tribute to the people's power of amendment and protesting against any theory that would make of the Constitution a means of thwarting instead of securing the absolute right of the people to rule themselves. Speeches on such occasions are, of course, so much flim-flam, but they did serve to welcome a broad range of amendments. Nor did progressives expect to stop with state constitutions. But amending the U.S. Constitution was far more difficult than amending state constitutions. And federal laws were harder to pass, too. They were especially difficult to get through the Senate. Then, too, if a progressive law did get passed, chances were good that the laissez-faire Supreme Court would strike it down. That made Article 5 more important than it had ever been before. Nothing better illustrated the nature of this constitutional blockade than the debates over the direct election of the Senate and the establishment of a federal income tax. Progressives viewed the Senate as aristocratic, anachronistic, and unaccountable. Remedying its malapportionment was banned by Article 5, which placed the states' equal suffrage in the Senate beyond the power of amendment. How senators were elected did admit of a remedy by way of amendment. The problem was, sitting senators had to agree to the change, and this they had proved stubbornly unwilling to do, no matter how many times voters had asked for this reform. First introduced in 1826, an amendment calling for the direct election of senators had been put forth repeatedly in the 1880s and 90s, with proposals mainly from the states. It had also been supported by petitions, beginning in 1867 with a petition from the Kansas legislature. Farmers and laborers, especially in the western states, demanded it. The State Grange of Illinois petitioned for the amendment. So did the Farmers Mutual Benefit Association of Indiana and the Knights of Labor of Washington, D.C. But every time the House voted for the amendment, in 1893, 1894, 1898, 1900, and 1902, the Senate voted against. To accomplish much of what they wanted to accomplish, progressives had first to wage and win a war against the Senate. They alleged that election to the Senate was chiefly accomplished by bribery and other forms of corruption. They called the Senate the House of Dollars. It is as difficult for a poor man to enter the Senate of the United States as for a rich man to enter the kingdom of heaven, one member of Congress charged in 1900, putting forth the interesting but sadly unsupportable contention that direct election by the people would make it nearly impossible for money to get a man elected to the Senate. There were indeed instances of men who bribed state legislators to earn their seats. But between 1857 and 1900, the Senate investigated allegations of quid pro quo against only 10 senators and found merit in only 3 cases. The bigger issue was the larger role of money in politics. In 1894, for instance, Henry Havemeyer, head of the Sugar Trust, was questioned by a Senate special committee to investigate attempts at bribery. The American Sugar Refining Company said paying for influence was a necessary price of doing business. And then there was the problem of the ineptitude of state legislatures, which not infrequently failed to elect anyone to the Senate at all, but instead delayed or deadlocked. Delaware, for instance, failed to send 2 senators in 1895, 1899, 1901, and 1903. Between 1891 and 1905, 8 states were without any representation in the Senate for stretches of time as long as 4 years. No senators might have been better than 1 or even 2 senators, since far too many of the men who did take their seats were willing to sell their own votes, at least according to an investigative series published in 1906 called, memorably, The Treason of the Senate. The fate of the income tax seemed also to illustrate the influence of a moneyed aristocracy. Congress had first introduced a graduated income tax in 1862 to fund the Union in the Civil War. Radical Republican Thaddeus Stevens, then chair of the House Ways and Means Committee, had declared that it would be manifestly unjust to allow the large money operators and wealthy merchants whose incomes might reach hundreds of thousands of dollars to escape from their due portion of the burden. The law established the Internal Revenue Bureau and imposed a 3% tax on incomes over $600 and 5% on those over $10,000. 2 years later, the tax on incomes over $5,000 was raised to 10%. After the war, by which time European nations were increasingly using graduated income taxes and inheritance and estate taxes as progressive alternatives to regressive tariffs and sales taxes, Ohio's John Sherman, he of the Antitrust Act, tried to stave off calls to repeal the tax in the United States. "We tax the tea, the coffee, the sugar, the spices the poor man uses," Sherman said. "We tax every little thing that is imported from abroad, together with the whiskey that makes him drunk, and the beer that cheers him, and the tobacco that consoles him. Everything that he consumes we call a luxury and tax it. Yet we are afraid to touch the income of Mr. Astor. Is there any justice in that? Is there any propriety in it? Why, sir, the income tax is the only one that tends to equalize these burdens between rich and poor." Sherman had been unsuccessful. Congress repealed the tax in 1872. But after the Panic of 1893, a depression caused chiefly by bank failures, Congress reintroduced an income tax, a 2% tax on incomes of $4,000 or more, and a capital gains tax applied to both individuals and corporations on all gains, profits, and income, whether derived from any kind of property, rents, interest, dividends, or salaries, or from any trade, employment, or vocation. Corporations raised objections to it. A lawyer for Standard Oil declared its principles as communistic, socialistic, what shall I call them, populistic as ever have been addressed to any political assembly in the world. This had been James Beck's view, too. Beck and the leaders of America's largest corporations therefore applauded when, in Pollock v. Farmers Loan and Trust Company, the court declared the 1894 income tax law unconstitutional. But Justice John Marshall Harlan, dissenting, argued that the decision subjected the American people to the dominion of aggregated wealth. And despite the sighs of relief heaved by millionaires, the decision was extraordinarily unpopular. "Nothing has ever injured the prestige of the Supreme Court more than that last decision," said William Howard Taft. Progressives immediately began calling for a constitutional amendment to overturn the decision. "If the Constitution really prevents equal and just taxation, the people can amend their Constitution," announced the New York World. And they will. William Jennings Bryan had led the charge on the national stage, and in 1896, when both the People's Party and the Democratic Party nominated Bryan as their presidential candidate, both included support for an income tax on their platform. Beck, who started out as a Democrat, left the party when it nominated Bryan. Still, progressives were in a pickle. To implement a federal income tax, they needed a constitutional amendment. To get a constitutional amendment, they had to get it through the Senate. To get an income tax amendment through the Senate, they needed a more accountable Senate. To get a more accountable Senate, they needed a constitutional amendment. They went back to the drawing board. High time for a constitutional convention. The only way to amend the Constitution without Congress is for 2/3 of the state legislatures to call for a convention to propose amendments. In 1893, states began calling for a convention to propose a direct Senate election amendment. California went first. But some states weren't willing to wait for a constitutional amendment to elect their senators by popular vote, so they came up with workarounds. Beginning in 1901, Oregon put the election of the state's U.S. senators directly to voters in non-binding elections. In an initiative measure, Oregonians then passed a law requiring candidates for the state legislature to declare on the ballot whether they would honor the vote of these non-binding elections. By 1910, 28 other states had adopted this or a similar de facto method of direct election. Nebraska's ballot indicated, after the name of each legislative candidate, whether he promises to vote for the people's choice or will not promise to vote for the people's choice. Nationally, in elections that year, 10 Republican senators who had earlier voted against the direct Senate election amendment lost their seats. Meanwhile, momentum for a convention grew. In 1906, the governor of Iowa held a conference in Des Moines where representatives from 11 states discussed whether a convention, if it were held, ought to be limited to considering the direct Senate election amendment. By 1909, 28 state legislatures had petitioned Congress to call a convention. Only 31 were needed to reach 2/3. Under these circumstances, Americans became exceptionally interested in the intricacies of Article 5. The federal amendment process was soon the subject of sustained public fascination, serious scholarship, and congressional deliberation. Historians, constitutional lawyers, and a new breed of academics, calling themselves political scientists, all engaged in this debate, which took place at conferences, in academic journals, in the popular press, and by the 1920s, on the radio. At a time when the breakup of empires and the establishment of new democracies was leading to a surge of constitution writing in Europe, Americans were especially intrigued by remarks offered by foreign observers in the long line of commentators on American constitutionalism that stretched from Tocqueville to Lieber to Bryce. In 1905, for instance, Australia's Attorney General, Henry Bourne Higgins, contributed an article called The Rigid Constitution to the American journal Political Science Quarterly. Higgins had served as a delegate to Australia's Constitutional Convention in 1897, but disliked the resulting constitution and had campaigned against its ratification because he had supported an easier amendment mechanism and regretted that, in imitation of the U.S. Constitution, the new Australian Constitution requires the concurrence of artificial majorities for amendment. Still, he was grateful that it is less hopeless to look for amendment in Australia than in the United States. Marveling at the unchanged and nearly unchangeable U.S. Constitution, Higgins remarked that, true to Jefferson's ideal constitutional duration, the average lifespan of a state constitution in America was only 19 years. Inspecting the graveyard of failed federal amendments, Higgins deemed two to have been particularly sensible: the direct election of the president and the direct election of senators. Given the difficulty of amendment, Higgins pointed out that constitutional change in the United States happens only at the hands of U.S. Supreme Court justices, and sadly, it must be admitted that judges are not persons to whom the amendment of a constitution should be entrusted. Amendment by the judiciary, he concluded, was a deformity of American constitutionalism, in which far too much energy was spent in ascertaining what a dry piece of parchment means rather than what the people need. Nor was this criticism, of course, offered only by foreigners. In 1906, North Carolina Supreme Court Chief Justice Walter Clark called for the next Constitutional Convention in the Yale Law Journal. Clark had little reverence for the last one. Describing the 1787 convention as reactionary, he pointed out the many ways in which it fell short of democratic ideals. Its proceedings were closed to the public, its records were secret, and only 39 of the 55 delegates even signed the resulting document, which was in any case submitted not directly to the people for a vote but to ratifying conventions. The Declaration of 1776 was concerned with the rights of man, Clark wrote. The Convention of 1787 entirely ignored them. The U.S. Constitution was never very good, Clark argued, but at this point it was worse than useless. It was designed for 3 million people living along the Atlantic, but we are now trying to make it do duty for nearly 100 million, from Maine to Manila, from Panama to Puerto Rico to the Pole. Concluding that it was high time to hold another convention, Clark urged a series of reforms aligned with the progressive agenda. Reform of the Electoral College, a single 6-year presidential term, the election of Supreme Court justices to non-renewable 10-year terms, direct election of senators, and abolition of the equal suffrage of the Senate. If conservatives feared constitutional amendments, they were terrified by the prospect of a convention. Never before had a movement for constitutional reform deployed the threat of a convention so effectively. If the choice was between an amendment or a convention, conservatives preferred an amendment. Congress edged toward action. In 1908, the Democratic platform called for an income tax amendment, but William Howard Taft, accepting the Republican nomination that year, said he still hoped Congress could pass a law that the Supreme Court would tolerate, not least because its decision in Pollock had turned on one vote. Taft asked Congress to pass an inheritance tax. Many Democrats in Congress supported a tax on corporations. To persuade them against that course, Republicans, including the president, offered to support an income tax amendment, which they believed had no chance at ratification. In a message to Congress in June 1909, newly elected President Taft said that amendment is the only proper course for establishing Congress's power to tax incomes. The Senate introduced the amendment weeks later. The income tax amendment passed the House, 318-14, and Senate unanimously in July 1909 and went to the states for ratification as the 16th Amendment. This process proved maddeningly slow. As frustration over the delay in ratifying the 16th Amendment and getting the direct Senate election through the Senate grew, the number and range of proposals to amend the amending provision grew too. In April 1911, Victor Berger, a member of Congress from Wisconsin, and a member of the Socialist Party during the peak of its influence in the United States, proposed 2 amendments on the floor of the House. The first granted Congress the power, by a majority vote of both houses, to call a convention for the purpose of revising or amending the Constitution. The second, another kind of workaround, abolished both the presidential veto and judicial review and effectively abolished the Senate. In the same congressional term, Oklahoma Democrat Robert Owen proposed an easier method of amendment. With direct election in effect in all but the Constitution and facing the prospect of an open-ended convention, the Senate finally relented. In 1911, it for the first time brought the direct election resolution to a vote. The cautious warned against the change. Cried New York Senator Elihu Root, "How little we know what any amendment would produce!" The amendment fell 5 votes short of a 2/3 majority, but then, to Root's everlasting disgust, it passed barely a month later in a special session in June 1911. There remained the matter of reconciling it with the House version. And still the 16th Amendment remained unratified. By July 1911, it had achieved the approval of the legislatures of 31 of the 46 states, but those 31 states contained 73% of the population of the United States. In the North American Review, Monroe Smith, professor of law and history at Columbia, marshaled a great deal of evidence to contend that the framers had not intended amendment to be so difficult, and that the time had come to amend Article 5. As Smith pointed out, even if the direct Senate election amendment were to be ratified, it would not prove that Article 5 could be relied on, since the measure by that point enjoyed such extraordinary bipartisan support. Proposed by a Republican president and passed by a Republican Congress, it is supported by Democrats as an essentially democratic measure, he wrote. The rejection of this amendment, indeed, would go far to prove that formal change of the Constitution is impossible, but its adoption should not unduly elate those who desire further amendments. Smith listed all kinds of deformities that he believed were caused by the difficulty of amendment, including the hollowness and cynicism of the parties. Our parties have no use for principles because they would not be able to put them into practice. Worse, he conceived of Article 5 as the only possible check on the Supreme Court. If the people elect legislators who pass a law and then the court effectively vetoes that law, the people's only remedy, since they can't vote the justices out of office, is a constitutional amendment. But if that doesn't work, the people are helpless. Smith then joined the ranks of the many observers who offered a new method of amendment. A proposed amendment would have to pass both houses of Congress by a simple majority vote, but in 2 successive Congresses, after which it would be sent to state legislatures, to state conventions, or directly to the voters. Congress chooses which. By whatever method, ratification would be accomplished by a vote in a majority of the states, provided that the ratifying states contain, according to the last preceding enumeration, a majority of the total population of all the states. At least one commentator pointed out in this era that the conservation movement, concerned with wildlife and wilderness and an ancestor of the late 20th century environmental movement, was of such fundamental importance that it too required changes to fundamental law, or even an entirely new constitution. In May 1912, after a nearly year-long stalemate between the House and the Senate, the direct Senate election amendment went to the states for ratification as the 17th Amendment. Reporting the news of its ratification the next year, the Washington Post pointed out that a proposal for direct election of senators had first been introduced into the House in 1826, first reached the Senate in 1850, and met with senatorial disfavor for the next 62 years. William Jennings Bryan, as Wilson's Secretary of State, had the honor of signing the formal announcement of its ratification on May 31st, 1913. But as Monroe Smith had predicted, the advance of the 16th and 17th Amendments hardly slowed the momentum for a gateway amendment. By now, the Socialist Party platform advocated amendment by a majority of voters in a majority of states. In the 1912 election, socialist mayors and other municipal officers were elected in more than 50 American cities. A minority report issued by the Judiciary Committee called for an amendment to Article 5, making possible federal constitutional amendment by way of popular initiative. A constitution ought to be the direct election of the people, they insisted, rather than the declaration of a legislative body representing the people. In August, Wisconsin Senator Robert M. La Follette Sr. proposed that if a majority of both houses, or any 10 states, supported an amendment, it would be sent to the states, where ratification would be accomplished by a majority vote in a majority of states, as well as by a majority of voters nationwide. In November, something close to La Follette's proposal, the endorsement of an easy and expeditious method of amending the federal Constitution, became a plank in the platform of the Progressive Party. And in Congress in 1913, Republicans introduced gateway amendments too. 5 more variations were introduced that spring. If these proposals were no more than kite flying, there were more kites flying in that constitutional sky than ever before. Why did Beard have to tell it? No wonder 1913 was conservatives' annus horribilis. The 16th and 17th Amendments were ratified, after which income tax became the federal government's principal source of revenue, allowing for its continued expansion. Without that revenue, the United States would never have been able to enter the First World War. Also in 1913, gateway amendments were introduced into Congress, and suffragists marched to the Capitol and presented Congress with their amendment in March, while the Anti-Rum March offered up its own amendment on the steps of the Capitol in December. Bolshevism was on the rise in Europe, socialism in the United States. Yet in some ways, nothing so troubled conservatives as the publication in 1913 of Charles Beard's An Economic Interpretation of the Constitution, which would become at once the most influential and most controversial book ever written about the Constitution. The red-headed Charles Austin Beard was born in Indiana in 1874 and worked on the family farm before going off to study at DePauw, where he met Mary Ritter. In 1899, Beard went to Oxford to study constitutional history. He and Ritter married in 1900 and both began graduate school at Columbia. Beard earned a Ph.D. in 1904 and began teaching at Columbia. Ritter became a pioneer in women's history, and she and Beard collaborated on a slew of books, including the best-selling textbook, The Rise of American Civilization. For Beard's 1913 study of the Constitution, he examined the previously unexamined records of the Treasury Department to investigate the stock holdings of the 55 delegates to the 1787 Constitutional Convention. In a sense, he was investigating whether the framers were the sorts of men whose accumulation of wealth informed, even corrupted, their view of government. He argued that in devising the Constitution, and in particular in implementing its aristocratic features, the framers were protecting their own property interests. His conclusion was unambiguous. For Beard, the Constitutional Convention had been, in effect, a house of dollars. Beard's theory proved explosive. One later student of constitutional history compared Beard's influence to that of Darwin or Freud. At the time of the book's publication, it was met with a furious reaction. Warren G. Harding, the man who had coined the reverential phrase Founding Fathers at the Republican National Convention in 1916, called Beard's book libelous, vicious, and damnable in its influence. At least one city banned it from public schools. According to Mary Ritter, Taft said, "Of course Beard was right, but that being true, why did Beard have to tell it?" The book was everywhere read as a commentary on progressive efforts to amend the Constitution and on the Supreme Court's conservatism. But Beard himself would later insist that in no sense was the volume a work for the occasion, written with reference to immediate controversies. This contention is difficult to accept. In 1910, Beard had bemoaned the difficulty of amendment, regretting that the extraordinary majorities required for the initiation and ratification of amendments have resulted in making it practically impossible to amend the Constitution under ordinary circumstances, and it must be admitted that only the war power in the hands of the federal government secured the passage of the great clauses relating to slavery and civil rights. In 1915, he founded in New York an organization called the Committee on the Federal Constitution, which proposed a 2-part amendment to Article 5. Among the progressive reformers who joined Beard on the Committee on the Federal Constitution were Florence Kelley, the labor leader, and Albert Bushnell Hart, the Harvard historian who had supervised the dissertations of W.B. Du Bois and Herman Vandenberg Ames. Ames was the scholar who had made the first compilation of proposed amendments to the Constitution. His influence on Beard's committee and on the broader debate was considerable. He made it possible to quantify the difficulty of amendment. Some scholars reviewing the proposed amendments compiled by Ames found the overwhelming majority of them to be either frivolous and self-promoting or the whims of a temporary political fancy. These men expressed relief that the Constitution had escaped the fate that has befallen the constitutions of the states, which had been so buffeted by the winds of change that they had long since ceased to be constitutions in a true sense. But for every commentator who had looked at Ames's numbers and was glad that Article 5 had proved as sturdy as an iron door, 3 more looked at Ames's numbers and wanted to fashion a battering ram. In 1916, the American Political Science Review cited Ames in reporting that although 2 amendments had just been ratified, they were 2 in 1,000, for an amendment rate of 0.002. More than 700 resolutions for 977 amendments had been introduced into Congress between 1889 and 1913, the author reported, predicting that given this appalling amendment rate, an amendment to amend Article 5 would soon be sent to the states. In the same journal, a call for a more democratic procedure of amending the Constitution attempted to calculate the costs to the country of the lapse of more than 2 decades between the Supreme Court's overturning of the income tax in 1895 and the ratification of the 16th Amendment in 1913. In that span of time, the nation had moved from a predominantly agricultural economy to a predominantly industrial one, and the absence of a tax on income subsidized the wealthy at the expense of the laboring poor. Still, Beard's tiny and short-lived Committee on the Federal Constitution was outgunned, outfunded, and outlasted by its conservative counterpart, the National Association for Constitutional Government, or NACG. The organization had first been proposed in The Crisis in Constitutionalism, published in the North American Review in 1913 by the Reverend David Jane Hill, a Baptist minister and former ambassador to Germany. Hill founded the NACG in Washington in 1916 for the purpose of warning the public about the danger of reconstructing the Constitution and bringing to the minds of the people a realization of the vital necessity of preserving the nation's basic law unimpaired. Endorsed by Elihu Root, a former Secretary of State who had left a seat in the Senate rather than submit to direct election, the NACG published its own journal, the Constitutional Review, beginning in April 1917. Its inaugural issue, printed just as the United States entered the war in Europe, denounced those who called for structural changes to the Constitution and warned that the nation's founding document was in danger of assassination. The National Association for Constitutional Government disseminated an understanding of constitutionalism that would have been unrecognizable to the 18th century framers, but quite familiar to 21st century originalists. But the NACG was only one of a host of patriotic societies founded before and during the war, advocating for military preparedness, constitutional fidelity, and political loyalty. These included the National Security League and the American Defense Society. Both James Beck and Columbia University President Nicholas Murray Butler served on the editorial board of the Constitutional Review and on the executive board of the National Security League. All these organizations took up constitutional education, printing pocket constitutions, and instituting the teaching of the Constitution in schools and as part of the naturalization process. "Denouncing the Reds does no good," wrote the editor of the Constitutional Review. "There must be a campaign of counter-education." The NACG also advocated the establishment of September 17th, Constitution Day, the anniversary of the signing of the Constitution, as a national holiday. The idea had first been proposed by the Sons of the American Revolution in 1917. Its printed pocket constitution contained not only the text of the document, but a short treatise on how to read it and why to be very, very cautious about amending it. During the war, the Constitution became itself a kind of loyalty oath. In October 1917, Beard submitted a letter of resignation to his university president, the NACG's Nicholas Murray Butler, after the university trustees fired 2 faculty members who opposed American involvement in the war. Beard supported involvement. He just didn't support loyalty oaths or firing faculty for their political views. Charles and Mary Ritter Beard then moved to Connecticut, where they wrote books and raised cattle. Ratification of the 18th Amendment in January 1919 was essentially a wartime measure, banning alcohol as a matter of military preparedness, but it divided conservatives. Many, like Beck and Butler, objected to amending the Constitution to police private morals, but other conservatives approved of prohibition for the very same reason. In any event, they agreed about the necessity of constitutional education, a campaign that saw startling success. Between 1789 and 1860, only one state, California, had required the teaching of the Constitution in public schools. By 1924, the legislatures of 25 states had mandated such classes. They were to teach constitutional worship. Students were to be taught to revere the Constitution as the best form of government ever devised by the mind of man. Let him not try to diminish the power of any one of the 3 columns of government. Particularly, let him not attempt to question the restraining power of the Supreme Court. The book they very often assigned was written by Mr. Constitution himself. Be a Good Boy. Mary Church Terrell, 2 years younger than James Montgomery Beck, was born in 1863 to freed slaves in Memphis. Her father became a wealthy businessman, a millionaire, as an investor in real estate. Church grew up in Oberlin, Ohio, and studied at Antioch College, then at Oberlin College, where she became an avid suffragist. She studied classics as an undergraduate before earning a master's degree in education. She married in 1891 and spent much of her career as a teacher and a writer, but in the 1890s began dedicating herself to organizational work, first through helping to found the Colored Women's League in 1892, and then the National Association of Colored Women. In 1909, she helped found the NAACP. Terrell led the struggle to push white suffragists to eradicate the racism within the women's suffrage movement and to collaborate with black women to use suffrage to fight the double burden faced by black women. Terrell was crucial to the suffrage movement, both for the pressure she exerted on white suffragists and for the advocacy for female suffrage that she undertook within the black community, persuading black men of the need for the women's vote, an argument all the more intricate and urgent because even as suffragists were fighting for what would become the 19th Amendment, white supremacists were attempting to repeal the 15th. After the suffrage parade in Washington in March 1913, the House finally took up the suffrage amendment, known as the Susan B. Anthony Amendment, in honor of Anthony, who died in 1906. Modeled on the 15th Amendment, it read, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex." The debate in Congress proved agonizingly slow, but meanwhile, suffragists sought victory in the states. By 1919, women could vote in 28 states. Of the 21 states where women could not vote, 10 were in the South. Those were the same states where poll taxes, literacy tests, voter registration requirements, and vigilantism meant that the 15th Amendment was effectively a dead letter, an interpretation that the Supreme Court had supported in Gwynne and Beale v. United States in 1915. There the court, while striking down a grandfather clause, did not question the constitutionality of literacy tests and affirmed the state's power over suffrage. Even so, white Southerners in Congress had been fighting to repeal the 15th Amendment, introducing 30 different resolutions for its repeal between 1900 and 1915. One resolution was introduced by a Pennsylvanian, the rest came from Alabama, Georgia, North Carolina, Mississippi, and South Carolina. In 1915, Mary Church Terrell published an arresting piece in the pages of the NAACP's magazine, The Crisis, arguing that support for women's suffrage was not in tension with, but was in fact a necessary element of efforts to preserve the 15th Amendment. Precisely the same arguments used to prove that the ballot be withheld from women are advanced to prove that colored men should not be allowed to vote, she wrote. The reasons for repealing the 15th Amendment differ but little from the arguments advanced by those who oppose the enfranchisement of women. Terrell's reading of the opposition was all too accurate. In an address to the Alabama State Bar Association in Selma in 1919, Emmett O'Neill, the former governor of Alabama, delivered a spirited attack on the Anthony Amendment by comparing it to the 15th Amendment. The 15th Amendment does not grant black men the right to vote, he pointed out. It only bars states from denying anyone the right to vote on the basis of race, color, or previous condition of servitude. It struck out the discriminating word white from every state constitution, O'Neill said. The same was true of the Anthony Amendment. It didn't grant women the right to vote. It only barred states from denying anyone that right based on their sex. There are plenty of other ways to bar people from voting, as O'Neill well knew. In 1901, at Alabama's Constitutional Convention, Delegate O'Neill had framed the state's poll tax and literacy test requirements. Does the Anthony Amendment, if ratified, give to women the right of suffrage? He asked in his 1919 address to his fellow Alabama lawyers. The same question was asked as to the 15th Amendment, he pointed out, and the court had answered that it did not in its true sense give to the Negroes the right of suffrage, and the court would give the same answer to the Anthony Amendment. That is to say, it would strike from every state constitution the discriminating word male, but the states would retain the power to discriminate in any other way they wished. Alabama's poll tax, for instance, would remain in effect, as would its requirement that citizens wishing to vote must have worked or been regularly engaged in some lawful employment, business or occupation, trade or calling, if they wished to register to vote. Housekeeping would qualify, O'Neill argued, hence poor women and black women, most of whom were poor, would be able to vote, but wealthy white women who hired housekeepers would be excluded from the ballot, with the result, O'Neill warned, that were the Anthony Amendment to be ratified, the great mass of Negro women in Alabama and the South would become part of the electorate which would unquestionably menace the domination of the white race. The Anthony Amendment passed in the House in January 1918 and again in May 1919, then passed in the Senate the next month. 3 states, Illinois, Michigan, and Wisconsin, ratified it almost immediately, followed by more states over the summer. Though in July, Georgia became the first state to reject the amendment. South Carolina voted no in January 1920, as did Virginia and Maryland in February, and Mississippi in March, and Louisiana in July. Despite losses in these 6 southern states, by August 1920, only 1 more state was needed to ratify the amendment. In Tennessee, Mary Church Terrell's home state, the Senate voted yes, and when the vote went to the House, it was expected to be close. Supporters of the amendment wore yellow roses, opponents red roses. 24-year-old Congressman Harry Byrne wore a red rose, but he had a letter in his pocket from his mother, Phoebe Ensminker Byrne. "I wish you were home," she'd written to her son. "Hurry and vote for suffrage, and don't keep them in doubt," she told him. "And don't forget to be a good boy." Young Harry Byrne voted yes, breaking the tie. The 19th Amendment became law. That November, all over the South, black women voted for the first time. More than 1,000 black women registered to vote in Chatham County, Georgia, more than 6,000 in Duval County, Florida, where in Jacksonville the Klan patrolled the streets on election eve. Like black men, black women often headed to the polls in groups for safety, for help filling out forms, and for fighting intimidation. They went as families, with their schools and with their congregations. 3 people from the AME's Old Folks Home in Baltimore went together that fall. Mrs. Geneva Gray, 84, Mrs. Mary Garrett, 90, and Mr. Moses James, 90, and in a clear voice, but with shaking hands, got themselves on the books. The next year, Mary Church Terrell delivered a speech called An Appeal to Colored Women to Vote and Do Their Duty in Politics. She wanted women to vote, but admitted that everything about the suffrage campaign and black women and men's experience trying to cast their ballots on Election Day 1920 had convinced her that the ratification of the 19th Amendment had not solved the problem of the South's unwillingness to honor the 15th Amendment. What good was an amendment if it existed only on paper? Constitutional Jello. The Supreme Court was undergoing its own revolution in the 1920s under the Chief Justiceship of William Howard Taft. Taft was born in Ohio in 1857, the year the Supreme Court decided Dred Scott, and went to Yale before studying at the Cincinnati School of Law. He'd served 3 years on Ohio's Superior Court when, in 1890, he became the youngest ever U.S. Solicitor General. He argued 18 cases before the Supreme Court and won 15, and in 1892 he was appointed a federal judge for the Sixth Circuit. While serving as Governor General of the Philippines, he was twice offered a position on the Supreme Court. Both times he declined. Elected U.S. President in 1908, he failed to win re-election in 1912, after which he joined the faculty of Yale Law School. His best-known academic work was a series of lectures published in 1916 as Our Chief Magistrate and His Powers, a critique of the presidencies of Theodore Roosevelt and Woodrow Wilson, masquerading as what Taft described as a careful study from the unbiased standpoint of the historian and the jurist. Taft had long wanted to restructure the federal judiciary, and he was also keen to defend the Constitution from what he considered to be the excesses of progressivism. In 1916, when Wilson nominated the nation's leading progressive lawyer, Louis Brandeis, to the court, Taft vigorously opposed the nomination, which he had expected to come to him. It is one of the deepest wounds that I have ever had as an American and a lover of the Constitution and a believer in progressive conservatism that such a man as Brandeis could be put on the court, Taft wrote, calling Brandeis a muckraker, a hypocrite, and a socialist. Taft solicited the signatures of 6 other former presidents of the American Bar Association on a letter he wrote opposing Brandeis. Much of the objection to Brandeis was anti-Semitic, much was political. I think as ill of William Howard Taft's morals now as of his intellect, Brandeis wrote to his wife at the time. Privately, Brandeis referred to the walrus-mustached Taft, who tipped the scales at around 300 pounds, as the fat man. Taft's campaign did not derail Brandeis's confirmation, and in any case, at the time confirmation was all but automatic. It certainly did not elicit the interest of the public. No nominee appeared before the Senate Judiciary Committee until 1925, when Harlan Stone appeared briefly to answer specific narrow questions about the Teapot Dome scandal. No proposed justice was called before the committee until Felix Frankfurter in 1939, who initially refused but finally relented, if only for the purpose of denying that he was a communist. In 1920, Taft delightedly accepted the invitation offered to him by Warren Harding to serve as Chief Justice. He remains the only Chief Justice of the Supreme Court to have served as President of the United States. If he cannot be said to have had the keenest legal mind, he had the strong and steady arm of an experienced executive. He ran the court for only 9 years, but during that time he ushered in sweeping reforms, changing not only what cases the court heard, but also where it operated, elevating its power, its prestige, and not least, its mystique. Originally, the Supreme Court heard every case that made its way to its chambers. It had no choice. Questions may occur which we would gladly avoid, but we cannot avoid them, John Marshall, the longest-serving Chief Justice, complained in 1821. A century later, in a country whose population had grown tenfold, the court was overwhelmed by its backlog. Taft convened a committee that he charged with drafting a bill that would rationalize the court's docket. In what became known as the Judges' Bill, the justices proposed the certiorari system, by which they would in most areas of law be able to exercise their discretion to choose what cases they deemed worthy of their attention. Taft went before the House Judiciary Committee to explain the importance of letting the Supreme Court decide what was important and what was unimportant. Congress passed the bill in 1925. Easily 1/2 of certiorari petitions now presented have no justification at all, Taft reported in the Yale Law Journal 9 months later. The executive branch had the White House, the legislature, the Capitol, but the court had no home of its own and had long met in a dingy room, the old Senate chamber. Taft convinced Congress to authorize funds for the construction of a building for the court alone, befitting the status of the judiciary. Taft himself chose the 7-acre site. The new building was meant to be the largest marble building in the world, an austere and imposing monument to the rule of law. It looks like a Grecian temple restored. The Taft Court was the hinge between laissez-faire conservatism and the 1930s duel between the court and the New Deal. Taft himself wasn't a great thinker or a powerful writer. The luminaries on his court were Oliver Wendell Holmes Jr. and Brandeis. Holmes described Taft's opinions. Between 1921 and 1928, Taft wrote 249 of them, as opposed to 205 by Holmes and 193 by Brandeis, as rather spongy. Brandeis, with a nod to what the abolitionist Wendell Phillips once said about Abraham Lincoln, that he was a first-rate, second-rate man, said Holmes had a first-rate, second-rate mind. But Taft's opinions were the court's opinions. One legal scholar determined that Taft authored or joined the opinion for the court in 98.7% of its decisions. He ran an amiable bench. Once he joined the court, he took the initiative of forging a peace, even a friendship, with Brandeis. "I've come to like Brandeis very much," he wrote his daughter. And Brandeis, for his part, was charmed. That didn't mean they agreed. Brandeis was the least likely member of the court to agree with the majority, as his dissents were nearly always informed by his commitment to democracy over prosperity. Conservatives on the court granted the court authority to overrule legislation in order to accord the law with custom and tradition and original intent. Taft's rule for whether a law could be declared unconstitutional had to do with his equation of progress with the accumulation of wealth. Property and contract had to be protected at all costs. Holmes disagreed. "The justification of a law for us cannot be found in the fact that our fathers have always followed it," he wrote. "It must be found in some help which the law brings toward reaching a social end which the governing power of the community has made up its mind that it wants." Holmes argued that the framers had called into life a being the development of which could not have been foreseen completely by the most gifted of its begetters. They had created an organism, and its growth required the court to evaluate cases in the light of our whole experience and not merely in that of what was said 100 years ago. Brandeis most fully advanced the progressive view of the Constitution as a living organism. "Our Constitution is not a straitjacket," he wrote in the draft of a dissent in United States v. Moreland, in which he was joined by Holmes. "It is a living organism. As such, it is capable of growth, of expansion, and of adaptation to new conditions. Growth implies changes, political, economic, and social. Growth, which is significant, manifests itself rather in intellectual and moral conceptions than in material things. Because our Constitution possesses this quality of adaptation, it has endured as the fundamental law of an ever-developing people." But Chief Justice Taft had asked him to take these sentences out, "because they are certain to be used to support views that I could not subscribe to." To secure the Chief Justice's concurrence in his opinion, Brandeis omitted these sentences with regret. In 1921, Harding, who had nominated Taft to the court, named Beck Solicitor General. Beck served for 4 years, during which he oversaw more than 800 cases and argued more than 100. He also set about to defeat the idea of a living constitution. A man of daunting energy, he wrote a great deal for the popular press, even while holding this position. He was best known for a book whose first edition appeared in 1922 as The Constitution of the United States, a brief study of the genesis, formulation, and political philosophy of the Constitution of the United States. Essentially a refutation of Beard's economic interpretation, Beck's Constitution began as a series of lectures delivered at Gray's Inn, London, and was first published by the National Security League. Treasury Secretary Andrew Mellon paid for the distribution of 2,000 copies to libraries across the country. Beck's Constitution was printed and reprinted, updated and amended, translated and exported, and so widely circulated that it became the reigning interpretation of the Constitution. It was inescapable. Beck loved the Constitution. He blamed Americans for betraying it. He was a constitutional fundamentalist. In 1896, a Christian socialist had published a short book called In His Steps, What Would Jesus Do? Beck, in his book on the Constitution, asked, what would the framers think? A chapter on the centennial celebration in 1887 reminded readers that Benjamin Franklin had once written that he wished he could be preserved in a cask of Madeira wine for 100 years to see how things would turn out. Beck imagined that such a cask existed, then argued that Franklin, and alike George Washington, upon emerging from the Madeira in 1887, would have been thrilled to discover that their Constitution had survived so many epoch-making changes, but that if they'd gone back into the cask and come out again in 1922, they would have been heartbroken to discover that this profound faith in the Constitution had weakened, and that millions of men would distrust its wise restraints, that organized parties would declare their hostility to some of its essential principles, and that responsible leaders of thought would be willing to tear down in a day what had required a century to erect. Beck was angry that in the half-century since 1887, Americans had questioned the Constitution and amended it. He didn't like the 16th Amendment. He didn't like the 17th Amendment. And he very much didn't like the 18th Amendment. In these views, he concurred with the leading historian of the Supreme Court, Charles Warren, who published his own anti-Beardian account of the Constitution. He and Beck arranged to review one another's books, in which he emphasized that the framers were great men, employed upon a great task, and moved by high impulses. When you are asked hereafter to consider amendments to that instrument, it would be well to consider carefully whether the men who urge such changes are equally great and whether their motives and ideals are equally high. Beck's Constitution issued an identical warning, denouncing what he described as the decay of leadership, the revolt against authority, and Americans' gross ignorance of the very nature of the Constitution. Mr. Beck draws an indictment against a whole people, one review of Beck's work was titled. But by far the most perceptive and cruelest criticism of Beck came from the acerbic constitutional law professor Thomas Reed Powell. Powell, born in Vermont in 1880, had studied at the University of Vermont and practiced law in Burlington before going to graduate school at Columbia, where he completed a dissertation in 1913, the year Beard published An Economic Interpretation. He surely knew Beard as a student, and he also knew him as a colleague. After finishing his Ph.D., Powell taught in Columbia's political science department before being appointed to a professorship at the law school in 1920. In 1925, he moved to Harvard Law School, but remained friends with Beard, who later wrote him, "It would be a joy to have a jaw with you once more." In two reviews published in the New Republic in 1923 and 1925, Powell charged Beck with having written nothing so much as a prayer book. Men without their Sinai and Olympus must have their Runnymede in Philadelphia, Powell sneered. Powell had no patience with Beck's appetite for metaphor. On a single page, Beck had compared the Constitution to a Roman emperor, a temple, a beacon, and a Gothic cathedral. In another passage, Beck had written, "The Constitution is neither, on the one hand, a Gibraltar rock, which wholly resists the ceaseless washing of time or circumstance, nor is it, on the other hand, a sandy beach, which is slowly destroyed by the erosion of the waves. It is rather to be likened to a floating dock, which, while firmly attached to its moorings, and not therefore the caprice of the waves, yet rises and falls with the tide of time and circumstance." Powell wrote, "His idea seems to be that while it does not move forward or backward, it jiggles up and down, like Jell-O." Beck kept updating the book. Powell kept reviewing it. Once, writing in a voice he referred to as a simple man, Powell laid it on especially thick, pointing out one of Beck's more ridiculous absurdities. His claim that the framers wrote a constitution designed to protect the United States against the advance of communism, an ideology that did not exist in 1787. Most of Beck's Constitution is about how the Constitution got made, A. Simpleman reported. The rest of the book is about what a good Constitution it is and how bad it is to make changes in it. The main reason why it is so good is because it was made by such good men. Mr. Beck says very nice things about them. That goodness is what Mr. Beck has in his mind when he speaks of the anterior necessity of those who had property interests to protect themselves against the spirit of social revolt, which we today call Bolshevism. With Beard and Powell on the one side, and Beck and Butler on the other, American academics and lawyers divided over what the Constitution ever had been, what it was, and what it could be. Was it the Rock of Gibraltar? Or was it a bowl of Jell-O? Chapter 9. Miss Bolsheviki. The Congress shall have the power to limit, regulate, and prohibit the labor of persons under 18 years of age. Failed amendment to the U.S. Constitution, passed by both the House and Senate, 1924. The conservative movement to halt the amendment and decay of the Constitution in the Progressive era was led neither by James M. Beck nor by any man. It was headed by Mary Guthrie Kilbreth, a New Jersey-born member of the Daughters of the American Revolution, an anti-socialist, anti-suffragist, and anti-feminist. Like Phyllis Schlafly in the 1970s and 80s, Kilbreth appeared before Congress to object to just about every piece of legislation advocated by feminists in the 1920s and 30s. Although she failed to defeat the 19th Amendment, she led a successful campaign to defeat the Child Labor Amendment and effectively demonized the Equal Rights Amendment. Before the ratification of the 19th Amendment, Kilbreth had been the president of the National Association Opposed to Woman Suffrage, and, under the auspices of the Woman Patriot Publishing Company, published a magazine called Woman Patriot, dedicated to the defense of womanhood, motherhood, the family, and the state against woman suffragism, feminism, and socialism. The term feminist was coined in 1913. Woman Patriot regularly ran a column called The Amendment Situation, with updates as the 19th Amendment marched toward ratification. After ratification, the National Association Opposed to Woman Suffrage contested the amendment's constitutionality in the Supreme Court. The first of these cases, Fairchild v. Hughes, was filed by the president of the American Constitutional League, Charles Fairchild, whose wife, Elizabeth Nelson Fairchild, was a vice president of the National Association Opposed to Woman Suffrage. Undeterred, Kilbreth set her sights on halting the agenda that many former suffragists had now turned to, maternal and child welfare, and the abolition of child labor. She moved from New York to Washington. Under the auspices of the Woman Patriot Publishing Company, she published a twice-monthly successor magazine with a slightly revised title, Woman Patriot, dedicated to the defense of the family and the state against feminism and socialism. Suffragists and anti-suffragists have always agreed upon one point, that the importance of the issue is not in the ballot itself, but in what follows women's suffrage, Kilbreth wrote in a 1921 essay called The New Anti-Feminist Campaign. She wished she could have stopped suffrage, but having lost that battle, she called on her supporters to stop the sex revolution, by which she meant the destruction of the family by way of a Bolshevik revolution. Feminists did indeed have sky-high expectations for what women could do with the ballot. The economist Charlotte Perkins Gilman, who in 1915 had published a feminist utopian novel called Herland, blamed men for much that was wrong in the world, telling them, "You have had your day, you have worked your will, you have filled the world with warfare, with drunkenness, with vice and disease. You have wasted women's lives like water, and the children of the world have been sacrificed to your sins. Now we will have a new world, a Herland." To that end, feminists, although divided on many points, built a coalition. In November 1920, a confederation of 25 women's organizations, including the National Women's Trade Union, the PTA, the YWCA, the League of Women Voters, and the American Association of University Women, formed the Women's Joint Congressional Committee, or WJCC, to lobby Congress for legislation to improve the lives of women and children. Kilbreth called it a secret lobby and denounced the vast feminist bureaucracies it represented, including the Children's Bureau, a federal agency established in 1912. The WJCC's first major accomplishment was the passage in 1921 of the Shepherd-Towner Maternity and Infancy Protection Act, which provided funds for everything from prenatal care to home visits by nurses. Urged on by none other than Solicitor General James M. Beck, Kilbreth and the Woman Patriot Publishing Company sought to block the law, which she connected to birth control, a term only recently coined by Margaret Sanger, who had founded the nation's first birth control clinic in Brooklyn in 1916. When the law passed, Kilbreth sought to overturn it. In the Supreme Court, James M. Beck, as Solicitor General, defended the legislation with reluctance. "More children die within the first month of their existence than this nation lost in the World War," he said. "Nearly 200,000 children die in the first year." The government prevailed. Kilbreth's anti-suffragism and anti-feminism fused with anti-radicalism. The Red Scare that began in 1919, a year of labor strikes and anarchist bombs, race riots, and their violent suppression, took a new form after 1920 in a conservative women's campaign against social reform as amounting to the nationalization of women, or the placing of women's sexual and reproductive functions into the hands of the state under Bolshevism. Once the 19th Amendment was ratified, the Red Scare didn't wind down. It just turned its attention from immigrant radicals to American feminists as defilers of the Constitution. The Spiderweb Chart. Women's constitutional leagues began forming in 1921, starting in Massachusetts. Their purpose was to sound the alarm about the growing menace to the Constitution. Complaining that the Constitution had been amended past recognition, they also supported an early version of what conservatives called the Back to the People Amendment, a proposal to make amending the Constitution more difficult. Conservatives, through organizations like the National Security League, the Sentinels of the Republic, and the Women's Patriotic Conference on National Defense, were fighting both for what would come to be called conservative constitutionalism and for preparedness as a political objective, urging Congress to continue the military expenditures it had begun during the war. The Boston-based Sentinels mission had 5 parts. To maintain the fundamental principles of the American Constitution, to oppose further federal encroachment upon the reserved rights of the states, to stop the growth of socialism, to prevent concentration of power in Washington through the multiplication of administrative bureaus under a perverted interpretation of the General Welfare Clause, to help preserve a free Republican form of government in the United States. The Sentinel's constant refrain, not least in a series of radio addresses, was that the United States suffered from too much government, by which it meant too many social services, but not too much military spending. Feminist organizations, those associated with the peace movement and beyond, by contrast, called for a reduction in federal military spending. They wanted to use their votes and their lobbying skills to convince the federal government to spend money on women and children, not on guns and tanks. The War Department was determined to defeat those efforts. The head of the Chemical Warfare Service, whose munitions peace activists were particularly keen to ban, believed that all such women were either socialists or Bolsheviks or doing the work of Bolsheviks. In 1923, Lucia Ramsey Maxwell, a librarian working for the Chemical Warfare Service, prepared an extraordinarily intricate 1-by-2-foot chart known as the Spiderweb Chart, attempting to establish the ties between 16 of the nation's largest women's organizations and leaders, from Florence Kelley's National Consumers League to the PTA and the YWCA. She dedicated the chart to Kilbreth, with appreciation for her work, and provided as a title a quotation from the report of the Lusk Committee, a New York legislative body investigating sedition. The socialist pacifist movement in America is an absolutely fundamental and integral part of international socialism. And she added a poem to accompany it, which begins, "Miss Bolsheviki has come to town with a Russian cap and a German gown. In women's clubs she's sure to be found, for she's come to disarm America. She sits in judgment on Capitol Hill and watches appropriation bills. And without her okay, it passes nil, for she's there to disarm America. She uses the movie and the Lyceum, too, and alters textbooks to suit her view. She prates propaganda from pulpit and pew, for she's bound to disarm America. Maxwell sent copies of the spider web chart to President Harding and to J. Edgar Hoover, who would soon become head of the newly formed Federal Bureau of Investigation. It circulated privately in 1923, but in March 1924, it was printed in Henry Ford's newspaper, the Dearborn Independent, and then widely reprinted. Maud Wood Park, chair of the Women's Joint Congressional Committee, wrote to the War Department to complain and ask for a retraction. She received an acknowledgement that the department had destroyed its own copies and an admission that the chart contained errors, but no public retraction. Park then led an internal investigation into the methods deployed by Kilbreth, which reported that the relentless opponents of the last two amendments, the Prohibition and Woman Suffrage Amendment, had now turned their attention to the defeat of anything that might improve the lives of women and children. Since the end of the war, these opponents had been joined by the advocates of greatly increased military preparedness. Together, they employed the same method as against any legislation or proposed amendment. It is charged that the legislation is un-American, that it seeks to break down the Constitution, that it originated in Moscow. The timing of the spiderweb charts leaked to the public in March 1924 was no accident. By then, Mary Kilbreth and the Woman Patriot Publishing Company had undertaken to grapple with an entirely new amendment situation. The Alice Paul theory of constitutional law. In April 1923, the court handed down its decision in Adkins v. Children's Hospital, striking down D.C.'s minimum wage law for women. Justice George Sutherland, an English-born conservative from Utah, writing for the majority, argued that labor laws aimed at women amounted to an unconstitutional interference in the Lochnerian liberty of contract, and that, in any case, such laws were no longer necessary because the ancient inequality of the sexes had become, in the dizzying Model T and frozen food age of the flapper, a thing of the past. Given the great, not to say revolutionary, changes in the contractual, political, and civil status of women, culminating in the 19th Amendment, Sutherland wrote, it is not unreasonable to say that these differences have now come almost, if not quite, to the vanishing point. Oliver Wendell Holmes notably dissented. It will need more than the 19th Amendment to convince me that there are no differences between men and women, or that legislation cannot take those differences into account. Florence Kelley, the nation's leading labor lawyer, didn't think you had to squint to notice the enduringly unequal status of women in the United States in 1923. You could, for instance, turn your gaze on the court itself and give it a long, hard stare. Sutherland was celebrating, and sadly, wildly overstating, changes he'd had a real hand in, as had his wife, Rosamond Lee Sutherland. From the time of Sutherland's election to Congress from Utah in 1900, and through his years in the Senate, he and she had fought for woman suffrage, hosting delegations at their home in Washington, making speeches at suffrage meetings, and publishing articles in magazines. In 1910, Rosamond Lee Sutherland published the essay, The Appeal of Politics to Woman, in the North American Review. In it, she argued that women needed more than the right to vote. They needed to be elected and appointed to public offices because laws made, enforced, and interpreted by men were unfair to women and children. Are there not many ways in which the active voice, as well as the passive influence of women, is sadly needed in remedial legislation today? She asked. Does not the cause of working women need serious attention? For instance, there was the problem of unfair wages for women. Men and women work shoulder to shoulder as teachers, clerks, and in countless capacities as wage earners, but the men almost invariably receive much better salaries, not because they do better work or are more trustworthy, but simply because they are men, which is unjust, illogical, and all wrong. Then, too, she wrote, the crying evil of child labor would surely be eradicated were women instrumental in making and enforcing the laws. In 1913, when suffragists stormed the Capitol to argue why women should have the ballot, according to the Salt Lake Telegram, Rosamond Lee Sutherland was one of two senators' wives to join the delegation. The other was the formidable feminist lawyer Belle Case La Follette, wife of Wisconsin Senator Robert La Follette. Like Florence Kelley, Belle La Follette was named on the spiderweb chart. A year later, George Sutherland denounced the rule of women by men. To deprive women of the right to participate in government is to make an arbitrary division of the citizenship of the country upon the sole ground that one class is made up of men and should therefore rule, and the other class is made up of women who should therefore be ruled. He had also, in 1915, introduced the 19th Amendment into the Senate and declared women's disenfranchisement an unjust and intolerant denial of equality. In 1923, Sutherland was working with Alice Paul, head of the National Women's Party, on a draft of the Equal Rights Amendment, even as he was writing his opinion in Adkins. Florence Kelley, meanwhile, had dedicated herself to eradicating what Rosamond Lee Sutherland had described as the crying evil of child labor. Kelley led not only the campaign for maximum hour and minimum wage laws for women, but also the urgent and exhausting campaign to end child labor. In 1904, she'd founded the National Child Labor Committee to coordinate efforts across the states. The obstacle to that work was the U.S. Supreme Court, especially after 1921, under Chief Justice William Howard Taft. In Adkins, Brandeis had to recuse himself. His wife had been involved in the Children's Hospital. It was Taft who dissented in Adkins, following Muller v. Oregon, which Brandeis himself had argued before joining the court. Taft, who had headed the War Labor Board, found it hard to dismiss outright the need for a wage floor. But this would be his last real disagreement with his court's conservative majority. Adkins set in motion a confrontation with the court that wouldn't fully come to a head until the New Deal. But in 1923, for Florence Kelley, it wasn't just Adkins. It was the two cases that had come before. For decades, Kelley had been fighting for child labor laws in the states. Twice, Congress had passed laws aimed at abolishing or at least limiting child labor. Twice, the Supreme Court had struck down those rules as unconstitutional. Then came Adkins, which Kelley called a new Dred Scott. She called for an overhaul of the federal judiciary. She wanted to put women on the bench. 3 times in 3 years, the Supreme Court has given warning that justice and mercy for women and children are not to be expected from a court which, itself a perpetual monopoly of men, incarnates age-long injustice, wrote Kelley in commentary published a month after Sutherland issued the court's decision. Where Sutherland had insisted that the ancient inequality of the sexes had been all but eradicated by the 19th Amendment, Kelley answered that the court itself represented an age-long injustice in the form of the perpetual monopoly of men serving on the bench. To break that monopoly, the next appointees both to the Supreme Court and to the D.C. Court of Appeals, Kelley insisted, had to be female, the first in a series of able women of the modern mind. Set the 9 men on the bench aside, 2 bow ties, 1 cravat, 6 neckties. Wasn't this a case about women? That was another of Kelley's points. Although the life, health, and happiness of women and girls are at stake, no woman has participated in the minimum wage case at any of its stages, she pointed out in her reading of Sutherland's opinion. This wasn't strictly accurate. No female lawmakers had voted on the D.C. law. No female judge or justice had heard the case. No female lawyers had argued it. But Kelley had had a hand in writing a great many of the nation's labor laws, including D.C.'s minimum wage law for women, on which she'd collaborated with Harvard Law School professor Felix Frankfurter, who then went on to argue for the appellants in Adkins. And Molly Dewson, Kelley's deputy, had drafted much of the 1,248-page brief for the D.C. Minimum Wage Board in Adkins, even though it went out under Frankfurter's name. Still, in the end, Sutherland decided to ignore Dewson's work in its entirety, declaring the empirical evidence in her brief, more than 1,000 pages of statistics, testimony, and analysis regarding the suffering of women, as having shed no legitimate light upon the question. When Frankfurter read the court's opinion, he telegrammed Kelley, "Upshot would be adoption of Alice Paul theory of constitutional law." The Alice Paul theory of constitutional law was a theory that Florence Kelley considered a species of madness. As soon as the 19th Amendment was ratified, Paul had begun crafting a new constitutional amendment. There is at this moment an insanity prevalent among women where one would least expect it, Kelly wrote about an early draft of the Equal Rights Amendment. The slogans of the insane are, "A fair field and no favor, equal rights for women and nothing more. We ask no privileges now that we have the vote." As for the very term equality, Kelly had little use for it. "Let's not begin with meaningless words," she'd once said. "Equality, where there is no equality, is as terrible a thing for the defenseless workers as the cry of peace where there is no peace." She felt the same way about liberty of contract. Alice Paul had struggled over the question of whether a prohibition on discrimination by sex would undermine labor legislation. She'd sent drafts of the Equal Rights Amendment to Sutherland. One draft's Section 2 read, "This article shall not be interpreted as preventing legislation in the exercise of the police power or for the protection of women in industry." But after Sutherland and other lawyers she consulted took the position that the clause was not needed, it was deleted. She then aided the plaintiffs in Adkins, and by the end of the year had succeeded in having the Equal Rights Amendment introduced into Congress. Lost in the tug-of-war between Kelly and Paul was their shared understanding that the Constitution was not written for women and children. The 19th Amendment hadn't ended the need for amendments required to remedy so dire an inadequacy. After Adkins, Florence Kelly turned her attention to drafting and lobbying for the Child Labor Amendment. Paul's amendment aimed to eliminate a distinction. Kelly's aimed to make one. Mary Kilbreth wanted them both to fail, and it was she who succeeded. The Mother Amendment. According to the U.S. Census for the year 1900, 1 in 6 American children under 14, nearly 2 million children, worked in mills, meat-packing plants, stores, mines, factories, and fields. State legislatures had been attempting to contend with the problem, with little success. The problem was especially acute in southern textile mills. Alabama passed a child labor law in 1901, but under its terms, children as young as 12 could still work 60 hours a week. And in any event, many of the owners of the mills were out of state, beyond the reach of state laws. The need for a national law had led Florence Kelly to help found the National Child Labor Committee in 1904. 4 years later, the NCLC hired the photographer Louis Hine, who between 1908 and 1924 took over 5,000 photographs of children at work. By 1909, 43 states had passed laws regulating the labor of children. In 1916, in the Keating-Owen Act, Congress attempted to regulate child labor by setting minimum wages and maximum hours. To challenge the law, a textile industry leader in North Carolina found a man named Roland Degenhardt, whose 2 sons worked in a textile mill. On their behalf, he filed a suit against William C. Hammer, the U.S. Attorney for the Western District of North Carolina. In a 5-4 opinion in Hammer v. Degenhardt, 1918, Justice William R. Day held that regulating child labor did not fall under the Constitution's Commerce Clause. Holmes, in a dissent, found this hard to swallow. Regulation means the prohibition of something, and when interstate commerce is the matter to be regulated, I cannot doubt that the regulation may prohibit any part of such commerce that Congress sees fit to forbid. Reuben Degenhardt, one of the boys who worked in the mill, was interviewed 5 years later. "We got some automobile rides," he said about his involvement in the case when he was 15, with his brother, then 13. "They bought us both a Coca-Cola. That's what we got out of it." He was now 20. "Look at me, 105 pounds, a grown man, no education. I may be mistaken, but I think the years I've put in the cotton mills have stunted my growth. They kept me from getting any schooling. I had to stop school after 3rd grade, and now I need the education I didn't get. It would have been a good thing for all the kids in this state if that law they passed had been kept." Congress in 1919 had tried again, passing the child labor tax law, imposing a tax on any products manufactured by a company that employed anyone under the age of 16 in any mine or quarry and under the age of 14 in any mill, cannery, workshop, factory, or manufacturing establishment. In 1922, in Bailey v. Drexel Furniture Company, Taft wrote the majority opinion that ruled this law unconstitutional as well. At the time, Justice William R. Day's son, Rufus, who had clerked for his father and helped prepare his opinion in Hammer v. Degenhardt, was working for James Beck, the Solicitor General, while living with his father, the Justice. Justice Day hired 3 of his 4 sons to clerk for him. All 3 also argued cases before the court while their father was still sitting on it. Only irregularly did the justice recuse himself in those cases. Beck, who approved of Day's opinion in Hammer v. Degenhardt, didn't like the child labor tax law because of its assertion of federal power at the expense of the states. Left to defend the law, he slyly offered to the court a way to overturn it, perhaps aided by his clerk, Rufus Day, who prepared briefs for him and who, in the spring of 1923, argued 3 cases before the court. Beck, in his brief in Bailey v. Drexel Furniture Company, volunteered an argument for the opposition, claiming that candor compelled him to admit arguments that ran against his own. Beck made sure Taft knew he'd done this on purpose, writing to the Chief Justice after hearing his 8-1 opinion striking down the law, in which he was joined by Day, that although I presented the government's contention in the child labor cases as strongly as I was able, yet none who heard you deliver the opinion may have welcomed the decision more than I. Florence Kelley immediately called for a constitutional amendment. In Cincinnati, at the annual convention of the American Federation of Labor, she presented the Child Labor Amendment, granting Congress the power to limit, regulate, and prohibit the labor of persons under 18. In 1923, Kelley began pressuring Congress to pass it. Introduced in the House in April 1924, it passed on the same day. Less than 2 months later, it passed the Senate, the swiftest amendment to get through Congress. It seemed poised to be the swiftest amendment ever ratified, too, given the breadth of its support. Mary Church Terrell's National Association of Colored Women sent orders to chapters to lobby state legislatures. Please remember, dear sisters, that state legislators had to pass the Child Labor Amendment or else it will not be incorporated into the Constitution of the United States, warned Terrell, and that will certainly be a calamity. The Child Labor Amendment was endorsed by every political party and by the AFL, 11 members of the Women's Joint Congressional Committee, and the Federal Council of Churches of Christ. 20 years ago, the Constitution was a grim and ancient spinster dead set in her ways, declared the New York Times. But now she's succumbing to an almost flapper passion for change and excitement. In truth, as the Congressional Research Service reported in 1924, the Progressive Era amendments had all been the subject of long-standing and widespread political support and had for years appeared on party platforms. The Greenback Party's platform first called for what became the 16th Amendment in 1880. The People's Party platform called for the 17th Amendment in 1892. The Prohibition Party's platform included what became the 18th and 19th Amendments in 1872. Support for the Child Labor Amendment had been strong, and legislators expected that it would only get stronger, that it would enjoy the overwhelming support of newly enfranchised women, who are widely expected to vote as a bloc. That changed with the March 1924 publication of the Spiderweb Chart, damning the very women's organizations that supported the Child Labor Amendment as part of a radical, socialist, communistic plot to destroy the United States. The fear of a female communist conspiracy did not succeed in derailing the amendment in Washington, but it had an extraordinary effect in the states, where the vote on ratification was in many places conducted by a popular referendum, and where child labor amendment advocates had failed to plot an effective state-by-state ratification strategy. The campaign against the Child Labor Amendment had many lieutenants, but its brigadier general was Mary Kilbreth. Between 1921 and 1938, Kilbreth testified before Congress 26 times. She, for instance, appeared 3 times in 1921, twice to oppose the Shepard-Towner Maternity and Infancy Protection Act, claiming the birth control movement was behind it, along with a socialist conspiracy to destroy for this world the holy institution of marriage, and once to oppose the establishment of the Department of Education as an unwarranted expansion of the federal government. Kilbreth, the blue-blooded daughter of the director of an Ohio life insurance company, never married and did not have children. Her influence far surpassed the constituency she represented, It was, rather, a consequence of her zeal and dedication. The Woman Patriot Publishing Company consisted of 4 board members plus Kilberth. Its sole publication, Woman Patriot, boasted, at best, 2,500 subscribers. When Kilberth appeared early in 1924 to oppose aid for women and children in Germany, she was asked, "How large is this organization which you represent?" She admitted she represented no organization. "We are a group of women who are publishing a paper," she said. "You represent no organization or society?" "Absolutely none." Nevertheless, Kilberth was extraordinarily effective at recasting social reforms as social ills. In her opposition, which included a petition campaign, she was joined by the textile industry, the National Manufacturers Association, and the Sentinels of the Republic. But she and Woman Patriot supplied the basic argument against what she and her allies liked to call the Mother Amendment, insisting that a coterie of socialists had hoped to nationalize the children and replace mothers with the state. For progressive reformers, the abolition of child labor was the flip side of compulsory public education. One reason to prevent the employment of children was to allow them to attend school. "Child labor amendment means federal control of schools," Kilberth warned in a front-page story in Woman Patriot the month before the House vote. She raised a particular alarm about the teaching of sexology. Before the House Judiciary Committee, she argued that brain stuffing from books was not as good for children as all the practical moral training inherent in work. The Child Labor Amendment, like the Maternity and Infancy Protection Act, involved communistic government interference in the domestic relations, she said, and claimed that under its terms, a girl could not help her mother wash the dishes or a boy help his father milk the cows. She attacked Florence Kelley, referring to her as a translator of Marx and Engels. Kelley had in fact translated Engels. And she insisted that the Woman Patriot Publishing Company, with its 5 board members, represented the voice of the people, and that it was people like Kelley who were imposing changes over the heads of the people without the people themselves having any voice whatever in these changes. The Child Labor Amendment passed the House on April 26, 1924, the same day it was introduced, and in the Senate only a month later. But in Massachusetts, it met its Waterloo. Massachusetts had been among the state legislatures to petition Congress for the amendment in the first place, and the legislature was widely expected to ratify easily. But given the persistence of complaints that the 18th Amendment had been ratified by state legislatures when public opinion opposed the amendment, including in Massachusetts where public opinion opposed prohibition, Massachusetts had in 1920 passed a Public Opinion Act, whereby any proposed federal amendment had to be put to the voters in a non-binding referendum. Hence, the Massachusetts legislature sent the Child Labor Amendment directly to voters in a statewide referendum. Opponents hinted at Bolshevism and cited the use of the word labor in the amendment instead of employment to argue that the amendment would prevent parents from assigning chores to their children. In November 1924, voters rejected the amendment by a 3-to-1 margin, and the legislature abided by that preference. Before Massachusetts held its vote, 5 states had ratified the amendment. After the Massachusetts vote, no other state in the 1920s approved it. The Back to the People Amendment. Weeks after Taft issued the court's opinion in Bailey, Wisconsin Senator Robert La Follette, in a speech before the American Federation of Labor, decried what he called judicial oligarchy and proposed a constitutional amendment granting states the right to nullify Supreme Court opinions. La Follette had campaigned against Taft's bid for re-election in 1912, and he had voted against his confirmation to the court. He was a close friend of Louis Brandeis's. The court had repeatedly defied the will of the people, expressed through state legislatures and through congressional action, La Follette said, pointing out that Taft had been invested with the enormous prestige and influence of Chief Justice by presidential appointment, who had been repudiated by the voters of the United States on his record. La Follette claimed that it would take a dozen constitutional amendments to correct the evils of the decisions which the Supreme Court has handed down in the last 2 or 3 years. Progressives called for all manner of remedies, including not only a child labor amendment, but also a minimum wage amendment, granting Congress the power to set one. They also sought another route to their constitutional ends. They proposed reforming the judiciary, including by an amendment allowing Congress to remove any Supreme Court justice by a majority vote in both houses, and by an amendment providing for the justices to be elected and to hold office for 10-year terms. Florence Kelley wanted to put women on the Supreme Court. That would not happen until 1981, when Ronald Reagan appointed Sandra Day O'Connor. Idaho Senator William Borah, examining 40 cases in which the court had overturned state laws by a 5-4 majority, proposed that any such decisions ought to require a 7-2 majority. Taft was distressed, but confident. Meantime, he wrote a fellow justice, "There is nothing for the court to do but go on about its business, exercise the jurisdiction it has, and not be frightened because of threats against its existence." The historian Charles Warren came to the court's defense. As to criticisms advanced by men like La Follette and Borah, there is no novelty in these attacks, Warren declared, insisting that no functioning body under our government has been more subjected to continuous assault than the Supreme Court. Warren, a former assistant U.S. Attorney General and Boston Brahmin, so dedicated to Harvard that he regularly wore a crimson bow tie and who, with 2 other men, had founded the Immigration Restriction League, agreed with Taft's denunciation of Charles Beard's interpretation of the framers, insisting that young men must be taught that America is much more than the result of class interests and sectional influences. They must learn that the men who made America had aspirations and beliefs apart from their personal fortunes. In 1922, he published a 3-volume book, The Supreme Court in United States History. Every history of the Supreme Court takes a position on the nature of its authority. Warren's work not only placed the court at the center of American history, but also defended it against progressive critics. No one can read the history of the court's career without marveling at its potent effect upon the political development of our nation, and without concluding that the nation owes most of its strength to the determination of the judges to maintain the national supremacy, he argued. No institution except the railroad had so wholly kept the American people together and preserved the Union. In 1923, the book won the Pulitzer Prize. Even as progressives continued to argue that the Constitution ought to be made easier to amend, the success of the 16th, 17th, 18th, and 19th Amendments, and the seeming likely ratification of the Child Labor Amendment as the 20th, led conservatives to propose a constitutional amendment of their own, one that would make the Constitution more difficult to amend. In the Senate, New York Republican James Wadsworth, Jr., who had voted against both the 18th and 19th Amendments, had been introducing amendments to stiffen Article 5 since 1917. Wadsworth campaigned to repeal the Prohibition Amendment, and while he supported women's suffrage, he believed these matters should be left to the states. Tennessee Democrat Finis J. Garrett introduced a version into the House. By January 1924, an amended version, known as the Wadsworth-Garrett Amendment, had earned support in both houses. It also enjoyed the strenuous support of the Sentinels of the Republic, which claimed to have originated the idea. After various adjustments as the proposal went to committee and back again, the version considered in 1925 added 5 hurdles to ratification. Amendments were to be ratified in the states either by a state convention or by a referendum, the states choose. States could reverse their ratification votes at any point until either 3/4 of the states voted yes or 1/4 of the states voted no. If 1/4 of the states rejected an amendment, no matter how many other states had or had not voted, the process ended and the amendment failed. To be ratified, an amendment had to be accepted by 3/4 of the states within 8 years of its passage by Congress. Senator Wadsworth and Representative Garrett argued for this reform in the interest of the people's rule. As the situation now stands, fewer than 4,000 individuals in this nation of 110 million people can, if they choose, alter every sentence and paragraph of the Constitution, Garrett said on the floor of the House, and the people have no means of prevention nor any method of recourse or review. Conservatives dubbed the Wadsworth-Garrett Amendment the Back to the People Amendment. Mary Kilbreth sometimes just called it the People's Amendment, and sometimes the Second Bill of Rights. Feminist organizations, including the League of Women Voters, fought to defeat what Maud Woodpark called the vicious amendment, alerting women that its every provision, no matter the name, would operate to increase the odds against ratification and in favor of rejection. Feminists and other progressives braced for a fight, but aside from the scant followers of Mary Kilbreth, no one lined up behind the Back to the People Amendment. There was no fight to fight. The decline and fall of the American Constitution. Before the 1920s, the Constitution itself, the sheepskin parchment marked with goosequill ink, had never been seen by the public. The original document had in fact largely been forgotten and ignored, and more than once all but misplaced. After it was signed in 1787 and sent to Congress, which then met in New York, it had been filed away. Eventually it was moved to Philadelphia, and in 1800 to Washington, where it was stored first in the Treasury Department and then in the War Office. During the War of 1812, it was hidden in an empty house in the countryside for safekeeping. In 1875, it was found in a tin box in the bottom of a closet, and in 1894, it was locked in a steel safe in a basement. Not until the rise of James Beck and Mary Kilbreth-style conservatism was attention paid to the parchment Constitution as a near-sacred relic. It was, as it happened, the age of the discovery of the tomb of Tutankhamun, and also of the colonial revival, during which the robber barons of the Gilded Age, who supported immigration restriction, made a fetish of the founding of the United States, and especially the framing of the Constitution, as expressions of patriotism and a bulwark against socialism. The DuPont family purchased Madison's home, Montpelier. A Pittsburgh industrialist purchased James Monroe's home. John D. Rockefeller funded Colonial Williamsburg. And a group of New York City lawyers purchased Monticello from a Wall Street financier in order to create a national shrine. In the 1920s, as again in the 1980s and 2020s, constitutional conservatism, originalism, and its Beckian ancestor was inseparable from heritage tourism. In 1921, President Warren Harding ordered the Constitution, along with the Declaration of Independence, transferred from the Department of State to the Library of Congress, with the idea that both documents ought to be preserved and possibly, for the first time, displayed together, as Harding said, to satisfy the laudable wish of patriotic Americans to have an opportunity to see the original fundamental documents upon which rest their independence and their government. By 1924, in time for the 150th anniversary of the Declaration of Independence, the two documents were displayed in a glass and marble shrine on the second floor of the library. By 1929, James Beck was arguing for a permanent memorial to be built to the Constitution, in time for the 1937 celebration of its 150th anniversary. He was worried, as he said in a radio address, that the words of the Constitution had become so faded in the minds of the American people as to be almost illegible. Calvin Coolidge's landslide victory in 1924, defeating both the Democrat John W. Davis and the progressive Robert La Follette, vindicated the conservative cause. After Coolidge took office, Beck lobbied for the position of U.S. Attorney General. When that was not forthcoming, he decided to defend the Constitution by running for a congressional seat from Philadelphia. He had not lived in Pennsylvania since 1903, but in 1926 he leased a 2-room apartment on Spruce Street in Philadelphia. When he won the seat, his election was contested on the ground that Beck in fact lived in Washington. By his own confession, he had never once even eaten a meal in his Philadelphia apartment. And as The Nation magazine reported, only in the late summer of 1927 did Beck pay his first Philadelphia tax in 24 years, a 50-cent poll tax, so he could register to vote, though when Election Day came, he stayed in his grand mansion in Washington, pleading a cold. Beck weathered the controversy and took a seat in Congress, where he became a prominent orator in the immensely popular campaign to repeal, or at the very least, to amend the 18th Amendment, positions that, after the Depression set in, were favored by nearly 3 in 4 Americans. Having for so long opposed amending the Constitution, Beck now championed it, but only for the sake of unamending the Constitution. In a radio address promoting the repeal, he assured listeners that the framers of the Constitution did not regard any who suggested amendments as wanting in patriotism. At the end of 1932, he announced that he would be introducing an amendment to amend Article 5 to make ratification easier. He proposed reducing the number of states required to ratify an amendment from 3/4 to 1/2, so long as the total population of the ratifying states was at least equal to 3/4 of the population of the United States. Beck wanted to ease the path toward ratification in order to push through the repeal of prohibition. He had another motive, too. He wanted to defeat the proposal, then on the table, to ratify the repeal of prohibition by conventions rather than legislatures. This had never been done before, and with the newly elected Franklin Delano Roosevelt taking office, promising a New Deal to pull the nation out of the Great Depression, Beck didn't think 1933 was a good time to start experimenting. Beck's concern was federal power, especially in the hands of the incoming Roosevelt administration. He wasn't worried about the states ratifying an amendment by convention. He was worried about Congress telling the states how to ratify an amendment. "We are probably entering upon a period of great constitutional changes," he wrote in January 1933, anticipating FDR's inauguration. "The changed political philosophy of the American people is rapidly converting this nation from one that was based on an individualistic conception of government to a highly collectivist theory." Beck was appalled by the New Deal upon which FDR had campaigned. And if he was determined to accomplish the repeal of the 18th Amendment, he did not want to grant the federal government any further power over the amendment process, warning that a Congress so emboldened might one day soon decide it would be necessary for all elections to state conventions to be controlled by the federal government and even conceivably by the use of federal bayonets. The repeal amendment passed Congress in February 1933, and by December it had been ratified, by conventions rather than by legislatures, as required by Congress, as the 21st Amendment. Beck, for all his delight in the end of Prohibition, regretted the method by which it had come about. And with that, the ever-alarmed Beck complained, all that was left of the Constitution was a skeleton. With FDR in the White House now vigorously implementing the New Deal, which truly did amount to a constitutional revolution, Beck became one of the president's most outspoken congressional opponents. The National Recovery Act was, he said, economic slavery. The Constitution, under the New Deal, was like a dead oak in a forest. It was still standing, but its roots were dead, and the next strong storm would surely blow it down, whereupon the noble tree under which 7 generations of Americans have sheltered themselves, and under which they have builded the greatest and noblest and freest government in all the world, will fall forever. Beck's metaphorically exuberant political despair in the 1930s became, among political commentators, something of a national joke. In 1932, when he published Our Wonderland of Bureaucracy, an indictment of the growth of the federal government in the form of agencies and bureaus, the economist Harold Lasky derided it as a vast mass of unproven and rhetorical statements and described Beck's eloquence as of the type which conceals an essential poverty of thought. As for Beck's ceaseless sounding of constitutional alarms, the truth is that he is a Rip Van Winkle who went to sleep in the era just after the Civil War and has awakened to dismay in a world quite beyond his understanding. But Beck, of course, was far from alone in waging a campaign against the New Deal. In August 1934, he joined with fellow conservatives in founding the American Liberty League, backed by wealthy industrialists, including the brothers Pierre and Irénée DuPont and Alfred P. Sloan, Jr., president of General Motors. The League's president had previously headed the Association Against the Prohibition Amendment, and the Liberty League continued the anti-prohibitionist campaign against the regulatory power of the federal government. James Wadsworth of the eponymous Wadsworth-Garrett Amendment served as one of its first officers. Beck served on the League's National Lawyers Committee, a group of corporate lawyers keen to use their powers to topple the New Deal. FDR, in a press conference, likened the League's worshipful attitude toward the Constitution to that of lovers of the 10 Commandments, whose tenets appeared to be love thy God, but forget thy neighbor, except that God, in this case, appeared to be property. Robert Jackson, then in FDR's administration as a special counsel, called Beck's endless Liberty League speeches and articles about the imperiled Constitution a driveling defense against phantom enemies. The New York Times reported that the League's sole purpose was bringing back the old deal. The Democratic National Committee hired a publicist who, in echoes of the House of Dollars epithet, dubbed the League the Millionaires' Union, a moniker that stuck. In September 1934, having been re-elected to Congress 3 times, Beck announced that he would leave the legislature at the end of his term. Congress has largely ceased to be a deliberative body, he said, having become merely a rubber stamp for the executive, and to be 1/400th part of a rubber stamp no longer appeals to me. In his statement of resignation, he charged FDR with attempting to build a unitary socialistic state. On the good ship Constitution, he warned, the waters of innovation are pouring into this noble vessel, and the undercurrent of socialism is now pouring into the hold. In December 1934, in a radio address on the question, "Shall we abandon the ship?" Beck answered, unsurprisingly, that Americans must not abandon the ship, for if we do, it will not be the Constitution alone that will perish. Still, he believed some changes were necessary, and offered the very unusual proposal that when the Depression ended, the president ought to appoint a committee of 200 outstanding Americans to consider amendments. Charged with advocating for amendments, Beck then retreated and said he expected that such a committee would in fact decide against amendments to any fundamentals, though a few to its mechanics might be in order. He favored a 4-year term for members of Congress and a 7-year term for the president. Beck, after leaving Congress, dedicated himself to radio addresses, law review articles, worked for the Liberty League, and legal efforts to overturn elements of the New Deal. He challenged the constitutionality of the Tennessee Valley Authority, a federal electric utility, before the Supreme Court, telling the justices that if they upheld the law creating it, they would be guilty of converting a constitutional federation of the states into a unitary socialistic state of unlimited powers. He lost. In a law review article, observing that Edward Gibbon had completed The Decline and Fall of the Roman Empire in June 1787, even as delegates were deliberating in Philadelphia, he asked Americans to consider whether the time is approaching when some Gibbon of the future can take pen in hand and write of the decline and fall of the American Constitution. Beck plodded along, clanging his warning bell in the night after night after night. In March 1936, he appeared again before the Supreme Court, this time on behalf of his client, J. Edward Jones, an oil stock dealer. Jones refused to file information with the new Securities and Exchange Commission in defiance of the Securities Act of 1933. It was Beck's last case, and he won. 6 days later, he died of a heart attack at home. He was 74. But like Rip Van Winkle, he had for a very long time seemed 100 years older. Indian self-government. FDR's administration instituted a series of reforms that came to be known collectively as the Indian New Deal. In 1924, in large part due to the advocacy of Gertrude Simmons Bonin of the Yankton Sioux, also known as Zitkala Shah, president of the National Council of American Indians, Congress had passed the Indian Citizenship Act over the opposition of many Indians, including the Haudenosaunee. It granted citizenship to all indigenous peoples born within the United States, or as seen from the Indians' vantage point, it imposed citizenship on them without their consent. It did not require Indians to give up their tribal citizenship. Zitkala Shah then presented a petition to Congress in 1926 on behalf of the National Council of American Indians. By 1927, both Zitkala Shah and the social activist John Collier testified before the Senate in support of a proposed investigation into Indian affairs with an eye toward the relief of poverty through the remedy of self-government. Zitkala Shah blamed Congress for the near pauperization of the Indians. Collier described the condition of the Indians under federal law as the practical enslavement of Indians. A century after the Cherokee Nation adopted a written constitution, most indigenous groups in the United States did not have written constitutions. Urged on by Zitkala Shah and Collier, the federal government came to believe that Native nations should enact written constitutions, chiefly as a means to formalize the government-to-government relationship between the United States and sovereign native nations. When FDR took office, he appointed Collier as head of the Bureau of Indian Affairs. A progressive who had trained as a sociologist at Columbia and spent time among the Taos Pueblo in the 1920s, Collier hoped to reverse much of earlier federal Indian policy, including forced assimilation and Americanization, and the undermining of tribal sovereignty and culture. He'd headed an investigation that had resulted in the publication in 1928 of the report The Problem of Indian Administration, and with his appointment in 1933, he hoped to put his recommendations into effect. His many initiatives included closing Indian boarding schools. For decades, the Bureau had forcibly removed children from their families and sent them to schools where they were forbidden to speak their native languages. Many were horribly maltreated, abused, and even starved. Many never saw their families again. Above all, he aimed to end the Dawes Allotment Program, instituted in 1887, and return unallotted land to the tribes and promote self-government. In January 1934, Collier's Bureau of Indian Affairs distributed a circular titled Indian Self-Government to Indian Tribes, recommending a set of steps toward self-government, including the drafting and ratifying of written constitutions. It asked tribes to review the proposal, meet to discuss it, and report back. More than 250 tribes held the recommended referenda, but to Collier's surprise and disappointment, opposition was considerable and turnout was low. Only a minority of those tribes who reported back approved of what was being proposed, though the circular was so murky that it was difficult to know quite what was being proposed. That spring, as Congress debated a bill that became known as the Indian Reorganization Act, Collier sponsored 10 Congresses across Indian country to debate the bill's provisions. The first Congress among Northern Plains Indians was held in Rapid City, South Dakota. The response was mixed at best. Many Indians had accommodated themselves to the allotment scheme and were reluctant to give it up. Then, too, as Lakota delegate Oliver Prue told Collier at one Indian Congress, "We have come to learn to distrust all government officials that come out here to negotiate with the people, and really have been fooled so many times, time and again, that we just simply distrust every government official that came out here, however true they may be." Collier, working with the Ho-Chunk reformer Henry Rowe Cloud, a Yale graduate, had success at some Congresses, though they were notably unable to secure the support of the Navajo. In May, Collier reported to Congress that 55 tribes, comprising 141,881 Indians, had approved the bill, and that only 12 tribes, with 15,106 members, had voted against it. The tribes also proposed some 30 amendments to the bill, all of which Collier supported and presented to Congress. But, as Vine Deloria, Jr. of the Standing Rock Sioux would later write, on his return to Congress, Collier saw his program virtually gutted. In advocating for communal ownership of tribal lands, Collier was accused of advancing communism. As passed, the Indian Reorganization Act did not require the tribes to adopt written constitutions, but it did require tribes on reservations to hold a referendum within a year of the Act's passage on whether the tribe wished for the Act to apply to them. These elections took longer than expected, and in many cases resulted in the Bureau essentially strongly encouraging a specific outcome, the adoption of a written constitution. The Indian Reorganization Act, or IRA, which exempted Oklahoma, a vast portion of Indian country, Hawaii, and Alaska, stated that a tribe had the right to organize for its common welfare and may adopt an appropriate constitution and bylaws, and it established procedures for ratification by a popular vote. But it also required that any constitution and any amendment to any constitution be approved by the Secretary of the Interior. It did not require either constitutions or a specific form of government, but it did require that any constitution adopted under its authority had to prevent the sale, disposition, lease, or encumbrance of tribal lands, interests in lands, or other tribal assets without consent of the tribe. The IRA had been chiefly drafted by the young New Deal lawyer Felix Cohen, assistant solicitor with the Department of the Interior, whose sensibility aligned with Collier's, and who had received an education in the history of Indian law from a Mohawk teacher, Ray Fadden, from Onchai-Ota, New York. Born in 1907, Cohen was named after Felix Frankfurter, a friend of his father's. Indian constitutions, Cohen observed, are not an innovation of the New Deal, but go back at least to the 15th century Guyana-Shogoa, binding the Haudenosaunee. Based on his reading of wampum and written Indian constitutions, as well as U.S. state constitutions, Cohen prepared a model constitution, an outline suggesting what ought to be one, and a basic memorandum on the drafting of tribal constitutions. Whether he sent his model constitution to tribes is not altogether clear. In 1934, he wrote that he had not done so because the tribes were so variable that no single constitution prepared by the Indian Office could possibly fit the varied needs of the different Indian tribes, and because a constitution adopted from the model would be only an adopted child and not be the natural offspring of Indian hearts and minds. He also warned against distributing it out of concern that the tribes would naturally be tempted to regard it as compulsive rather than suggestive. It seems unlikely, however, that everyone in the Bureau of Indian Affairs heeded this warning. Nearly 100 tribes, from the Blackfeet to the Winnebago, adopted written constitutions in the years immediately following the law's passage. In the 21st century, not all of the 574 federally recognized tribes have written constitutions, but of those that do, 60% are IRA constitutions. But the Indian New Deal, like countless other federal policy changes, lasted only until the federal government determined on a new course of action, known as termination, in 1953. It also revealed the limits of the federal government's commitment to the idea of republicanism, as embodied in the acts of writing, ratifying, and amending a written constitution. The federal government didn't consider Indian constitutions to be rocks of Gibraltar, or bowls of Jell-O, or ships whose holds were flooding. With Indian constitutions, every act of drafting, ratifying, and amending was conditional on the approval of the Bureau of Indian Affairs, and ultimately of Congress. The Living Constitution. It was purely accidental that Charles Beard's article, The Living Constitution, appeared in May 1936, the month after James Beck's death, though it was unfortunate, because Beard appeared to be mocking a dead man. He began by poking fun at orators who delighted in constitutional metaphors, likening the Constitution to a sheet anchor, a lighthouse, and a beacon. For Beard, constitutional metaphors were a whole lot worse than bad writing. They reduced constitutional analysis to sorcery. The idea of a living constitution was hardly new, even if it had newly taken on that name. Thurman Arnold, FDR's Assistant Attorney General, is credited with popularizing the phrase living constitution in the 1930s. But Francis Lieber had written about the Constitution as an organism in 1865, representing amendments as its offspring. Woodrow Wilson had advanced this idea, as had Holmes and Brandeis. The Constitution of the United States is most significantly not a document, but a stream of history, Frankfurter wrote in 1937, and the Supreme Court has directed the stream. By the 1930s, this conception of the Constitution had gained purchase in the public mind. Beard, having witnessed the rhetorical effusions of James Beck for decades, and who had just published a new edition of his Economic Interpretation of the Constitution, took pains to contrast living constitutionalism with a cult of constitutional certitude that had come to dominate Washington, at least insofar as it was trotted out on all ceremonial occasions. Anticipating the upcoming 1937 commemoration of the sesquicentennial of the Constitution, Beard reminded readers that the Constitution was hardly a set of positive and unequivocal commands. Article 2 of the parchment may repose peacefully in the archives, he observed, but the article that counts most in real life is the personality occupying the White House. Yet what seemed to count most in the 1930s was neither the parchment preserved in the archives nor the personality occupying the White House, but the 9 old men in black robes who sat on the Supreme Court. Before 1935, the court, with a 5-man conservative majority, had broadly upheld the New Deal. While an emergency does not create power, Chief Justice Charles Evans Hughes had said, an emergency may furnish the occasion for the exercise of the power. In January 1935, the court ruled in favor of FDR, and Hughes upheld FDR's agenda, leading one of the four most stalwart conservatives, known as the Four Horsemen, to cry out, "The Constitution is gone!" But then, on a single day in May 1935, nearly the last session before the court moved to a new and impressively grand Supreme Court building, it struck down 3 elements of the New Deal, including the National Recovery Administration. Over the next year and a half, the court struck down more than a dozen laws, all in 5-4 decisions. FDR, exasperated, considered his options. He had plenty of experience with constitutional amendments. As a state senator, he had supported the 16th, 17th, and 19th Amendments. His wife Eleanor had engaged in the campaign for the child labor amendment. Democrats' support for the repeal of the 18th Amendment had helped FDR win the White House in 1932. Roosevelt advocates constitutional changes, the Los Angeles Times reported in June 1935, listing a few of the president's latest ideas. One scheme is to increase the number of Supreme Court justices so as to create a pro-New Deal majority therein. Another is to so alter the Constitution as to destroy the court's present power to negative acts of Congress. Constitutional amendment seemed, at the time, the easier path, but it was difficult enough that the New York Times reported that the administration was considering a specific plan for a quick method of amending the Constitution by what would be the equivalent of a popular referendum. FDR bided his time, waiting for the 1936 election. One idea was a constitutional amendment resurrecting an idea proposed by La Follette in 1924, requiring that only a unanimous court could overturn a law passed by Congress. There were other amendments on the drafting table, too, including a slightly less strenuous requirement for a 2/3 opinion for overturning a law passed by Congress. FDR also considered an amendment strengthening Congress's power to enact general welfare laws. In 1787, Washington had proposed language in the Constitution granting Congress the power to legislate in all cases for the general interest of the Union, and also in those to which the states are separately incompetent or in which the harmony of the United States as may be interrupted by the exercise of individual legislation. He also considered a judicial retirement amendment and presented to his cabinet a proposal to grant Congress power to overturn a Supreme Court ruling by once repassing at its next session a law that the court had found unconstitutional. After Roosevelt won re-election in a rout in 1936, he won 46 states and 61% of the popular vote. He was widely expected to proceed with a call for an assortment of amendments, or even for a constitutional convention, though he is reported to have been against that, having allegedly said that there was no way of keeping such an affair from getting out of hand, what with Coughlin and other crackpots about. That is, the demagogue, Father Charles Coughlin. But there is more than one way of killing a cat. The Liberty League hoped he would call for a raft of amendments or a convention, knowing how well they could organize against it. Instead, he abandoned the idea of amendment, partly because of the delay it would have entailed, partly because he knew the Liberty League had amassed a war chest to fight any New Deal amendment, and partly because he did not relish the prospect of building a coalition with conservative Democrats. Plus, he was working out another way to kill that constitutional cat. But first, something in the character of an experiment, Roosevelt in 1937 called for an immediate ratification of the child labor amendment and undertook to blitz the press. The March of Time obliged with a vivid 7-minute newsreel presenting footage of children wearing little more than rags, dwarfed by enormous machinery in factories and working as day laborers in fields, in something of a moving picture version of Lewis Hines' photographs, while a solemn narrator explained the urgency of ratification. The newsreel presented the opposition, which by now had dubbed the measure the Federal Control of Youth Amendment. The narrator noted that throughout the U.S., conservatives cry that regulation of youth is the first step toward dictatorship, but presented a much stronger argument on behalf of what it called the most bitterly contested constitutional amendment in U.S. history, and confidently predicted ratification by year's end. Roosevelt had no such confidence. The experiment failed. Meanwhile, 2 of his closest advisers were supporting his resolution to abandon the path of constitutional amendment, arguing that the wiser path would be to continue to insist on interpreting the Constitution to accommodate social and economic legislation. The first was Felix Frankfurter. The second was Roosevelt's Attorney General, Homer Cummings. "The American constitutional method is a process of adaptation and growth," Cummings said in a speech delivered to the New York Bar Association at the end of 1935. And, as Cummings wrote in his diary a week after the 1936 election, "There is nothing the matter with the Constitution but that the entire difficulty has grown out of a reactionary misinterpretation of it." In February 1937, Cummings proposed instead a legislative solution that became known as the court-packing plan. He asked Congress to pass a law reforming the federal judiciary that would require naming an additional justice for every sitting justice over the age of 70. That described 6 of them, including Hughes, who was 77. To a senator who pressed him to pursue a judicial retirement amendment instead, FDR wrote in February, "I am an optimist, as you know, but I think you are a worse optimist than I am." In a fireside chat in March, he described the court-packing bill as the only possible solution short of amendments, since while many in Congress liked various amendments, support fell short for any single one. And then there was the matter of urgency. "We cannot rely on an amendment as the immediate or only answer to our present difficulties," he insisted. Amendment in the interests of social legislation was bound to encounter formidable obstacles and delays, he warned. Looking back at the amendment history of his own lifetime, he insisted that no amendment which any powerful economic interests or the leaders of any powerful political party have had reason to oppose has ever been ratified within anything like a reasonable time. This wasn't strictly true. Yes, the Child Labor Amendment had stalled, but the 21st Amendment had moved along fairly quickly. Still, amendments were unpredictable. Urged on by Frankfurter, whom FDR would name to the Supreme Court in 1939, the president abandoned amendment in favor of the exercise of executive and judicial power. This marked a fateful turn in the history of liberalism. Roosevelt had reasons for making this turn. He was daunted by his fear of the bottomless pockets of the Liberty League and by his frustration at the failure of the Child Labor Amendment, still 8 states short of the required 36. And, as the reigning historian of the amendment process has pointed out, amendment happened so infrequently that few politicians or legal theorists had any sufficient experience with it to anticipate how any proposal might fare during ratification in the states, whether by legislatures, conventions, or referendum. Meanwhile, the president had good reason to expect success with his court-packing bill. But the campaign waged against it proved every bit as energetic as the campaign he feared the Liberty League would wage against an amendment. By now, new methods to measure public opinion allowed the president and Congress to determine just how much support existed for restructuring the federal government. George Gallup had founded the American Institute of Public Opinion in 1935, later followed by Roper's opinion polling outfit. Both organizations measured Americans' attitudes about possible amendments. Broadly, they were in favor. In 1936, 61% favored the Child Labor Amendment. This rose to 76% in 1937. 70% favored the Minimum Wage Amendment. In 1936, only 43% of Americans favored an amendment transferring to the federal government the power to regulate agriculture and industry. This rose to 58% in 1937. In 1937, 64% favored an amendment requiring Supreme Court justices to retire between ages 70 and 75. By 1939, that number had dropped to 59%. A slim majority of 53% agreed that amendments should be approved by a direct vote of the people instead of by state legislatures. In 1937, only 17% favored lowering the ratification requirement from 3/4 of states to 2/3, and only 28% agreed that the Constitution should be made easier to amend. If FDR had stayed the course and pursued a constitutional amendment to restructure the Supreme Court, he might well have succeeded. A strong majority of Americans favored such an amendment. Had FDR not blinked, Article 5 might well have constituted the New Deal, placing it on far firmer ground than it gained. That nice, unconstitutional bill. What's the best way to change the Constitution? In the end, the court decided. FDR's battle with the court reached its dramatic conclusion on March 29, 1937, when the court issued its opinion in West Coast Hotel Company v. Parrish. Reversing its decision in Adkins v. Children's Hospital from 1923, the court upheld a Washington state minimum wage law for women. Justice Owen Roberts changed his position, a reversal widely seen as a response to Roosevelt's court-packing plan, and thus ever afterward known as the switch in time that saved 9. Soon afterward, the Senate Judiciary Committee elected not to move the court-packing plan out of committee. West Coast Hotel Company v. Parrish ended the Lochner era, as Chief Justice Hughes, writing for the majority, acknowledged that the Constitution does not speak of freedom of contract. An aging George Sutherland, still on the bench, dissented. Sutherland's method of constitutional interpretation was, he insisted, both specific and disciplined. The whole aim of construction, as applied to a provision of the Constitution, is to discover the meaning, to ascertain and give effect to the intent of its framers and the people who adopted it. He'd written in a dissent in 1934. The meaning of the Constitution does not change with the ebb and flow of economic events, he wrote in his dissent in West Coast Hotel Company v. Parrish. He accused the majority of effectively amending the Constitution. The judicial function is that of interpretation. It does not include the power of amendment under the guise of interpretation, he scolded his brethren. The New Deal involved such a wholesale restructuring of the powers of the federal government that those who supported it tended to endorse the very idea of change. I don't believe in one generation deciding what the others shall do, wrote one philosophy professor in 1931. Our forefathers didn't know anything about a country of 120 million people with automobiles, trains, and radios. Thomas Reed Powell, looking back at 1787 from 1937, said the framers indulged in change, they planned for change, they provided the way for change, they and their friends agreed upon further change as the price of securing the immediate change they sought to bring about. More important still, they left open the way of change by what they left